Section 39 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases, by John B. Lewis and Charles C. Bombaugh. Homicide, Part 16. The Goss-Udderzook Tragedy, Part 15. Jane Udderzook, the aged mother of the prisoner, was next called to identify the handwriting of her son, William E. Udderzook. She had corresponded with him for years past, since he was a boy, and was able to recognize his handwriting when she saw it. Several letters were handed her, with the request that she would look at the signatures and say what was her best judgment as to whether it was his handwriting or not. She had not her glasses with her, and her eyes were suffused with tears, so that she could not answer definitely. A pair of glasses were handed her, which, she said, did not suit her very well. Of a letter dated Baltimore, October 30th, 1871, addressed to his mother and signed William E. Udderzook, 167 Conway Street, she said, "It is likely it is his writing." Of a letter dated Baltimore, November 16th, 1871, directed to Mr. and Mrs. Mullen, she said, "It looks like his writing." Of a letter dated Baltimore, October 28th, 1871, addressed to Mrs. Mullen, she said, "I think that is the same handwriting." The letter to Rhodes was handed to the witness, when Mr. McVeigh, the prisoner's counsel, remarked, "I think these letters are so proven they will have to go to the jury." The letters were then offered in evidence by the Commonwealth. Gassaway Peters, recalled. I noticed Udderzook's appearance when he brought the horse back that night. I saw that one leg of his pantaloons was dirty. He wore dark clothing. There were no blankets with the buggy when he returned it. John Hurley. I reside in West Fallowfield Township. It is about 1 field from my house to Bear's Woods. My wife awakened me on the night of the 1st of July, and I heard a noise of a man hallooing. I did not look to see what time it was, but I think it was between 10 and 11 o'clock. I got out of bed and went to the window, and I heard 3 loud calls after I got to the window, a kind of hallooing. Then it was still for about 2 minutes, and then I heard what sounded like loud and wicked scolding. One of them hallooed, "Oh," not nearly so loud as the other sounds. I was at the window listening, some 20 minutes or so. I heard a sound like a horse and wagon. I saw nothing. I could tell by the sound from what direction it came. It came from Bear's Woods. Towards daylight I noticed a light burning in the woods. Dr. John J. Gibson. I reside in Cochransville. On the morning of the 2nd day of July, 1873, I observed smoke arising from about the center of Bear's Woods. I was where I could plainly see full 2/3 of the top of the woodland, and was about 1 3/4 miles distant from the woods. It was about 5:30 o'clock in the morning. James Robinson. I am a millwright, and in the early part of July in this year I was repairing a mill near Cochransville. On the morning of the 2nd of July, at about 4:30 o'clock, I noticed smoke ascending from Bear's Woods. The smoke seemed to come from the center of the woods. I was about 1.5 miles distant when I first saw it, and as I was going in that direction, I approached to within about 3/4 miles of it. It attracted my attention considerably, and I stopped and looked at it. It was a heavy body of smoke, and showed very plainly. I continued to notice it until I lost sight of it in the hollow, as I turned off from the pike to go down to the mill. Samuel Robinson. On the morning of the 2nd day of July last, I saw smoke rising from near the center of Bear's Woods. It was between 4:30 and 5 o'clock. On the Sunday following after the body was discovered, I was in the woods and saw a few burned fragments of clothing at a spot where there had been a fire. I have these charred fragments with me. Opening package containing pieces of cloth. Here is part of them. It was 10 days or more after I saw the fire when I went into the woods. Albert Baldwin recalled. I examined the buggy next morning after Udderzook had returned it to my stable. The rivets of the bows on the left side were broken so that the bows would spring backward and forward. The iron of the dash was broken off on the left side, at about 4 inches from the top. The whole dash was bent over forward. The oilcloth, which had been tacked to the floor of the buggy, was torn out and missing. Only portions of it remained that were held round the edges by the tacks. Afterwards, on the 4th, I noticed what appeared to be bloodstains upon the bottom of the floor of the wagon. It appeared to have run through a crack in the floor. I searched the wagon to ascertain if there were any bloodstains, because of what Rhodes told about his conversation in the hayfield with Udderzook. I made out a bill against Udderzook and gave it to Mr. Patchell to collect. The bill was for the missing blankets, for breaking the wagon, and for overtime. A paper handed to witness, which he identified as the bill. The bill is made out for $12.75. I received $9 through Mr. Patchell. Edwin Patchell recalled. Mr. Baldwin gave me a bill to collect against William E. Udderzook on the evening of the 2nd day of July. I found Udderzook at his mother's house and presented him the bill. I said to him, "Here is a bill that Baldwin has made out against you for breaking his wagon and losing his blankets." He stood for a second or two and then said, "Yes, I lost the blankets, but I did not break his wagon." Then he said, "Yes, I broke one small iron in front. I do not feel willing to pay for the wagon, but the blankets I will pay for." He looked at the bill and handed me $9, all in $1 notes. He asked me for a receipt, and I said to him it was not necessary, as Baldwin would give him a receipt when he got the money. He said, "I will not be here longer than tomorrow morning, but Baldwin can give it to mother." He kept the bill. Joseph Wilson. I reside in Cochransville. Am clerk of the hotel there. The prisoner at the bar called at the hotel in Cochransville at about 7 o'clock in the morning of the 2nd day of July last and asked for breakfast. I immediately ordered breakfast for him, and after he had finished, he paid his bill and went away. Mrs. Lydia Bowman. I saw the prisoner on the morning of the 2nd day of July last at the hotel in Cochransville. I waited on him at his breakfast. I noticed his clothing. He wore his coat buttoned tightly across his breast. I noticed then his pantaloons were dusty, as though dust had settled on them after they had been wet. As he passed out of the room, I noticed his pantaloons were turned up at the bottoms. His hair seemed to be very much rumpled, as though he had been lying down and had not combed it afterwards. Samuel C. Jeffres recalled. I saw Udderzook the next morning after he left my hotel in Jennerville. I met him about 2½ miles north of my house, on the road leading from Cochransville. He was going towards Jennerville. After saying good morning, I asked him what he had done with his partner. He told me he had left him at Parksburg, that he, Udderzook, was going down to see his mother, and then home. He was traveling on foot. It was then between 8 and 9 o'clock in the morning. It was a warm morning. Cross-examination. His coat was off, and I think he was carrying it on his shoulder. I noticed the lower part of his pantaloons were foxy, dusty. Robert C. Kelton. I am station agent at Penn Station on the P&B CRR. I know William E. Udderzook. He was at my station in the evening of the 2nd day of July last, and purchased a ticket from me to go on the 6 o'clock train. He went on the train towards Philadelphia. I saw him again in about 1 hour afterwards. He came back on the 7 o'clock train. He had no baggage with him when he first came. When he came back he had a valise. I spoke to him and said, "Billy, you didn't stay long." He answered me saying he did not intend to. He went towards Joseph Miller's, where his mother lives. I next saw him on the morning of the 3rd of July. He got no ticket from me on that morning, but he got on board the train going to Baltimore. He had no baggage with him, unless it was a small bundle under his arm. Henry Painter. I reside in Westchester. I visited the house of Mr. Joseph Miller on the 27th day of July, and inquired for Mrs. Jane Udderzook. She gave me a valise containing a box of paper collars. The valise heretofore introduced in evidence, exhibited to and identified by the witness as the valise he obtained from Mrs. Udderzook. Cross-examination. I went to the house at the instance of Mr. Wanger, the district attorney. I did not search the premises at that time. I did subsequently. Thomas Carroll. I reside in Baltimore. Am a detective officer. On the 15th of July last, Sheriff Gill came to our office in Baltimore, and I went with him over to Otto Duker's planing mill, and there found and arrested William E. Udderzook. I took him into a room in the presence of Deputy Marshal Frey, Chief Detective Crone, Sheriff Gill, and myself. He stated that he went up to Chester County, Pennsylvania, to see his mother, that he hired a horse and went to see his sister and brother-in-law. Prisoner's counsel. Was the statement he made entirely voluntary? Witness. Yes, sir. He said that the horse was a false one, and he concluded to hire a horse and buggy. He then started back to take the horse he had first hired home to its owner. He tried to lead him, and he would not lead. He then tied him to his carriage horse, but he would not go. He then untied him and started him on the road by himself. The horse bolted off to one side of the road, so that he had to get out of his wagon and turn him back to the main road again. He took the horse back to where he belonged, and then took the wagon to return it to the parties from whom he had hired it. In going along the road, a man came out and asked him to take him in the wagon. He did so, and carried him to Cochransville, and there put him out. He said he did not know who the man was, he was a stranger. Marshal Frey, Sheriff Gill, and Mr. Crone then left the room, and I was left alone with the prisoner. The prisoner then made the remark to me, "This looks bad, doesn't it?" I said to him he had better find someone who saw him let the man out of the buggy, and our conversation ceased until I delivered him to Sheriff Gill at the depot. In the cars at the depot, he asked me if I thought he would get out of it. I told him I did not know what evidence the state would be able to produce against him. Cross-examination. There was no conversation at the planing mill about the offense, nor on the way to the office. Marshal Jacob Frey. On my arrival at my office, about the middle of July last, I was informed of the arrest of William E. Udderzook, and went into the detective's office, and saw him there with Sheriff Gill and Detectives Crone and Carroll. I shook hands with Udderzook, having been acquainted with him formerly, and commenced a conversation with him by asking him if he had not been connected with the police force of Baltimore. He said he had. Conversation drifted upon the subject of this murder. He said his people lived in that part of the country, and he had usually gone there to visit them during the holidays, and as 4th of July was coming on, he thought he would go a day there and spend the 4th with them. Witness then related Udderzook's statements in substantially the same manner as did the preceding witness. Udderzook further said that when he had returned to Jennerville, at the place where he had hired the saddle horse, a gentleman there met him and asked him to take him in his buggy to Cochransville. The gentleman got in, and he drove to Cochransville, when the man got out, and he immediately lost sight of him. He said he did not ask the man his name, nor where he belonged, nor where he had come from. It was not the first time, he said, that he had seen this man. He had first met him in the cars going from Philadelphia to Jennerville, and sat by his side. He said the gentleman appeared to be sick. He judged that from the fact that he laid his hands and arms across the back of the seat in front of him, and laid his head on his hands. And the gentleman had asked him for a glass of water, which he gave him, and also to take the fare ticket to give to the conductor. Satisfying myself that Udderzook was the man that the requisition called for, I told him that we would have to deliver him to Sheriff Gill, who had a requisition for him, and that he would have to be locked up until the sheriff could leave with him. He asked permission to go home and change his clothes. I told him I could not grant that, but would send an officer to his house to tell his wife to send him anything he would want, and that his wife could visit him. I then sent him to the station house where he was locked up. William C. Crone. I reside in Baltimore, am a detective. This witness corroborated, in detail, the testimony of the preceding witnesses relative to the arrest and statements of Udderzook. I then ordered his person to be searched. In searching him, we found a bill for the hire of a horse and buggy, and for the loss of blankets. I delivered the bill to Sheriff Gill. The bill of Mr. Baldwin, heretofore introduced in evidence, was shown to and recognized by witness as the bill found on Udderzook's person. I afterwards went to the station house with Udderzook's wife, and he gave her what money he had in his pockets. It was his last week's salary, he stated. David Gill. I am sheriff of this, Chester, County. I received a requisition on the 14th of July and went to Baltimore that night, and was at the detective's office the next morning. This witness related the same account as the previous witnesses of the arrest of Udderzook, and of what he said of meeting the man whom he took into the buggy and drove to Cochransville. On the cars, coming up from Baltimore, Udderzook told the witness that, after he had got acquainted with the man whom he met for the first time on the cars, he got off that train at West Grove Station, and walked from there to Jennerville. George Robinson visited Bear's Woods on the 11th day of July, and at the place where the fire had been, which was near the center of the woods, he found a brass, riveted button, such as he had seen upon pantaloons. James M. Crossan was in the woods on the 13th of July, saw where the fire had been, and in searching the spot found an elastic button and a riveted button. He saw nearly a dozen other buttons, and one buckle which had been found among the ashes where the fire was. He saw what appeared to be pieces of charred clothing which were found there. Hugh Rambo, Esquire, recalled. Examined the buggy for bloodstains a few days after the body was found. He found some spots underneath the floor by a crack, which he thought he would have recognized as bloodstains if he had not heard of the alleged murder. He cut off some of them with a knife and placed them in a paper, which he subsequently delivered to Dr. Howard. Professor E. Lloyd Howard recalled. District Attorney Wanger called my attention to a wagon which I examined while in Penningtonville on the 18th day of July last. I paid special attention to the floor of the buggy and other parts of it, upon which I found some red stains, several of which I cut off with my penknife for subsequent examination, and upon a careful examination I found they were bloodstains. Most of these pieces on which the stains were most prominent I destroyed in the process of examination. I have several here. These stains I found upon the floor of the buggy, upon the under surface of the floor, immediately below a crack between two of the boards in the floor of the buggy, at about the center of the floor, and upon the edges of the boards at the crack or space between them. I examined them with sufficient care to thoroughly satisfy myself that they were bloodstains. I made special examination to determine if they were stains of human blood, but on account of the length of time which had elapsed since the blood had remained there, I could not decide. That is, I could not form such an opinion as I would be willing to give as testimony. Comparing them with pieces of wood stained with my own blood, the results were identical. I also received from Esquire Rambo some pieces of wood stained with blood. Cross-examined. This examination was microscopical. It was analytical, both chemical and microscopical. I formed my judgment from the agreement in all the experiments or investigations. The Commonwealth here closed. End of section 39. Section 40 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases, by John B. Lewis and Charles C. Bombaugh. Homicide, Part 17. The Goss-Udderzook Tragedy, Part 16. Mr. McVeigh, addressing the court, said, "In view of the fact that some of the witnesses in Baltimore have not complied with our request to come up here, owing to there being an election which was held there yesterday, we desire leave to retire for a few minutes for consultation with the prisoner as to the matter of arranging the testimony." Leave was granted by the court, who said the sheriff must accompany the prisoner. Mr. McVeigh and Mr. Perdue, of the prisoner's counsel, together with the prisoner and his wife and Sheriff Gill, retired to an adjoining room. Mr. Whitney, who had taken no part in the conduct of the defense since the introduction of the testimony of the Newark witnesses, remained in the courtroom. After some minutes spent in consultation, the parties reappeared in court, when Mr. McVeigh said, "May it please your honors, owing to the fragmentary manner in which we will be compelled to introduce our proof this afternoon, in consequence of the absence of various witnesses, it is thought hardly worth while to present any formal opening statement. These witnesses live out of the state, and, of course, are not amenable to process, and the prisoner is not in such circumstances as will admit of his purchasing their attendance. All we can do is to have those persons who are here come upon the stand and tell their story in their own way. We will call Mrs. Goss and ask her the circumstances attending the death, as she supposed, of her husband. We will call in other members of the family who can throw light on this matter, and wherever the circumstances surrounding this cause enable us to do so, we will endeavor to meet the testimony that has been adduced. When that is heard, when this testimony is given, if the witnesses of whom I have spoken are not here, we will have to ask your honors to favor us with an adjournment until tomorrow. The excuse made by these witnesses for their non-appearance is that there is an election of an exciting character being held in the state of Maryland today, and those upon whom we rely have declared their inability to be here till the election is over." Mrs. Eliza W. Goss, sworn and examined. I was the wife of Winfield Scott Goss. In the month of February, 1872, I was living at number 314 North Utah Street, Baltimore. At that time, my husband was not engaged in any business in particular, but he was working for himself, on the York Road, at gilding, and working in a substitute for India rubber. We had been boarding just opposite the place where he was engaged, at the house of Mr. Engel, from July till November, and then I went home to my mother's, where I was at the time of the burning. My husband was boarding there with me. I last saw my husband alive on Friday at noon, the 2nd day of February, 1872. I first heard of the burning about 9:30 o'clock Friday night. When I first heard of the fire, I did not know that my husband was supposed to have been burned. I first heard of that at about 11 o'clock that same night. Mr. Lewis Engel gave me that information. He said he came at the instance of Mr. Udderzook. Mr. Udderzook came himself at about 11 o'clock. The coroner's inquest was held the next day. The remains reached my house at about 6 o'clock Saturday evening. I saw them and recognized them as the remains of my husband. They remained until Monday, at 1 o'clock. I saw them 2 or 3 times during the interval. I accompanied the remains to Baltimore Cemetery, where they were placed in a public vault. They remained there until the following Thursday, when they were put in the ground. I was present. Since the 2nd day of February, 1872, I have not heard from my husband, Have not received any communication from him, directly or indirectly. I had been married 9 years on the 26th of last November. When the remains were taken to the Baltimore cemetery, it was a public funeral. Handing witness a photograph not before shown any witness. It is a picture of Mr. Goss taken 6 or 7 years ago. There was no scar upon my husband's forehead. His eyes were dark blue. Handing witness the ring heretofore introduced in evidence by the Commonwealth. I have seen this ring before. Mr. Perdue showed it to me. I have examined it. I do not believe it is my husband's ring. From my recollection of my husband's ring, where that one has a beading in the center, his ring was in regular cuts all round. In creases, grooves. Then there is a smooth appearance around the setting, on the top of that ring, which I do not think my husband's ring could have had, as he only had it and wore it about 18 months, and that ring has a worn appearance to me. His ring had a similar stone, only I can't describe any marks on the stone at all. I know it was a dark green setting, but I did not know at all, until after this trouble, that his ring was what they call a bloodstone ring. I did not know what a bloodstone ring was. Cross-examined by Mr. Hayes. I was able to recognize the remains by the form of the head and size of the body and form of the neck, fullness of the neck. That was all there was for me to recognize. The Court. Was there at that time any question about it that called for examination? Witness. No, sir. The Court. You had no occasion at that time to think whether they were or were not your husband's remains? Witness. No, sir, I did not. Mr. Hayes. Please give us a description of your husband as you recollect him. Witness. Well, he had dark brown hair, very clear, smooth skin, dark blue eyes. He wore a heavy mustache and goatee at the time of his death. He was stout built. His height I cannot say. Witness further testified. When I saw the remains, they lay in a coffin and were covered with a sheet. I uncovered them. The whole body was of a brownish color. I could not see the teeth, as the lips were closed. The eyes were closed also. The hair was burned off, except a small portion on the back of the neck. Mr. Hayes. I was about to show the witness a letter which, unfortunately, I do not have at hand, but may have tonight. It may be interesting for her to see. I would ask her, do you know Miss Eliza Burke? Witness. I do. Question. Where does Miss Eliza Burke live? Answer. At Mr. Udderzook's. She is his servant. Question. That is a picture of whom? Handing witness a photograph. Answer. It is a picture of A. Campbell Goss, a brother of my husband. The letter of which the Commonwealth's attorney spoke as being one that might interest the witness to see, but which was not then at hand, is a remarkable document. The letter was addressed to Alexander C. Wilson, 329 Mulberry Street, Newark, New Jersey, and arrived at its destination by due course of mail, but not until after W.S. Goss, alias Wilson, had left there to meet Udderzook in Philadelphia. The letter was found at the above-mentioned address, the boarding-house of Mrs. Toombs, early in the investigation of this case, by parties in the interest of the insurance companies. The letter is postmarked Baltimore, Maryland, July 1st, 7 p.m., and the address upon the envelope was found to be, unmistakably, in the handwriting of A. Campbell Goss, the brother of W.S. Goss, alias A.C. Wilson, and brother-in-law of Mrs. Goss, the witness. Upon opening the letter, it was found to be written in a hand evidently seeking disguise, and was signed Miss Eliza Burke, Conway Street. It was easily ascertained that Miss Eliza Burke, as Mrs. Goss testifies, supra, was a servant in Udderzook's family, an ignorant sewing woman, who had been in their employ some time. Her name was used by Campbell Goss as his nom de plume while in correspondence with his brother, W.S. Goss, and during their conduct of the conspiracy to defraud the insurance companies. Notwithstanding the attempt at disguise, upon being compared with that of Campbell Goss, the writing is shown to be the same. The following is the letter. Mr. Wilson, I wrote to you more than 2 weeks ago, and asked you to send me word whether you would meet you in Philadelphia or not, and to direct to you in my care Conway Street, the old house. I am very anxious to hear from you, and am waiting patiently. If you will meet him, state when and where. All is right here so far. W. and J. and I had a long talk yesterday, and it is all in our favor. Please write soon and direct as I told you, and oblige, yours, etc., Miss Eliza Burke, Conway Street, July 1st, 73. Let me hear from you by return of mail. C. It will be observed that in this letter Campbell Goss is desirous of arranging for his brother, W. S. Goss, to meet you, Udderzook, in Philadelphia. But, through some blunder on the part of the conspirators, W. S. Goss had already met Udderzook in that city, and the two were on their way to Bear's Woods, riding in the buggy, at the very hour this letter was postmarked in Baltimore. The initial letter C of Campbell Goss's name may be noticed in the bottom left-hand corner of the letter. The long talk with W. and J. refers to a talk held by Campbell Goss with his attorneys in the insurance suits then pending, Messrs. Whitney and Johns of Baltimore. In the early part of Udderzook's trial, Mr. Whitney appeared and assisted in the conduct of the defense. But before the Commonwealth closed its case, he withdrew from active participation in the cause. At the time when Mr. Whitney thus withdrew, Mr. Johns, who was then in Westchester attending the trial, privately expressed his unqualified astonishment at the overwhelming testimony produced by the Commonwealth, and also his indignation at having been thus imposed upon and deceived by his clients, the Goss and Udderzook families. The Goss-Langley photograph, heretofore introduced in evidence by the Commonwealth, was handed to witness, who identified it as a picture of her husband, standing, and of Mr. Langley, sitting. Question. Will you please describe your husband's ring? Answer. His ring is of the same style as this. The ring heretofore introduced in evidence by the Commonwealth. It was the same looking, but the only difference I can remember is that his ring was made round in the ridges, instead of this beading. That is as I recollect it. I do not know where my husband got the ring. He had it about 18 months. I first learned of his having it when he came home with it on his finger. I never learned what became of his ring. The stone in this ring is the same looking as in that of my husband's, according to my recollection. I could not say anything about the stone more than that his had a stone in it of the same color and size. The Court. One other thing about which I want to be certain. I understood you, Mrs. Goss, to say that your recognition of these remains as your husband's was from the size of the neck and the form of the body. Witness. The general appearance of the body in size and shape. The Court. Was that your only means of recognition? Witness. The only means there were left. The Court. The expression from the features of the face? Witness. There was none. David Arden. I am stepfather of Mrs. Goss. I live at number 314 Utah Street, Baltimore. Mr. and Mrs. Goss lived at my house in January 1872. I remember Mr. Lewis Engels coming there on the night of the 2nd of February, between 9 and 10 o'clock. He came and informed us that the house was burned. I asked him then what had become of Goss. I went with him up to the place of the fire on the York Road. I found nothing there but the cinders. There was no one about the building at the time I got there. I first saw the remains the next morning at the inquest. I recognized the shape of the head, the full neck, the very full chest, and in that manner identified the remains. I had known Mr. Goss about 18 years. There was no scar upon his face. He was of fair complexion and smooth skin. I saw the remains which were exhumed at Penningtonville. It was on the 19th or 20th of July, the day after the examination made by Doctors Lewis and Howard. I had 2 views of these remains photographed at the time. Pictures handed to witness, who identified them as the ones he had taken. Mr. Hanson from Baltimore was with me at the time. He is a hatter by trade, and he had made hats for Mr. Goss for a number of years. Mr. Hanson did not take any measurement of the head at Penningtonville, but he took a good view of it. Cross-examined by Mr. Hayes: I identified the charred remains as those of Mr. Goss so far as they could be recognized. I recognized the shape of the head, the neck, and the breast. I recognized a resemblance. I recognized the shape of the head. There were no features. I have seen other heads of the same shape. The neck did not appear swollen. It was a little contracted, not much. It did not look quite so large as Goss's neck. It was a full, round neck. Of course, I have seen other full, round necks of the same kind. The fullness of the chest in these remains was peculiar. I have seen other men the same way. Under the circumstances, I thought I could see the form of Mr. Goss there. There was no question at that time about these remains being his. I never saw his teeth, could not describe them. His eyes were dark blue. His hair was very dark, between black and brown. He had a full, round head, good forehead, square eyes, person very erect, broad shoulders, and very full chest. When I saw the remains at the inquest, they were in a box. I could not see the shoulders very well. I examined the remains at Penningtonville. That head was not like Goss's head. That head was not a very long head. It was a round head, like Mr. Goss's head. The body at Penningtonville was lying in a coffin. I did not raise the head up. It lay in the coffin all the time I saw it. I thought his head was not as full as Goss's. Goss's head was very full. The features were so disfigured that I could not tell in what other respects it differed from Goss's head. I did not see the chest of the remains in Penningtonville. We did not go very close. We did not want to go very close. We did not stay there long enough to uncover it. It was so offensive. I saw just the head, and that satisfied me at once. I did not expect to find the corpse of Mr. Goss there. I went there because I thought it would be well for me to identify if that was Goss. It was said Goss had been found there, and I thought I would go and make sure of it. John M. Branson: I went to Penningtonville with Mr. Arden. I am a photographer, and took the picture of those remains. One is a full-faced view, and the other is a side face. They were taken on the 19th of July, between 3 and 4 o'clock in the afternoon. Cross-examination: We had to prop up the body at an angle of 60 degrees, but it would slide down. We could not get it a full front face, and it shortened the head by the angle. It was in a decomposed condition to take a picture in. Its hair was all off. The teeth had been taken out, and some of the flesh had been removed from the face. The sun was shining on it, and it blurred the picture. It had cleared off from a shower, and the sun was shining very brightly, which had a tendency to blur the picture. The features were all gone. They were of no account. There was just the outline of the face. Sarah Moore: At the time of the fire, I was cook in the family of Mr. Lowndes, on the York Road, in Baltimore. Just before the fire broke out, I saw Mr. Goss standing outside the door of his cottage. His sleeves were rolled up, and he held a light in his hand. He went in and locked the door, and I saw no more of him. I was eating my supper when a dog barked at the kitchen door, and opening it, I saw flames coming out the window of the cottage. I went and told Mr. Lowndes. The house I was in was about 100 yards from the fire. Monday, Willie and I went over to see if we could find anything. Willie found a pistol and something like a teaspoon. Cross-examination: It was between 7 and 8 o'clock when I saw Mr. Goss standing out of doors. When he went in, I heard him lock the door. There was one other door in that house that opens out of doors. It was in the back end of the house. Redirect. The other door was closed by being propped. It was not nailed. Once they nailed it, I believe, but it broke down and they had it propped. Cross-examination. It was propped by logs against it. Mrs. Sarah Arden. I am the mother of Mrs. Goss. I was at home at the time the charred remains of Mr. Goss were brought to my house. As far as recognition goes, I recognized them as his remains, but could not tell a great deal about it, only from the form of the head and on account of the very large neck and the form of the shoulders. I have never seen Mr. Goss nor heard from him from that time to this. The sheet upon the body was much stained by blood and the black cinders. I never saw a scar upon Mr. Goss's forehead. Cross-examination. It was impossible to recognize the body in the condition it then was. Mr. Goss did not have good teeth. I never noticed his teeth. Mr. Goss wore a mustache so that you could not see his teeth. I know that he had not good teeth because I heard him complain of his teeth. Mrs. Elizabeth Miller. I live in Penn Township, on the road from Jennerville to Penn Station. Mrs. Jane Udderzook was at my house during the early part of last July. Her son, William E. Udderzook, the prisoner, came there to see her in the evening of the first day of July. He stayed there while we were at supper and talked a while, and took his supper there. After supper he went away. I next saw him about 9 o'clock in the morning of the 2nd of July. He came in with his coat on his arm, and I took him into the sitting room. He went out on the porch after that. He was there about half an hour. I did not hear any conversation between him and his mother. They went upstairs to change his shirt. I do not think he came down again until dinner was ready. He had no shirt of his own to change with, and borrowed one of Mr. Miller's. I did not notice anything about the condition of his clothing when he sat on the porch. I saw him in his shirt sleeves, without either coat or vest on. I noticed nothing unusual about his shirt or about his pantaloons, except they were very dusty. Cross-examination. He came to the house on the evening of July 1st in a wagon of some kind. He came on foot the next morning. He went away that evening down to Penn Station and came back again. I did not see him when he came back. He and his mother went upstairs soon after he came in that morning. I did not see him downstairs again until dinner time. He went upstairs again after dinner and came down to supper. I did not see him between dinner time and supper. End of section 40. Section 41 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Homicide, Part 18. The Goss-Udderzook Tragedy, Part 17. Mrs. Jeffress recalled and examined by Mr. McVeigh. I saw Mr. Udderzook on the morning after he left our place. It was near 9 o'clock. He was passing my house. It was the 2nd of July. I did not notice anything particularly. He had his coat hanging across his shoulders. He passed through Jennerville towards Penn Station. I did not notice any change from the clothing he had when at our house the day before. Mrs. Sarah Kemble. I was at Mrs. Mullen's in Delaware County in June 1872. I saw several strangers there. I cannot tell the names of any but the one, Wilson. I saw a man there who was called Wilson. I was there from dinner time until evening. We were in the same room, and I again saw him sitting on the porch, where I saw him from an open window. I saw him at another visit. I met him there twice. That was in November, I believe. It was in chestnut time. We were there until the next day after dinner. The photograph heretofore introduced in evidence by the Commonwealth, representing one person standing and another sitting, was handed to witness. I cannot recognize either of these men. I do not see a resemblance to anybody I have ever seen. Cross-examination. I am a sister of William E. Udderzook, the prisoner. Mother and Mrs. Mullen were old acquaintances, and mother desired me and my children to go with her and see Mrs. Mullen. I was never there before. I have been since this matter occurred. Question. Did Mr. Wilson say in your presence that he knew William E. Udderzook? Mr. McVeigh. One moment. Whether or not he did or did not know, I object to the question, because it certainly is not evidence. In the first place, it is not cross-examination, and in the second place, it is not evidence as to the fact. We therefore object. The Court. The question may be asked. Exception noted. In answer to the question, witness said, I cannot say that he did. The Court. Have you any recollection? Witness. I cannot recollect his saying anything particularly. I do not remember the conversation. The conversation was all directed to my mother, and I did not have a conversation with him exactly to myself. I cannot say that he narrated any conversation about William, and I cannot say that he did not. I cannot say, because I do not exactly know. That is the reason. Witness further testified, I have been present in court during this trial this day week. Question. And you never saw either of the gentlemen in this picture? Witness. Oh, I was told who the one sitting down was. He was pointed out to me here. I would not have thought, only as he was pointed out to me. Question. Describe this man Wilson to the jury, if you saw him sufficiently to do so. Witness. He was not a very tall man, nor was he remarkably short, but he was a fleshy man. He had dark hair, dark eyes, and no beard. He was a smooth-faced man. I cannot think of anything else that I noticed. Mr. Wilson's conversation was with my mother. They were talking about half an hour. Dr. Jacob Price. On the 4th day of last August, I made an examination of William E. Udderzook at the instance of the district attorney, with a view of finding any marks of a struggle upon his person. It was a thorough examination of his whole person. We found no marks, no recent marks of any kind. To Mr. Hayes. This was more than a month after the alleged murder. A few witnesses were now examined with a view to impeach the character of Samuel Rhodes for truth and veracity. Robert A. Young lived about 4½ miles from Rhodes, had known him about 3 years, and testified that the character Rhodes bore in the neighborhood is not so good. On cross-examination, he said that he had not heard his character for truth-telling the subject of remark. John Townsend had known Rhodes about a year, had heard his character for truth was not very good. On cross-examination, he said he had not heard any question of Rhodes's character, that he could recollect of, prior to Rhodes's testimony in this case having been published. The court said, information based upon that is not evidence. Samuel Mayers had known Rhodes about a year and a half. In answer to the question whether he knew of Rhodes's reputation for truth and veracity in the community, witness said that he did not know it to be very bad. He had never heard a great deal. He never heard any reports upon the subject before this case. Rittenhouse Mayers lived about 1½ miles from Jennerville. Rhodes's reputation for truth and veracity was not so good. He had never heard it questioned before this case occurred. Harvey Jordan. I live 1/4 mile north of Penningtonville. I have lived there 10 years. I was past Bear's Woods the 2nd day of July, between the hours of 11 and 12 o'clock. I saw a horse hitched to the fence. I saw a man some 15 or 20 feet off, coming through the woods to the road, towards the horse and wagon. He was getting over the fence just as I was opposite the hind end of his wagon. He was just opposite where the body was afterwards found, between the road and where the body was found. He had an open wagon, what we call a mill wagon. I do not know who the man was. I never saw him before nor since. Cross-examination. It was an open, small wagon. I noticed nothing in it. There was nothing particular about the man to notice at the time. I lived within 1/4 of a mile of that place 1 year, and I have frequently gone there, and frequently have seen people hitch their horses to the fence there, and go into the woods for a short time, and come out again. There was nothing remarkable about it in any way. Joseph Harper. I live in Cochransville. I came past Bear's Woods on the night of July 1st, between 10 and 11 o'clock, as nearly as I can tell. I was riding in a small, open wagon. I did not see anybody as I went past the woods. I saw nothing to attract my attention. I saw no fire. I saw no horse and wagon hitched there. I heard no sounds of any kind, no voices. I cannot tell exactly the time, but it was from 10 to 12 o'clock. Cross-examination. I was on my way home from Penningtonville. I had been to a store there. It was 9:30 when I left the store. On my return, I stopped at Mr. Harvey's and stayed there a couple of hours. I suppose I heard the clock there strike 10 or 11. I know it did not strike 12. I heard a wagon drive past on a trot when I left the house. This house was about a mile from Bear's Woods. It may have been a little after 11 o'clock then. A little evidence was now offered in support of the good character of the prisoner. Andrew Shalady knew Udderzook 23 years ago, when he came into the neighborhood where the witness lived. The prisoner was then about 16 years of age. He remained there 6 or 7 years, and then went to Baltimore. While he lived in the neighborhood of the witness, the character of Udderzook was good, for anything the witness ever knew or heard of him. Since that time, the witness had known nothing about it. For the last 10 years, witness knew nothing of his character. David Mullen knew Udderzook as a boy, and had known him since. His character was good while he lived in the family of witness. He was a good boy what time he was there. Within 2 or 3 years, witness did not know anything about him. On cross-examination, witness said he could not speak of Udderzook's character since he was about 21. John W. Butler had known Udderzook since about 1867, when he came to work for him. All the time Udderzook worked for witness, he was very industrious and of good character. Witness had heard him spoken of, and had always heard he had a good character. Mr. Pardue, addressing the court, said, "We are in the unfortunate position of not having our witnesses from Baltimore that we expected. We will offer in evidence the pictures of the remains that were taken at Penningtonville, also a picture of Mr. W. S. Goss taken some 6 years ago." The defense here closed. The Commonwealth, in rebuttal, called several witnesses in support of the character of Rhodes for truth and veracity. Dr. Bailey lived within a mile of Rhodes since 1866, and had never heard it questioned. Robert H. Brown had known him at least 10 years, and had never heard his character or reputation for truth-telling talked of. Dr. J. J. Gibson had known him since 1861, and testified that his reputation was good, never heard it questioned. Hugh Rambo, Esquire, had never heard it questioned. He had known Rhodes 15 years. John K. Malone had known Rhodes 15 years, and knew his reputation for truth and veracity to be good, had never heard his word doubted. Thomas Martin had known Rhodes 10 years at least, and never heard it questioned. Charles Reese had known Rhodes over 20 years, and never heard his reputation for truth-telling questioned. Samuel Shannon had known Rhodes 25 years, and never heard anybody doubt his word, never knew it questioned. Evidence closed. Mr. Perdue opened the argument of the prisoner's case in a lengthy speech to the jury, from which we shall be able to make but a few brief extracts. May it please the court and gentlemen of the jury, I had hoped that the Commonwealth might open this case and tell their theories and give their proofs and points. They have waived their right, and the duty falls on me. It is a grave one, and I recognize its responsibilities. I shall go over the testimony as briefly as the circumstances will allow. I don't know that I need to go over it minutely. The first testimony offered has shown you an accurate plan of Penningtonville and the vicinity, on which was found, on July 11th last, the body of an unknown man. We will consider the testimony of those who first saw it. Gaynor P. Moore comes upon the stand, as you have seen, eager to testify, and with a show of importance that on him rests the burden of this case. People see these buzzards every day without thinking of anything remarkable. Do the prosecution believe that it is one of the fatalities of the case that when he saw them he went over into the woods? I do not ask you to throw suspicion on any man, or to say that any one has committed murder, but I call your attention to the remarkable evidence of Moore, the confidant of Rhodes, who passed a number of houses and went to hunt Rhodes, who came back with him to where this festered body lay. They only stayed there half a minute, raised it up and looked at the face. Then they dropped it down and rushed to the road. They say they heard a wagon passing. Men are not so easily disturbed under such circumstances. When Gaynor Moore got to the road, he found that Rhodes was close to his heels. They did not go back for another look, but started for the coroner. This body had been lying 10 or 12 days in this grave. The birds had torn what little dirt there was on the body off it. The inside portions were gone and decayed. A liquid mass filled that skin. But they raised it in midsummer, on a broiling July day. But, says Moore, the face was white like a dead man's, with the pallor of death on its features, and that anyone could have recognized those pale, deathly features. I don't say it is not so. I leave it in your hands. It is yours to weigh, mine to present. This was the first testimony hurled into the jury box. I will divert to consider the testimony of Rhodes as far as this matter is concerned. The first time he put the shovel down, he brought up the shirt. A wonderful coincidence! He does not say the face was white. It was enough for one witness to prove this fact. The Commonwealth did not need his testimony on this. They let that fact go. He didn't say it was to be recognized. He was not there to make out that part of the case. Then Esquire Rambo was called. He is the judicial officer who has been trying this case for the last 3 months. He lays the broad foundation of the case. I have not a word to say against Mr. Rambo. I have known him for years. I do not doubt he has believed all the time what he testified. But you must remember the terrible excitement in Penningtonville when this body was found. They were not used to such excitement. The whole town rushed down to the grave and sat on the coroner's jury and listened with breathless interest to hear all the witnesses. Recollect, they are human, creatures of circumstances, their minds to be swayed by prejudices and feelings. The testimony of those who have taken an active part in getting evidence must be warped in judgment and exaggerated in statement. This is human nature. We all do it. This was 4 months since, and all the circumstances have been talked over among them. I say it is not unnatural that the judgment of these people is not as safe as that of those not close to the circumstances surrounding the case. There was a man insured in Baltimore, in 4 companies, to the amount of $25,000. On February 2, 1872, this man was burned in his shop on the York Road. Of course, his family made application to the companies for the insurance. The preliminary proof was made by disinterested persons. They refused to pay the money. Suit was brought, and a verdict was obtained by Mrs. Goss. Immediately there was a motion made by these companies for a new trial. While this motion was pending, this murdered body was found in Bear's Woods. Then the creatures of these insurance companies came up to see about it. The insurance companies know that Udderzook is a very important witness in this trial, in which there is $25,000 at stake. They have a very strong interest in this trial. You all know how such an interest will prejudice men. If Udderzook should die, they will win their case. Acquit Udderzook, and he goes to Baltimore to testify against these corporations. Their case would then be lost. Therefore, they want a new trial with Udderzook's part left out. They then have out of the way an important witness. David R. Mullen tells us that a man came to his house June 22, 1872. The man gave the name of A.C. Wilson. He came on a Saturday and went to Philadelphia and came back with a bag. He described him as having a smooth, round face. He let his whiskers grow. He identifies the picture. Says it looks like him. Two men often look alike, don't they? We often speak to people, mistaking them for somebody else. This picture was shown him with Mr. Langley scratched out. When the picture was shown, the lower part of the face was covered up, and then the question was asked whether they didn't recognize Goss. But if this same thing is done to Langley's picture, it looks as much like the picture of Goss as two pairs. Mr. Mullen tells you that he got a letter from Udderzook some 6 or 8 months before the fire. Udderzook was raised with Mr. Mullen, and if he should know anyone who wanted board in the country, was it not natural that he should think of Mullen the first one? 6 months after this, a man, who said he was from Baltimore, came there to board. What connection is there between this man and Goss? They have been trying to impress you that Udderzook was trying to make arrangements for Goss to go into retirement. But there was nothing remarkable in Udderzook's sending this man there. He knew they took boarders, and was anxious to do them a service. Mrs. Toombs tells us all she knows about this man, and a little more. She is absolutely certain that she knew his habits, his clothing, his valise, where he got his liquor, how often he drank, and how often he was drinking, what paper he read, his associates, when and how often and to what degree he was intoxicated. She saw him address one letter to Mrs. Eliza Arden. She probably thought she was telling us that he wrote a letter to his wife, as she may have gathered the impression that that was the family name of his wife. But it happens that the family name of Mrs. Goss was Stewart. I much fear this good woman, in her desire to further the cause of justice, has overstepped the mark. Mr. Toombs, who had never read the papers, didn't care whether Wilson was dead or alive. He saw Udderzook come, and heard Wilson call him doctor or something. He remembers that morning of the 11th of May perfectly, just as well as he remembers the features of Udderzook, just as well, and not a bit better. Mrs. Toombs would seem to have lately given up this admirable boarding-house, and I have no doubt it was a good one. It may have been because of this excitement and her extended field of usefulness. Then they all talked about this picture, which had been sent them, and O'Donnell had a picture, and Mrs. Toombs had a picture, and they would all look at them and talk about them, these pictures with Langley crossed off, that the witness might not mistake his picture for Wilson. Then comes the witness Reeve. It is perfectly delightful to find such memories as these Newark witnesses have. We have no such minds here. Then Edward Sutton testified. He recollected the valise and recognized the ring. He was a jeweler and had examined it carefully. He thought the ring had been bent since Wilson had it, and you will remember Engel testified Goss's ring was bent when he had it in Baltimore. The witness Williams next came. He was also from Christopher Street. He bade Wilson good-bye when he left Newark, and says he had no baggage with him. Here again the Commonwealth's witnesses do not agree, and they should make them consistent. This witness, a jeweler, was a remarkable man. He was able to give the nationality of rings, and could tell the nation of the men who made them. He even knew the relative influence a residence here would produce on the workmanship. I must remark the breadth and extent of his mind." Mr. Perdue commented similarly upon the manner and character of nearly all the witnesses produced by the state, throwing doubt upon their testimony, and impressing upon the jury the fact that the prisoner was entitled to the benefit of everything which looked doubtful. His entire argument occupied nearly 4 hours. The Honorable Wayne McVeigh, the senior counsel for the defense, then addressed the jury in an eloquent and fervent appeal in behalf of the prisoner. The argument of the distinguished counsel was directed to the inherent improbabilities of the case, and he made the most of all that could be turned in any way to the advantage of his client. He was listened to with marked attention by the jury, the court, and the mass of spectators which filled every available place in the spacious courtroom. End of section 41. Section 42 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an Authentic Record of Remarkable Cases, by John B. Lewis and Charles C. Bombaugh. Homicide, Part 19. The Goss-Udderzook Tragedy, Part 18. District Attorney Abram Wanger followed with the closing argument for the Commonwealth. He reviewed the formidable array of evidence which had been produced against the prisoner, and pointed out the consistency of the theories of the state as based upon that evidence. Upon the conclusion of Mr. Wanger's argument, Chief Judge Butler delivered the following charge to the jury. Gentlemen of the jury, the prisoner at the bar, as you have learned, is charged with murder. The case of the Commonwealth rests upon what is known as circumstantial evidence, and indeed, where willful, deliberate murder, contemplated beforehand, is committed, it rarely occurs that direct, positive evidence respecting it exists. Perpetrated as it usually is by lying in wait, by means of poison, or by falling upon the victim when no one is by, the only evidence must, commonly, be found in the circumstances attending it. And this character of evidence is ascertained by experience to be little, if any, less satisfactory than that which is known as direct or positive. Where the circumstances relied upon are properly established, and the inferences arising from each one, and from all of them combined, point naturally in one direction, there is no greater danger in following them to their conclusion than attends all human investigation. That we may err in such cases is possible, but so we may where the evidence is direct or positive. The circumstances may, possibly, mislead, but so may the eyes or the ears or the dishonesty of witnesses. Now, turning to the evidence, we find that on the 11th day of July last, 1873, Gaynor P. Moore passed Bear's Woods on his way to Cochransville. He observed buzzards there in large numbers, and a very offensive odor. When returning home, he entered the woods to ascertain the cause of what he had observed. And at the distance of about 65 feet from the turnpike, he discovered, in his own language, something mysteriously hidden, a small part of which was uncovered, doubtless by the birds, the balance concealed by means of leaves and a thin covering of earth, and with the dead limbs of trees placed lengthwise over it. Obtaining the aid of Mr. Rhodes, who lives some distance away, he returned to the place with a shovel. Upon the earth being raised up at the left side of the body, a bloody shirt was uncovered. Next, the head was raised, and the body ascertained to be that of a man. At this time, the witness says, the face was quite white and natural, and he believes he could have recognized it had he been acquainted with the individual in life. It was now about 5:30 o'clock in the evening. They left the grave in the condition described, and, after attempting to procure the aid of a man who drove by on the turnpike, went to Penningtonville and notified the deputy coroner, Mr. Rambo. This gentleman, with several others, started for the place and reached it, as they have said, about 7 o'clock, being a little before sunset. Mr. Moore also again returned soon after. The color of the skin had now changed, and was quite dark, as you heard it described. The deputy coroner had the covering removed from the other parts of the body, and it was then seen that the legs and arms were off. That part of the abdomen which was exposed when Mr. Moore first entered the woods was open, the entrails had disappeared, a mass of semi-liquid corruption occupying their place. In another part of the woods, about 65 feet distant, the arms and legs were found, also under a slight covering of earth and leaves. The body, with the limbs, was removed to the turnpike, placed in a box, and then taken to Cochransville. At the grave in the woods, and at Cochransville, it was examined by Dr. Bailey, more critically at the latter place, and he has described to you the marks he found upon it. He says there was one opening in the side, between the 3rd and 4th ribs, another, he thinks, between the 5th and 6th ribs, and another between the 8th and 9th, and that these openings were on a line. That he found another between the 6th and 7th ribs, farther towards the back, and another at the lower part of the breastbone. How these openings or holes were made, the witness is unable to form any judgment, inasmuch as decomposition had probably changed their form when he saw them. He also found a small cut on the left side of the neck, about an inch above the collarbone, not penetrating deeper than the skin. Another incised or cutting wound, commencing on the left side of the neck, under the ear and on a line with it, running across the windpipe, opening it in 2 places. Also a small incised wound across the depression of the lower lip, not through the skin, and another wound across the bridge of the nose, breaking the bones and depressing them, apparently made with a blunt instrument of about the thickness of a spade. He also found that the front teeth, 4 above and 4 below, had been driven back into the mouth, 2 still adhering to the gum, and 2 lying loose upon the tongue. Dr. Howard testified that he made an examination on the 18th of July, refers to the wounds on the nose and the mouth, and says the blows by which they were inflicted must necessarily have been very severe. Now, were these remains those of one who had lost his life by violence? The unusual place and unusual manner of interment, the mutilation by severance of the limbs, so as to prevent identification, and their separate concealment, the marks upon the body, and manifest evidence of violence about the neck, nose, and mouth, the bloody shirt found in the grave, all bear with great weight upon this question. If you find that a murder or homicide of any grade was committed, you would next pass to the question, who was the man so killed? The Commonwealth alleges that it was Winfield Scott Goss. Was it? Winfield Scott Goss resided in the city of Baltimore and its near vicinity in the year 1871 and the early part of 72. He was a brother-in-law of the prisoner. Mr. Barnett's, who knew him intimately, having been employed in the same establishment with him for some years, describes him as about 5 feet 8 to 9 inches in height, well built, with an exceedingly prominent bust, very erect, with shoulders thrown far back, his form full and in every way well developed, with dark eyes, a straight nose, a round, full face, dark brown hair a little mixed with gray, a prominent forehead, and good teeth. Other witnesses similarly describe him, Mr. Carter saying that his teeth were very fine. He had procured insurance on his life in several different companies to a large amount, the first policy bearing date the 21st day of May, 1868, and the last the 25th day of January, 1872. On the night of the 2nd of February, 1872, a frame shop, in which it is said he was engaged in gilding picture frames and experimenting with a substitute for India rubber, was found to be on fire. After it was consumed, or nearly so, the charred and blackened remains of a man were discovered in the cinders, lying near the chimney, which was about the center of the building. Goss was no more seen in the neighborhood, and on the 23rd day of the same month in which the fire occurred, his wife made application to the insurance companies for payment of the sum insured on his life. Payment being refused, she commenced suits against them, the prisoner appearing as a witness in her behalf. Were the remains found in the fire those of Goss? That Goss went to the building some time during the day preceding the fire is clear. Joseph Laudenslager, the comments on whose testimony you will remember, says he saw Goss, in company with the prisoner, start on the afternoon of that day from the city for this building. That they took with them a box 4 or 5 feet long, about 15 inches in depth and width, containing, as the prisoner alleged, machinery for Goss's laboratory. Louis Engel testified that the prisoner and Gottlieb Engel came to his father's house, a short distance from the shop, after dark, saying the lamp at the shop had gone out, and desiring another to take over; that they did not start back immediately, but, in the language of the witness, stopped about the house after the lamp was ready; and while still there, the prisoner, who went to the door to empty a tumbler or dipper from which he had been drinking, saw the fire and gave the alarm; that he, the witness, the prisoner, and Gottlieb ran over, the prisoner and Gottlieb falling a little behind; that when he reached the shop it was in flames, and not long after the roof and upper part fell in; that he saw no attempt to enter the building or arrest the fire; that he heard no suggestion that anyone might be inside until after the building was burned nearly down, when the prisoner came and requested him to go to Baltimore and inform Goss's family of the fire, and that Goss was missing. Sarah Moore, the colored woman, called by the defense, testifies that she was living at the time of the fire about 100 yards from the shop; that, having occasion to go to her door, she saw Goss outside the shop with a light in his hand; that it was dark and she did not see him in front, but observed his side face as he passed in, and heard him lock the door; that she then sat down to her supper, and soon after finishing it discovered the shop to be on fire. Mr. Smith testifies that he reached the fire when the building was all in flames; that he heard Mr. Cator complaining to the prisoner for not giving the alarm before the fire had gotten so far, if he supposed anybody to be within the building, asking him if he desired to create a false alarm by saying Goss's body was in the flames, and that the prisoner replied that he was unacquainted with anybody about the place. The witness says he then went nearer the fire, and procuring the assistance of Martin Quinn, found a body, and succeeded in dragging it out of the flames. That, seeing the prisoner again in the crowd, he asked him if he was going to leave the corpse there like that of a dog, while claiming it to be the remains of his brother; upon which the prisoner turned his back and made a noise as if crying. The corpse was then placed in a box, and taken to Mr. Lowndes' stable, where it was left for the night. The next morning, this witness says, he went to the scene of the fire, as early as it was light enough to see, and sought among the ashes for Goss's watch and ring, finding nothing but a melted bottle, part of the door hinge, and a few small bones. From the body the hands and feet were off, the skin was burned crisp and blackened, and identification by means of the features and expression was impossible. Mrs. Goss testifies that the corpse was brought home in the evening of the day following the fire, that she identified it as that of her husband. She says, however, she judged only by the size and shape of the head, the neck and body; that in these respects it resembled him. This, it must be observed, falls short of identification, which can only result from observing some peculiar mark by which the individual may be known, or the peculiar expression formed by the features of the face. Mr. Arden, the stepfather of Mrs. Goss, who saw the corpse, also testifies that he observed the same resemblance to Goss in the head, neck, and body. Mrs. Arden, the mother of Mrs. Goss, says the body could not be recognized by reason of its condition, but that the shape of the head and body resembled those of Goss. Dr. Howard testifies that about 1 year after the fire he made a careful examination of this body and found it to be that of a man of about 5 feet 8 to 10 inches in height, with full chest and shoulders thrown back. This witness further says that upon a critical examination of the mouth, he found that 1/2 the teeth had been lost many months at least before death, 2 of them directly in front, one being from the upper and the other from the lower jaw. This latter statement is important when considered in connection with that of the witnesses who have described Goss's teeth as regular and fine. On the day preceding the fire, it is testified that Goss drew out of the bank the balance standing in his favor, and his account there closed. Was it his body that was found in the fire? If the inquiry stopped here, it might be unsafe to conclude that it was not. But the inquiry does not stop here. There is other evidence bearing upon this question of a highly important character. On the 22nd day of June following the fire, and while the suits referred to were pending, a man presented himself at the house of David Mullen, Cooperstown, asking to remain as a boarder, and giving his name as A.C. Wilson. Mr. Mullen says he remained until the 16th day of the next November, when he left for Athensville, about 2 miles distant. Here he remained 1 week, and then left, appearing at Mrs. Tombs's boarding house in Newark on November 29th, where he remained nearly 7 months. The witnesses who saw this man at Cooperstown and in Newark describe him as stoutly built, 5 feet 8 to 9 inches in height, full-chested, shoulders thrown back, with dark brown hair a little mixed with gray, good teeth, full, broad forehead, and having, when in Newark, mustache and side whiskers. The witnesses do not all precisely agree in describing his features, but unite as regards his general appearance, and in saying that his face was fine. Several witnesses also state that he had a habit of drinking to excess. These witnesses further testify that he carried on some correspondence with Baltimore, where Goss had resided, sending letters and packages and receiving others in return. One witness, Michael Olray, testifies that, being acquainted in Baltimore, he conversed with Wilson about mutual acquaintances residing there. It is clear he knew the prisoner, for he received a visit from him while at Newark. A pair of pantaloons, which several witnesses recognized as Wilson's, left behind when quitting Newark, have been exhibited. They are darned in the seat and are thus identified. Mrs. Toombs said she noticed that they were very short for him. Louis Engel testified that when Goss boarded in his father's family near Baltimore, during the summer or fall preceding the fire, he had such a pair of pantaloons as those exhibited. Says he, the witness, assisted Mrs. Goss to wash them, that he noticed the color, the cord on the side of the leg, and also observed that they were short for Goss when worn. It is further shown that this man wore a large bloodstone ring, such, in general appearance, as the one exhibited here. Some of the witnesses testify that they recognize this as the same. Engel testifies that Goss had a similar ring, being in all respects like this, that he, the witness, wore it sometimes, and that he believes this to be the same, while Mrs. Goss, who describes her husband's ring as being of about the same size and of the same general appearance as this, says it was, according to her recollection, in some respects different. Whether it is possible for any of the witnesses to recognize the ring fully, so as to swear to its identity, is for you to determine. It would seem to the court safer to conclude that the ring worn by Goss at Engel's and that seen on the man known as Wilson were alike in size, shape, material, and general appearance. A frock coat is produced, which Mrs. Toombs identifies as a coat worn by Wilson and left behind him when quitting her house. On this coat being exhibited to Mr. Hines, a tailor residing in Baltimore, he testified that he made one in all respects like it, being of precisely the same measure, for Goss. That while he cannot describe to you how he recognizes his own work upon this coat, he tells you that he believes he does. It is shown by several witnesses that Goss, while in Baltimore, had in his possession what is called a double ratchet screwdriver, very peculiar in its construction, and claimed to be his own invention. It is further shown that the man calling himself Wilson had a wooden model of this same screwdriver, which he claimed to have invented. Louis Engel testifies that when Goss boarded at their house, near Baltimore, he saw him and Udderzook a good deal together, and that Goss frequently called Udderzook Doctor. Several of the witnesses who saw Udderzook and the man called Wilson together at Newark testify that Wilson called Udderzook Doc. The significance of the last mentioned circumstances cannot be overlooked. And now, following this evidence, designed to show similarity in person and apparel, in the habit of intemperance, possession of the screwdriver, and in the appellation or title used when addressing Udderzook, the Commonwealth has undertaken to prove the actual identity of Goss and the man known as Wilson, by exhibiting the photograph of Goss to the witnesses who were familiar with Wilson, some of them having been his room-mates in the boarding-house. Were it possible to produce Goss himself before these witnesses, as he appeared in life, they would tell us, doubtless, whether he is the same man who was known to them as Wilson, and their judgment would be the highest and best source of information on this subject. As Goss cannot be so produced, possibly the next best means of judging of his identity with Wilson is obtained by producing his photograph, if it be a perfect one, and allowing these witnesses who were familiar with Wilson to base their judgment on it. The picture is of course a much less satisfactory means of judging than the presence of the individual would be, because it shows the face in a state of repose, not very frequently observed in the individual, and, showing it on a much smaller scale, the expression of the face is less distinct. Still, where a photograph is perfect, it shows an exact likeness to the extent presented, and can generally be recognized with great ease by those familiarly acquainted with the individual. The photograph exhibited here is shown to be that of Goss. Some of the witnesses who knew the man called Wilson say this picture looks like him, that the shape of the forehead and face is like his, but they do not recognize the picture as his. Their testimony must not be overestimated. It goes no farther than to show resemblance. Other witnesses, more familiar with this man, particularly some of those who boarded in the same house with him, say they recognize Wilson in this picture, one saying he sees the man in it, others it is him, and so on, in varied language expressing the same thing. Too much importance should not be attached to the fact that these witnesses were not able to point out any particular feature by which they recognized the picture as his. If asked to point out the feature or features by which your most intimate friend is distinguished from others, you probably could not do it. Were you to refer to the size of the head, shape of his face, nose, or mouth, you would doubtless find that in all these respects he is not singular. But you recognize him instantly, and with absolute certainty, by the peculiar expression which results from the combined effect of all his features and his mind. And this you cannot describe, for words will not portray it. In determining the weight to be attached to the testimony of the witnesses who say they recognize Wilson in the picture, or recognize the picture as his, it is important to remember that when they knew him, his beard was different. What effect the change of beard would have had on the expression and appearance of the picture, you will judge. You will also bear in mind the comments of the defendant's counsel on this testimony, and the fact that the prisoner's sister, who saw Wilson at Mr. Mullen's, says she did not see any likeness to him in this photograph. The Commonwealth has further undertaken to show that Goss and this man wrote, not only a similar, but the same hand. In this connection Emma Taylor testifies to the receipt of many letters or notes from Wilson, and a knowledge of his handwriting. 2 letters, one of them addressed to Mr. Mullen, signed A.C. Wilson, being exhibited to her, she says, in her judgment, they are his handwriting. On being shown another letter signed W.S. Goss, and testified by Mr. Butler, as he believes, to be in Goss's handwriting, she says that, in her judgment, it is the handwriting of Wilson. This witness, however, as you will remember, did not exhibit such accurate knowledge of Wilson's handwriting as to render her judgment in regard to it very reliable, and what she says should therefore be received with great caution. End of section 42. Section 43 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases, by John B. Lewis and Charles C. Bombaugh. Homicide, Part 20. The Goss-Udderzook Tragedy, Part 19. John W. Butler testifies that he knew Goss intimately, and corresponded with him some years ago, that he knew his handwriting very well, and believes himself able to recognize it. The letter signed W.S. Goss, before mentioned, being shown him, he answered, "I believe this to be Goss's handwriting." The 2 letters signed A.C. Wilson, also before mentioned, being shown this witness, he answered, that the writing, in his judgment, is that of Goss. The signature of A.C. Wilson on the register of the Central Hotel in Philadelphia, under date of being shown the witness, he answered that he would take this to be written by Goss, as also the signature on the register of the William Penn Hotel, though in respect to these single signatures his judgment is less distinct than that expressed in regard to the letters. The intelligence manifested by this witness, as well as the caution observed in expressing his judgment, should be considered in estimating the value of his testimony. Franklin Mills testifies that he knew the man called Wilson, and upon one occasion, when sitting at his side, discovered a small scar running up into his hair on the side of his forehead, that he had never noticed it before. Mrs. Goss testified that her husband had no scar upon him. You have heard the comments of counsel in respect to this, and will determine what weight this contradiction should have, but in doing so will remember that Mr. Mills speaks of the man more than a year after Mrs. Goss had last seen her husband. Now, was this man, called Wilson at Cooperstown in Newark, Winfield Scott Goss under an assumed name? If he was, you will judge whether the conclusion is or is not reasonable that he had entered into a scheme to obtain money fraudulently from the insurance companies, and that the burning of his shop was a part of this scheme. If you reach this conclusion, a reason will be found for his appearance in Pennsylvania and New Jersey under an assumed name. Still, if you find that this man was Goss under an assumed name, you will have made but a step towards finding that the remains discovered in the woods were his. But now, if this was Goss, we have him in Newark on the evening of the 25th day of June, 16 days preceding the discovery in the woods. He then started for Philadelphia. Mrs. Toombs testifies that, 3 days later, he wrote to her from Philadelphia under date of the 28th. Francis Jacobs testifies that he is clerk and bartender at the William Penn Hotel in Philadelphia, that in the forenoon of the 26th, the day after this man left Mrs. Toombs's, a man came to the hotel representing himself to be A.C. Wilson, and registering this as his name. The witness describes him, and being shown the photograph exhibited here, says it looks like this man. He is unable to describe any other stranger who called about that time or since, and says he did not recognize the resemblance in the photograph until told whose it was. You will judge whether this witness can truly describe this man as he undertakes to do, and whether he does see the resemblance in the picture to which he testifies. That a man came to the hotel, representing himself to be A.C. Wilson, that the witness saw him register his name, that he stayed till the next day, that the prisoner visited him, occupying the same room, and went away with him the next day, the witness is positive. The register is produced, and the name A.C. Wilson appears upon it, and this signature, as we have seen, Miss Taylor and Mr. Butler expressed the judgment, is in the handwriting of Goss. If this witness is believed, it is on the morning of the 27th that the prisoner and this man left the William Penn. Where they went at that time does not appear. On the evening of the following day, the prisoner was seen upon the train at Wilmington by Mr. Hodgson, who rode with him to Philadelphia. We do not observe any conflict between the testimony of Mr. Hodgson and that of Mr. Jacobs, because we fail to see inconsistency between the facts to which they speak. 2 days later, Francis Pyle, who lives near West Grove, in this county, testifies that the prisoner, in company with another man, came to his place. He says he had known the prisoner formerly and recognized him. Mrs. Pyle and the little boy, Elmer Pyle, also saw the men there, and say they recognized the prisoner as one of them. Mr. Pyle and the boy describe the appearance and parts of the dress of the other, referring to his build, his whiskers, and mustache. Mrs. Pyle saw but little of him, and was not very near. Mr. Pyle says he wore gaiters like those shown here, and had a ring on his finger. Upon being shown the photograph, he says it looks like a picture of this man. The son also, in addition to the general description, says this man wore gaiters, had eyeglasses, and that when they were together under the cherry tree, this man called the prisoner Doctor. This last circumstance, if true, is very significant, for, as we have seen, if the witnesses are believed, this is the same appellation by which Goss, in Baltimore, and the man calling himself Wilson, in Newark, addressed Udderzook. From Mr. Pyle's place these men went in the direction of Jennerville. In the evening of the same day, Mr. Jeffress, Mrs. Jeffress, and Mr. Townley testify that the prisoner, with another man, appeared at the hotel of Mr. Jeffress in Jennerville. These witnesses recognize the prisoner, as does also Mr. Wallace, who saw him there and had known him before. They describe the other man as about 5 feet 8 to 9 inches in height, good-looking, full-breasted, straight, with shoulders thrown back, mustache and side whiskers of a dark color, Mrs. Jeffress saying that she at the time thought he was the straightest man she had ever seen. On being shown the photograph before referred to, these witnesses also say the picture resembles this man. The next morning, being the 1st of July, it is shown, if the testimony is believed, that the prisoner obtained a horse of Mr. Patchell, living near by, and visited his brother-in-law, Samuel Rhodes, who resides a short distance from Penningtonville. Here he was recognized by Mr. Rhodes and his wife, who is the prisoner's sister. They testify that he spoke of the man he had left behind at Jennerville, and Mr. Rhodes says he described him as a man, having no one to look after him, who had been lost for a long time, and was supposed by everybody to be dead, one whom the prisoner had had at Newark, or New York, the sounding being so much alike that the witness was not certain which, and Philadelphia. The bearing of this description upon the identity of the man left behind is most important. You will judge whether it does or does not describe Goss and the man known at Newark as Wilson with great certainty. Lost for a long time, supposed by everybody to be dead, whom he, the prisoner, had had at Newark or New York and Philadelphia. On the evening of the same day, the prisoner, having hired a carriage and horse at Penningtonville, went to Jennerville, took the man he had left therein, and started back. When he reached Penningtonville in the night, this man was gone, and was no more seen alive. Bear's Woods is by the roadside. Were the remains found there his? The last time seen, he was going in that direction. If Mr. Rhodes is believed, the prisoner had contemplated leaving him in the woods. When the remains were first uncovered, Mr. Moore testifies that the face was white and natural, says he looked to ascertain whether he could identify it, and believed at the time, and does still, that he could if he had known it. On being shown the picture before referred to, he says it bears a resemblance to that face. This, standing alone, would be of no value, because of its uncertainty. But Mr. Moore and others who saw the remains that evening and the next day, say the upper lip presented the same appearance as the cheeks did where the whiskers came off on being touched, showing that the man had worn a mustache with side whiskers, that his hair was dark brown, mixed a little with gray, and Dr. Howard, as well as all the witnesses who examined the remains with care, says the forehead was square and straight, the face fine, chest full, shoulders well thrown back, the person very erect, and teeth regular and good. You will judge whether this is or not an accurate description of the man we have been following. In the same grave a shirt was found. It is not identified, for there are no marks upon it by which to distinguish it from others. There are many such, as Mr. Crockett testifies, but this witness says he sold a shirt in all respects like this, in Newark, to a man called Wilson, as he was informed. And Mrs. Toombs testifies that Wilson had such a shirt, showing another point of resemblance. Then again, a pair of Congress gaiters were found upon the feet, resembling those worn by the man we have been following. But a more remarkable and striking resemblance still is found in the fact that this man's gaiters were marked number 8 on the inside near the top, if Mrs. Toombs is believed, of which you will judge, and had recently, as Mr. Saurine testifies, been half-soled, and the gaiters found on these remains exhibit a similar number in the same place and a similar condition in respect to the soles. Now you will determine whether these are the remains of the man we have been following. If they are, and this man was Goss, then did the prisoner take his life? In starting upon this inquiry, the first thought that presents itself is, had the prisoner any motive to commit this crime? If the remains were those of Goss, you will still judge, as before remarked, whether he had not entered into a scheme to defraud the insurance companies by hiding himself from the world and endeavoring to create the belief that he was dead. And if he did enter into such a scheme, you will further judge whether the conclusion is or is not reasonable, that the prisoner had also entered into this scheme. For it would follow that while Goss was thus alive under an assumed name, and while the prisoner knew this, for, according to the testimony as we have seen, he visited him at Newark on the 11th of May, he appeared as a witness on the 28th day of the same month to prove his death, not, it is true, by swearing directly that he was dead, but by swearing to circumstances by which he sought to create that impression, and the result is the same. If it is true that the prisoner had united in such a scheme, it was very important to him that the existence of Goss should not come to light, for if it did, not only would the scheme fail, but the prisoner become liable to prosecution for conspiracy and perjury. If you find such motive existed, then you will judge whether the disappearance of Goss from the neighborhood in which he was known, and his reported death, did not invite the commission of the crime by reason of the immunity from discovery which these circumstances tended to afford. Still, a motive to commit the crime, and such opportunity to gratify it, would be of no consequence in the absence of evidence that the prisoner did commit it. Then what is the evidence that he did? If Wilson was Goss under an assumed name, and the remains found in the woods were his, then we have found the prisoner and Goss together on the 1st day of July. On the evening of this day, as we have further seen, the prisoner visited his brother-in-law, Samuel Rhodes, whose testimony I will now read. The evidence of Rhodes was here read by the court. This witness and his testimony have been criticized by counsel, and you will determine what weight his statements should receive. In this connection, it is important to remember that he exhibited the prisoner's letter, referred to, soon after it was received, and reported to his neighbors the interview, detailed here, almost immediately upon its occurrence. You will also remember the testimony heard respecting his character for truth-telling, and will examine the prisoner's letter to see whether it does not corroborate his statements. That letter appears by the envelope to have been forwarded in the preceding December, and Mr. Rhodes testifies that it was received at that time. On the evening of the same day after the interview with Rhodes, as night was coming on, the prisoner started with the man by his side in the direction of Penningtonville. Bear's Woods is about 9 miles from the place of meeting, and in this direction the parties were going when last seen. John Hurley, who lives within a short distance of the woods, testifies that his wife, in the night, aroused him to hear a noise in that direction, that he distinctly heard hallooing, and distinguished the voices of 2 individuals, but could not distinguish any expression except the exclamation, "Oh!" That about daylight the following morning he discovered smoke arising from a fire in the woods, and several other witnesses testify to having seen fire in the woods on that morning. Now, if the remains found in the woods were those of the man who started with the prisoner from Jennerville, you will judge whether the prisoner did or did not carry out the design which Rhodes says he expressed in the interview a few hours previous, whether the hallooing testified to by Hurley as heard that night did not come from this man, and whether the smoke seen did not issue from a fire that consumed the bloody garments, as well of the perpetrator as of the victim, and other evidences of the crime. It is further shown that at about 12 o'clock that same night the prisoner returned the vehicle to the stable at Penningtonville. The iron supporting the dasher on the left side, where the man was sitting when last seen, was broken, and the leather bent forward. 2 of the bows supporting the top, on the same side, were broken from the bed and swinging loose. The oilcloth that had covered the floor was torn out and gone. The blanket and sheet that had accompanied the wagon were missing. What had become of them? Had they been stained with blood and consumed in the fire? After discovery of the body in the woods, the floor of the wagon was examined, and red spots, apparently made by blood, were observable on the edges of the boards forming the bottom, and underneath where it appeared to have spread. Dr. Howard testifies that, having applied microscopic and analytical tests to these spots, he ascertained them to be made by blood. Where the prisoner spent the balance of the night after returning the vehicle does not appear. He was seen early the next morning entering Cochransville on foot. Later in the day he was met still on foot going in the direction of Jennerville. On the evening of the same day, about 6 o'clock, he appeared at Penn Station on the Philadelphia and Baltimore Railroad, where he took the train east, getting off again at West Grove, this being the point at which he and the former companion had, according to his own statement, left the train 2 days before. In a short time he reappeared, carrying a carpet-bag or valise, and entered the train going westward. At Penn Station he again left it, and passed in the direction of Mr. Miller's, where his mother resided. On the next day, being the 3rd of July, he took the train for Baltimore. When arrested, he made a statement which you have heard, and you will judge whether it is consistent with probabilities, or finds any countenance in the ascertained facts of the cause. We now repeat the questions before stated. First, were the remains found in Bear's Woods those of Winfield Scott Goss? Second, if they were, did the prisoner at the bar take his life? Both these questions must be found against the prisoner before he can be convicted. In passing upon him, you will carefully weigh all the evidence, as well as the comments of counsel upon it, and will also consider the testimony which the prisoner has produced in regard to his former character. If you convict him, you must determine the grade of his crime. That it is murder, if he is guilty at all, has not been questioned by his counsel. But in Pennsylvania, the legislature, considering the difference in guilt where a deliberate intention to kill exists, and where no such deliberate intention appears, has distinguished murder into 2 degrees, murder of the first and murder of the second degree, and required the jury trying the accused, if it finds him guilty, to ascertain and find by their verdict whether it be murder of the first or murder of the second degree, and has further provided that, "murder which shall be perpetrated by means of poison or lying in wait, or by any other kind of willful, deliberate, and premeditated killing, shall be murder in the first degree, and all other kinds of murder shall be deemed murder of the second degree." Then, if the defendant is guilty, is it of murder of the first or murder of the second degree? If the prisoner is guilty of killing Goss, you will determine whether it is not plain that the crime was contemplated beforehand, and the killing willful and deliberate. The circumstances bearing upon this question have been so fully stated, in treating other parts of the cause, and must be so distinctly present in your minds, that we need not repeat them here. Still, this question is for you alone to determine, and if you convict the prisoner, you must say whether it is of murder in the first or second degree. In conclusion, we urge upon you to bear constantly in mind its great importance. To the prisoner it involves everything of earthly desire. You will, therefore, give to the facts not only their most reasonable construction, but also their most charitable and merciful construction. And if, when thus considered, they fail to satisfy you of his guilt, you will acquit him, regardless of all consequences, and he is entitled to the benefit of every reasonable doubt. A doubt, however, is not a mere possibility that the prisoner may not be guilty, but an honest hesitation of the mind arising from want of proof. If, on the other hand, the facts satisfy you of his guilt, you must convict him. In such case, no consideration of pity or mercy can influence you. To the tender appeal made by the presence of wife and children, you must turn a deaf ear. To listen to it would be more than a mistake, it would be a crime against the innocent, against society. With the consequences which may attend conviction, you have nothing to do. They rest upon others. If the evidence satisfies your minds of his guilt, you have no choice. Following the pathway of the evidence, you can turn neither to the right nor to the left, but must accept the conclusion to which the facts lead. If you entertain views unfavorable to capital punishment, you must disregard them here, remembering that it is not the jury, but the law that inflicts the punishment. The jury does not pronounce the sentence which condemns to death, but simply determines whether the prisoner has committed the crime. You will now take the case, and forgetting everything but the law, the evidence, and your duty, will pass an honest, deliberate, and fearless judgment between the Commonwealth and the prisoner. The jury retired on Friday afternoon, November 7th, and on Sunday morning they sent a written request to see the judge. They were brought back into open court, where Judge Butler received them in presence of counsel and prisoner, and informed them he would hear their request. The foreman said that they desired more light in regard to the evidence of Dr. Bailey. The court sent for its notes and read the desired evidence very carefully. The foreman then said that the counsel had particularly called their attention to sundry papers, which they were charged to examine carefully, but which had not been given to them. The court said they would send for the papers and place them before them, which was done. The jury then retired to their rooms, and the court adjourned. At 2:00 p.m. the court was reopened on information that the jury had agreed, and the prisoner was brought in. The clerk then asked, "Gentlemen of the jury, have you agreed upon your verdict?" Mr. Morton, foreman, "Yes." Clerk, "What say you in the issue joined between the Commonwealth of Pennsylvania and William E. Udderzook, defendant? Do you find him guilty in manner and form as he stands indicted, or not guilty?" Foreman, "Guilty of murder in the first degree." Judge Butler said, "Gentlemen, your duties have been arduous and painful, and we have sympathized with you very deeply. We now discharge you, and for the careful and patient manner in which you have fulfilled your duty, you are entitled to the thanks of your fellow citizens." Mr. Perdue, of the prisoner's counsel, made a motion for a new trial. He was told that he had 4 days in which to file his reasons. The prisoner was remanded back to jail, and the court adjourned. End of section 43. Section 44 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an Authentic Record of Remarkable Cases, by John B. Lewis and Charles C. Bombaugh. Homicide, Part 21. The Goss-Udderzook Tragedy, Part 20. 5. On Tuesday afternoon, the 8th of December following, the testimony for a new trial of William E. Udderzook commenced. Mr. Perdue said the motion for a new trial rested mainly on the reason that 2 of the jurors had expressed opinions in regard to the murder previous to the trial. Also upon the reason that the court erred in sending the Dr. Steele letter to the jury for examination and comparison. The next subject spoken of by Mr. Perdue was that of permitting photographs to be used in the identification of dead bodies. A little evidence was produced to show that Arnold Nichols, the 12th juror, had expressed an opinion as to the guilt or innocence of Udderzook. Mr. Hayes addressed the court in behalf of the Commonwealth. He spoke disparagingly of the testimony in regard to the statements alleged to have been made by Nichols. He said, "It is a fact that Nichols was accepted as a juror by the defense after he admitted that he expressed an opinion in regard to the guilt or innocence of the prisoner." He continued, "I submit to your honor that, from the testimony, we can find no malevolence in Nichols's statements. It has been shown that he expressed a desire not to be put upon the jury immediately before he was called." Mr. Hayes made a few remarks upon the letters which were sent to the jury, and argued in support of the use of the photographs for the purposes of identification. As soon as the argument on behalf of the Commonwealth was finished, Wayne McVeigh arose and said, "There are 2 questions to be considered in this argument. The first is in the delivery of the letters to the jury on the Sunday upon which the verdict was rendered. If these letters had been given to the jury in the beginning, before they had determined to decide the one way or the other, they would have been much less dangerous than after they had been deliberating for a day and a half or 2 days upon the matter. The court may feel that when the jury ask for these things, they should receive them, but I think this is more dangerous than if they had had them in the beginning. Undue importance would be attached to the slightest trifle, after having deliberated for so long a time without reaching any conclusion. In the jury room, perhaps, an immaterial difference may have arisen, and after hours of wrangling, they agree to ask for testimony which would settle the dispute, and each side agrees to come over to the other in case of its being decided adversely. The letters are taken out, and the opinion of one side upon the immaterial dispute is corroborated, and then the verdict is rendered, having been reached by an artificial bridge. I next speak of the testimony in regard to Arnold Nichols. You have heard the statements of these witnesses, and the denials of them by Nichols. Can your honors hesitate to give the prisoner the benefit of this doubt? You will ask yourselves whether this man, as a juror, answers the requirements of the Constitution and the law. In the selection of the jury we must act hastily, and will necessarily often make mistakes. Nor is there any help for it if, after accepting a man, you find you are misled and that he is unfit. Now we only ask for a jury of fair minds. To that right we are entitled. I know that it is the natural disposition of this world to let things remain as they are, and to take a verdict as final. But I venture to urge, as reasons for setting this verdict aside, the facts in reference to this man Nichols, and I submit to the court whether it is possible to constitute him such a juror as the Constitution prescribes. Upon reconvening of the court on Saturday, the 12th day of December, Judge Butler announced the disposition of the Udderzook case as follows. Commonwealth v. Udderzook. The first and fourth reasons on which the demand for a new trial is founded have been abandoned. The propriety of using the photograph of Goss to aid in his identification under the assumed name of Wilson we do not doubt, nor do we doubt the propriety of granting the request of the jury to see the letter signed by Goss which was in evidence. The testimony relating to Mr. Wilson, one of the jurors, fails to show any expression of opinion previous to the trial, and, in the judgment of the court, is not deserving of further notice. That relating to Mr. Nichols, another juror, does show expressions of opinion, but this is no more than the juror stated when called to the box. It is urged, however, that the language used by him, as testified to by Lewis Powell, shows that this juror did not come to the trial with impartial mind. Without enlarging upon the testimony of Mr. Powell, it is sufficient to say that it did not impress the court favorably as respects the witness himself. His admission on being recalled that Mr. Nichols was intoxicated at the time to which he had previously referred, and his voluntary addition that he was not, "more so, however, than he commonly is," did not seem to indicate an unbiased mind towards the juror. With Mr. Nichols's denial, we do not regard the objectionable expressions as proved. But if this were otherwise, and Mr. Nichols under the influence of liquor at the time, his language might well be regarded as an exaggerated expression of opinion resulting from the excitement of liquor. In the subsequent statement, that he did not believe the prisoner guilty, or did not believe the evidence would convict, and the witness cannot be relied upon for the exact language used, we do not see the evidence of evil mind towards the prisoner suggested by counsel. The judgments of men are very diverse, and it is not improbable that many honest and impartial persons entertain this view. District Attorney Wanger then moved that the judgment and sentence of the court in vindication of the law be passed upon the prisoner. Judge Butler then delivered the sentence as follows. An impartial trial, in which you were prosecuted with fairness and liberality and defended with zeal and ability, has resulted in your conviction of murder in the first degree, and this result is just. That the corpse found in Bear's Woods was that of Winfield Scott Goss is not open to doubt. From the building on the York Road, which was burned to cover the flight of this man, he is traced with unerring certainty to the desolate grave in the woods. Changing his name, and seeking to hide himself, he yet left behind, wherever he went, evidences of identity that preclude all danger of mistake. His striking peculiarity of person, his habit of intemperance, the remarkable ring he wore, his handwriting, parts of his dress left behind, his photograph, recognized wherever he went, and especially his patent screwdriver, exhibited from time to time, his peculiar habit of addressing you by the title of Doctor, and your own graphic description of him to Rhodes, "as a man who had been lost for a long time and was supposed to be dead," enable us to identify Goss in the man called Wilson with as much certainty as if he had worn his proper name. Traced from place to place, a few days before the body was discovered he was seen in the vicinity of Bear's Woods, going in that direction, and was not seen alive thereafter. You, who were there with him, had informed Rhodes, only a few hours before, that the woods was his contemplated destination. When the grave was opened, the same remarkable personal peculiarities of Goss were found in the corpse, the resemblance agreeing in everything, down to the color of the hair, the shape of the whiskers, and the length of the unshaven beard. The ring was gone from the finger, but it was found virtually in your possession, upon the seat of the vehicle in which you had been riding. All his clothes, save the shoes and shirt, had been destroyed, but these remaining articles resembled his so closely that the shoes are virtually identified as the same. They were not only similar in kind, but were peculiarly marked in 2 respects, as his had been. We repeat, with unerring certainty Goss is traced to this grave, and with the same certainty is his murder traced to you. First, it is shown that you had a motive to commit the crime. The success of your schemes, as well as your personal safety, counseled, if they did not demand it. Second, it is shown that you expressed your purpose to do it, at first dimly, as in the letter of December, and afterwards distinctly, as in the conversation with Rhodes. And thirdly, it is shown that you did it. 5 days preceding the event he left the William Penn Hotel in your company. 3 days later he is found in this county, still in your company, manifestly under your influence, passing westward and shunning observation. In the evening of the next day, as night came on, he was again seen in your company, seated by your side in the vehicle procured at Penningtonville, now in the neighborhood of Bear's Woods, and going in that direction. Thus you were with him immediately preceding his death, near to and approaching the place where found. Directly after you were alone, and he was no more seen alive. The vehicle in which you were riding together was broken, the carpeting torn from its floor, the blankets missing, and the floor stained with blood. But a few hours previous you had expressed your purpose to commit the crime, and sought the aid of your brother-in-law in its accomplishment. To the crushing weight of these terrible facts you opposed nothing but an improbable, inconsistent statement, proved to be untrue in some respects, and supported by evidence in none. No rational mind with this knowledge can entertain a doubt of your guilt. And it is not the guilt of an ordinary murder. With full average mind and fair intelligence you entered upon a gigantic scheme of fraud. An element in this scheme was the false assertion of Goss's death supported by fictitious appearances, the creation of your acts, supplemented by your perjury. Possessed of a strong will, you carried this scheme almost to successful accomplishment. When, at length, threatened with discovery, your plans and your personal safety endangered, you resolved to secure yourself by taking the life of your accomplice in this crime. You had known him long and intimately, and were closely connected with him by marriage. You had obtained his confidence, and he seemed to follow your suggestions with unquestioning trust. You dragged his weary feet from place to place, under pretense of seeking an asylum where he might still be secure. At length you reached the neighborhood familiar to your youth, where it might well have been hoped the recollections of that better, purer time in your life would have awakened some spark of tenderness, and arrested your cruel hand. But here, Resolutely and fatally bent on your wicked purpose, as evening faded into night you committed this most horrible of crimes. Leaving your victim for a time, you returned at the solemn hour of midnight, and with the peaceful stars looking down upon you, and the sad appealing eyes gazing up, you carved and quartered him as if he were a dog, spending the night in a futile effort to cover up the evidence of your guilt. Then, visiting your aged mother, you returned to your wife and children, with as little apparent concern as a man returns from a journey of pleasure. The long record of crime scarce furnishes a parallel to this case. These things are not said to increase the misery of your present situation, but to vindicate the sentence which the law is about to pronounce. Nor are they said without sorrow, for we are not unmindful that human justice is imperfect, that the weakness of your moral nature and the force of your temptation cannot enter into its judgment, that they will be considered and justly weighed in the balance by him who knows the secret troubles of the soul, whose justice is perfect, and whose mercy is boundless, we cannot doubt. The 3 judges here arose, and the sentence proper was given as follows. The court does now order and adjudge that you, William E. Udderzook, be removed hence to the prison from whence you came, and there be closely confined until such a day as the governor may appoint, then you shall be taken from thence, and hanged by the neck until you are dead. May God have mercy on your soul. During the passing of the sentence, Judge Butler was very much moved, showing how keenly he felt the terrible importance of so unpleasant a duty, and when he had finished, he reclined back in his chair, and placing his hands over his eyes, so remained for several minutes. Udderzook, throughout the trying ordeal, changed some little in color, and showed some nervousness, but when the sentence was concluded, he, at the direction of Mr. Perdue, took his seat in an orderly manner, with not a tear or show of fear evident. After the sentence was delivered, the judge ordered the sheriff to take the prisoner back to jail. 6. The counsel for the defendant had taken a great number of exceptions during the trial, but not one of them was ultimately sustained. On July 2, 1874, the Supreme Court of Pennsylvania, sitting en banc, affirmed the sentence of death. Chief Justice Agnew delivered the opinion, which is of special interest, covering as it does the question upon the admissibility of photographs in evidence. William E. Udderzook versus the Commonwealth. Error to the Court of Oyer and Terminer of Chester County. Eastern District. Opinion of the Court. Agnew, Chief Justice. This is indeed a strange case, a combination by 2 to cheat insurance companies, and a murder of one by the other to reap the fruit of the fraud. The great question in the case was the identity of A.C. Wilson as W.S. Goss. This is established by a variety of circumstances and many witnesses, leaving no doubt that Goss and Wilson were the same person, and that the body found in Bear's Woods was that of Goss. All the bills of exceptions, except one, relate to this question of identity, the most material relating to the use of a photograph of Goss. This photograph, taken in Baltimore on the same plate with a gentleman named Langley, was thereby proved by him, and also the artist who took it. Many objections were made to the use of this photograph, the chief being to identify Wilson as Goss, the prisoner's counsel regarding this use of it as certainly incompetent. That a portrait or a miniature painting from life, and proved to resemble the person, may be used to identify him, cannot be doubted, though, like all other evidences of identity, it is open to disproof or doubt, and must be determined by the jury. There seems to be no reason why a photograph, proved to be taken from life and to resemble the person photographed, should not fill the same measure of evidence. It is true that the photographs we see are not the original likeness, and their lines are not traced by the hands of the artist, nor can the artist be called to testify that he faithfully lined the portrait. They are but paper copies taken from the original plate called the negative, made sensitive by chemicals and printed upon by sunlight through the camera. It is a result of art guided by certain principles of science. In the case before us, such a photograph of the man Goss was presented to a witness who had never seen him, so far as he knew, but who had seen a man known to him as Wilson. The purpose was to show that Goss and Wilson were one and the same person. It is evident that competency of the evidence in such a case depends upon the reliability of the photograph as a work of art, and this, in the case before us, in which no proof was made by experts of this reliability, must depend upon the judicial cognizance we may take of photographs as an established means of producing a correct likeness. The Daguerrean process was first given to the world in 1839. It was soon followed by photography, of which we have had nearly a generation's experience. It has become a customary and a common mode of taking and preserving views, as well as the likenesses of persons, and has obtained universal assent to the correctness of its delineations. We know that its principles are derived from science, that the images on the plate, worked by the rays of light through the camera, were dependent on the same general laws which produce the images of outward forms upon the retina through the lens of the eye. The process has become one in general use, so common we cannot refuse to take judicial cognizance of it as a proper means of producing correct likenesses. But, happily, the proof of identity in this case is not dependent on the photograph alone. Letters from Wilson, identified as the handwriting of Goss, a peculiar ring belonging to Goss, worn upon the finger of Wilson, the recognition by Wilson of A.C. Goss as his brother, packages addressed to A.C. Goss, and envelopes bearing the marks of the firm with which W.S. Goss had been employed, coming and going to and from Baltimore, and many other circumstances following up the man Wilson, leave no doubt of his identity as Goss, independent of the photographer. The objection to the proof of Goss's habits of intoxication is equally untenable. True, the habit is common to many, and alone would have little weight, but habits are a means of identification, though with strength in proportion to their peculiarity. The weight of the habit was a matter for the jury. It is unnecessary to follow the bill of exceptions in detail. They all relate to the facts and circumstances bearing on the question of identity. If the bills of exceptions are many, they only denote that the circumstances were numerous, and in this multiplication consists the strength of the proof. They are many links in a chain so long it encircled the prisoner in a double fold. There was no error in permitting the jury, after their return into the court for further instructions, to take out with them, at their own request, the letter, check, due bill, and applications for insurance, papers which had been proved, read in evidence, and commented on in the trial. The appearance, contents, and handwriting of the documents were, no doubt, important to be inspected by the jury, who could not be expected to carry all these features in their minds. It is customary in murder cases to permit the jury to take out, for their examination, the clothing worn by the deceased, exhibiting its condition, the rent made in it, the instrument of death, and all things proved and given in evidence bearing on the commission of the offense. We discern no error in this record, and therefore affirm the sentence and judgment of the court below, and order this record to be remitted for execution. 7. Strenuous efforts were now made by the counsel and immediate friends of the prisoner to obtain a pardon or a commutation of sentence. A hearing upon this took place before the Board of Pardons, in Harrisburg, Pennsylvania, on the 8th of October, 1874. The result was unfavorable to the petitioner, and a few days afterwards, Joseph F. Perdue, Esquire, one of the counsel for Udderzook, received the following letter from Governor Hartranft. Executive Chamber, Harrisburg, October 12, 1874. Joseph F. Perdue, Esquire, Westchester, Pennsylvania. Dear Sir, after careful consideration of the facts in the case of William E. Udderzook, I believe it to be my duty to issue the warrant for execution. I am yours, with great respect, J. F. Hartranft. Upon receipt of this letter, Mr. Perdue immediately proceeded to the jail to acquaint the prisoner, accompanied by 2 other gentlemen whom he had requested to go with him. Upon entering the cell of the wretched man, Udderzook read at a glance, in the countenance of his counsel, that the mission was of a serious character, and taking him by the arm, he led him to the farthest corner of the cell, and asked, "Have you my death warrant?" Mr. Perdue replied that he had not, but he had what was substantially the same thing, and then read to him the letter from the governor. At the conclusion of the reading, Udderzook expressed his disapproval of the action of the Board of Pardons, and also of that of the lower court in not granting him a new trial. "But," said he, straightening himself up and assuming an air of injured innocence, "they have all the way long thirsted, plotted for my life, and now they can have it." He said to Mr. Perdue that he had been well and ably defended, and gave his hand to attest his feeling of the truthfulness and sincerity of his remark. In the afternoon succeeding this interview with his counsel, the aged mother of the prisoner appeared at the jail, and upon her solicitation was shown to the cell of her unhappy son. The interview was a protracted one, and the scene is said to have been most pathetic. The death warrant soon followed, and was read to Udderzook in his cell by the sheriff, in the presence of the prisoner's counsel, the district attorney, and several other gentlemen. The warrant required David Gill, High Sheriff of the County of Chester, to cause the sentence of the court to be executed upon Udderzook between the hours of 10 o'clock in the forenoon and 3 in the afternoon of Thursday, the 12th day of November, 1874. During the reading, the prisoner stood with bowed head and clasped hands, and listened with seeming attentiveness. When the sheriff had concluded, that officer remarked to the doomed man, "I hope you'll be prepared," to which the prisoner replied, "You said the 12th of next month?" And the sheriff responded, "Yes." "That," said Udderzook, "is just 4 weeks from today. I am thankful I have that much time given me to prepare. If any of you were in my situation, you would think this time very short, but I am thankful it is so long, thankful that I am granted sufficient time to prepare for the worst. I suppose those who busied themselves in working against me thought they were discharging their duty. They may have been. The governor, I suppose, thought he did his duty. Also the officers of the Supreme Court of the state, and the court that tried me here, and the Commonwealth's officers, and the insurance agents. All thought they were performing acts such as their duties demanded. There were some things done falsely, but I hold no malice towards anyone. I forgive them all. It is not probable these were the exact words used by Udderzook, for he was incapable of expressing himself so concisely. But they, no doubt, faithfully express the ideas he intended to convey, although dressed in the words of one of his auditors. During the 4 weeks intervening between the reception of his death warrant and his execution, Udderzook busied himself in writing, but destroyed his manuscripts without making public their contents. He wrote letters to every member of his family, and expressed a desire to make a speech upon the scaffold, but from this he was dissuaded. One of his letters written for publication, dated October 19th, 1874, and addressed "To the world and my loved ones," appeared in the newspapers of that date. In that letter he says, correcting some errors of orthography, "It is my desire that my remains will rest in Baltimore, if not in the same lot, at least in the same cemetery with those of Mr. W.S. Goss, a friend ever dear to me, that our bodies may return to the mother dust, and our spirits may mingle together on the bright, sunny banks of deliverance, where pleasures never end. I hope the time is not far distant when the people will see the danger of prepared and bought testimony, and a prearranged design aided by thousands of dollars. He reiterates his innocence, and intimates to his readers an obscure prophetic alarm as to what the insurance companies will do. The execution of the murderer was consummated shortly after noon on the 12th day of November, 1874. It was attended with the least possible ceremony, everything being conducted by Sheriff Gill, decently and in order. Udderzook made no allusion to his guilt or innocence while upon the scaffold, nor did he appear disconcerted to any noticeable extent. He died manifesting the same spirit of arrogance that had been so conspicuous in him from the night of the fire on the York Road. End of section 44.
Section 45 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies. An authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Homicide, Part 22, Angie Stewart, the Murdered Child, Part 1. On the evening of December 5th, 1867, a fire broke out in the basement of a frame dwelling house in the village of Canaan, Columbia County, New York. As other dwellings were in close proximity, the neighbors hastened to the burning building in response to the alarm. The house was unoccupied, excepting the basement story, which had been rented temporarily to a man known as Joseph Brown, a painter by trade, who recently had arrived in the village and who was accompanied by a woman, Josephine, whom he called his wife, and a little girl, Angie, whom he called his daughter. The fire was subdued quickly, having been confined principally to the basement pantry, where it had been smoldering some time before discovery. All of the outside doors of the house were found to be locked, and upon effecting a forced entrance into the basement kitchen, the neighbors found the pantry door tightly closed. After getting it opened and extinguishing the fire therein, the dead body of little Angie was discovered underneath the pile of partially burned rubbish. Brown and his wife were absent at a neighboring house at the time and did not reach the scene of the fire until after the charred remains of the little girl had been recovered and the fire wholly extinguished. The attendant circumstances were so questionable as to give rise to startling rumors, but these finally quieted down, and the superficially conducted inquest of the coroner gave credence to a generally accepted theory that the child, while temporarily left alone in the house, had attempted to fill a lighted kerosene oil lamp, which had exploded and caused her death by burning. The following certificate was published soon after the occurrence, and was sufficient to divest the affair of any degree of public interest beyond that of short-lived pity for poor little Angie. Canaan, New York, December 6, 1867. This is to certify that I have this day examined the body of Angie Brown, by order of the coroner of this county, Columbia, and find that she came to her death by reason of fire communicated to her clothing and other combustible matter to me unknown, which fire was sufficient to cause her death. Azariah Judson, M.D. But the matter was destined not to rest here. Brown caused the child's remains to be boxed up for burial and removed to Granby, Connecticut, the place of his wife's former home. In company with his wife, he left Canaan for Granby, stopping en route in Westfield, Massachusetts, where they visited a lawyer's office and made up formal and affirmative proofs of loss under an accident insurance policy, and forwarded their claim by mail to the Travelers Insurance Company. It appeared that the child had been insured against death by accident in the sum of $5,000 for the benefit of Joseph Brown, the insurance being for the term of 3 months, and was written at the Cleveland, Ohio agency of the company under date of September 19, 1867. The mysterious circumstances surrounding the child's death were recalled under the light of this claim to recover the insurance, and the company, having its attention directed to the affair, was not slow to investigate it. It was ascertained that Brown had come from Dayton, Ohio, where he was known as Joseph Barney, and the woman as his wife, Josephine Barney. They had lived in Dayton several months, where Barney, alias Brown, had worked at his trade, that of painter. It was further learned that the little girl Angie was the daughter of a Mrs. Stewart, a respectable widow, residing in Dayton, and that the Barneys had obtained possession of the child on the 17th of September, with the consent of Mrs. Stewart, for the purpose of accompanying Mrs. Barney on a trip to Connecticut and return. Taking Angie Stewart with them, the Barneys went from Dayton to Cleveland, where they obtained insurance under the name of Brown upon Josephine and Angie in the sum of $5,000 each. Thence they went to Canaan, New York, where they boarded for a while, and there rented the basement story of the house wherein the fire was discovered shortly afterwards, as has been related. Further developments and revelations led to the arrest of Brown and his wife, who were brought from Granby to Hartford and lodged in jail. Subsequently, on a requisition from the governor of New York, they were taken to Hudson, where bills of indictment were found against Brown for the double crime of arson and murder, and his trial was fixed for the April term of court. The trial of Joseph Brown commenced April 13, 1868, and the first witness called was Mrs. Mary H. Stewart, who testified that she resided in Dayton, Ohio, and that she was the mother of Angeline Stewart, whose age was 12 years. Witness recognized the prisoner at the bar and his wife, having known them in Dayton for a period of 5 or 6 months, as Joseph and Josephine Barney. They left the house of witness in Dayton on the 17th of September, taking Angie with them. They said they were going to Cleveland first, where they would purchase a suit of clothes for Josephine and Angie each. After remaining in Cleveland a few days, they were then going to New York. Barney said he was going to seek work and would return to Dayton after being absent 3 weeks, while Josephine was going on to Hartford with Angie. But if Angie should become homesick, he would bring her back to witness when he returned. It was further agreed with Barney that, upon his return to Dayton, and until his wife's return, he was to board with witness. Josephine was intending to take another little girl instead of Angie, but that girl was taken sick, and then the Barneys pressed urgently for Angie, saying she would be back in a short time. After much entreaty, witness consented, little thinking it would be as it is. On cross-examination, Mrs. Stewart further testified that the Barneys wanted Angie to call them father and mother, saying they thought it would be nice in traveling. Witness told them the girl was too old to call them father and mother, but finally consented to their request, though she did not tell the child to so call them. They did not speak of adopting Angie. Mrs. Barney represented to witness that she wanted her as a companion, saying that men sometimes were uncivil to a woman traveling alone, and with the child accompanying her, people would know she was married. When speaking of their return from their Eastern trip, the Barneys said to witness, "Mother, when we come back, we will keep the house for you, and keep it well, too." The testimony of the succeeding witnesses occupied several days and was comprehensive and conclusive. It was shown that when Brown left the house to rejoin his wife, who had gone to make a neighborly call in conformity with their arrangements, he locked the outer doors, that the door of the pantry in which the child's body was discovered opened outwardly and adhered at the bottom, and that it could not have been pulled tightly shut, as it was found, from the inside, that as the thin dress she wore, which was minutely described, was insufficient for combustion. Other materials, obtained by splitting the shelving of the pantry, remnants of which were found, were added, and these had been saturated apparently with the inflammable fluids with which painters are familiar. That voluntary imprisonment in the form and manner as described, in which little Angie was found, was impossible. That if her dress had taken fire from the explosion of a lighted lamp while refilling it, the natural impulse to scream for aid and, if possible, to escape from the building would have been demonstrated itself in an obvious way, and that the lamp theory was disproved by the fact that Angie had been using a candle. Her young friend, Harriet Silvernail, who lived in the next house, called in between 6:30 and 7 o'clock in the evening to invite her to go to a prayer meeting. Angie was eating her supper, and a candle, about half consumed, which attracted Harriet's observation, was burning on the table. Angie excused herself from going to meeting on the plea that her father and mother were going away. That was the last interview with anyone but her murderers. Early in the investigation of this case, the charred remains were exhumed and carefully examined by 3 physicians who, in their evidence during the trial, concurred in the opinion that death took place before fire was applied to the body. This opinion was based mainly upon the appearance of the trachea or windpipe and the upper portion of the lungs, which were found to be free from the evidences of irritation which would have existed if the child had respired heated air. The body appeared to have been burned while in a sitting position upon the floor, the seat being the only portion unburned. The skin covering this unburned portion was found to be in a perfectly natural condition, while the partially burned clothing and remains gave a strong and unmistakable odor of turpentine. It was also in evidence that, upon the announcement of the tragic fate of Angie to Brown and his wife by their neighbors, Mrs. Brown could not conceal her brutal indifference, while the cold and cruel-hearted Brown's attempt to faint without pallor of countenance and his pretense of emotion was so ineffectual as to provoke comments of incredulity and displeasure. Dr. Judson, who keenly pitied them, was obliged to say that he saw no manifestations of grief, no tears shed. It was shown, too, that in conversations with their acquaintances, the insurance idea was uppermost in their minds. Mrs. Provost, for instance, testified, "Josephine said she could get my life insured, or anything I had, and I would be none the wiser. And if I should die, she could get the insurance money in spite of anybody." Josephine was free to declare that she herself had been insured, but cautiously concealed the fact of the simultaneous insurance of Angie. Moreover, it was shown that their purpose was to invest the sum, to be fraudulently obtained, in the purchase of a farm, and that Brown was already negotiating with Mr. Buell for such purchase. Brown offered Buell $5,000 for his farm, and said to the witness he would show the people of Canaan that he would have the money. Josephine playfully boxed his ears and said, "Yes, maybe $10,000. He also had been in conference with Mr. Williams, proprietor of a hotel in Canaan, about buying that place. Mr. Williams fixed the price at $3,000 and told Brown that he would make the payments easy. In reply, Brown said that, if he bought, he would pay all cash." It is also worthwhile to recur to a portion of the testimony of the Hartford Lieutenant of Police, who dispatched an officer for the arrest of the Browns, and who said that they were brought to the station house in Hartford and placed in different cells. That night, while they were in their cells, he heard a conversation going on between them, of which he made a memorandum in writing at the time, as follows: "Joe, everybody has gone home, and it is almost light. I told the officers all I knew about the child. Brown said, 'You had better go to sleep and not say another word till after we have sent for a lawyer.' She said, 'Jeffrey Phelps will be here in the morning. I told the officer I first saw the child in Dayton. Now remember that, and that you were in the country at the time, that you had been the father of 2 children, and one had died, and that you were a kind father.' Brown said, 'You keep still till we see a lawyer. Go to sleep now.' She said, 'I can't, but I'll try. I told him you kept those policies in that coat pocket, the coat you had on in Westfield, the coat you bought in Ohio. Do you understand?' Brown said, 'Yes.' She said, 'Well, remember.' At this stage of the conversation, the lieutenant interrupted her and told her to stop talking, or he would place her in a dark cell. The lieutenant subsequently had a long interview with Brown, and the conversation was fully reported and read in court. Brown's answers to questions propounded proved to be a tissue of falsehoods. He said, for instance, that he left a former wife, whom he represented as Angie's mother, in Canada because of her habitual intoxication, and that she afterwards died in Montreal. Probably the only truthful remark he made was, upon realizing his situation, "I have told the insurance company that I would give them the policy if they would let me go." The defense was unable to produce any evidence to satisfactorily explain away the fearful position in which Brown had been placed by the prosecution. The learned and able counsel for the prisoner did the best that could be done with the slender materials at his command. Mrs. Lydia Fox was called to say that she resided in Granby, Connecticut, and was the mother of Mrs. Josephine Brown, who was married to the prisoner 2 years previously, and that she never knew of their going by any other name than that of Brown. On cross-examination, it appeared that she had no knowledge of their marriage, other than that she had seen an announcement of such marriage in some newspaper, and that she had never seen Brown until the time he came to Granby with Josephine, for the purpose of interring the remains of Angie. Furthermore, a letter from Mrs. Fox to Josephine was produced, wherein it appeared that the witness had heard Josephine was not married to Brown. Mr. Drown, called by the defense, said that Brown worked for him on the forenoon of the day of the fire, quit about 12 o'clock, and quit because he had finished his job of work. A few witnesses were interrogated with an effort to show that the alleged fainting fit of Brown was real and not feigned, that the heap of charred rubbish found upon the dead body of the child was occasioned by knocking down the pantry partition, and that the pantry door which swung into the kitchen was not difficult to open, although it had settled from the top, and only by pushing hard or by putting the foot against it at the bottom would it crowd shut. The learned counsel then addressed the jury in behalf of the prisoner, going over the evidence in detail and at great length. He assailed the evidence of the medical experts who had testified, devoting much time to show that it had not been proved that the child was dead before burning. He called the jury's attention to the fact that there was plenty of evidence to explain the death of the child upon the idea that she had set herself on fire accidentally, by some mysterious means. She had a light, she had explosive materials, every requisite for the production of the effects which were produced. He remarked that much had been said by the district attorney in his opening statement about the motive of Brown to commit murder. Brown had a policy of insurance upon Angie's life for $5,000, which he supposed would come to him in case of death. But if he had such an idea, it was a mistaken one. He had no insurable interest in the child, and the insurance was, of course, null and void. Motives, said the counsel, exist in regard to everything. No man does anything without motive, and the only motive established here was that Brown, perhaps, believed at the time he took the policy that he would reap the benefit in case of Angie's death. Motives are always looked for, because you cannot ordinarily convict without a motive. It is unreasonable to suppose that a person in sound mind will commit homicide without a motive. It does not follow, because there is a possible motive found, that the person did actually commit the homicide. You must have proof to convict Joseph Brown, as though there was entire absence of motive for the crime. End of section 45. Section 46 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies. An authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Homicide, Part 23, Angie Stewart, The Murdered Child, Part 2. Attorney General Champlain followed in an able argument from which we select the following striking paragraphs. The learned counsel has been pleased to refer to the subject of motive. What is the theory of the motive? The child was obtained for the purpose of procuring insurance upon her life. She was carried to a remote and comparatively secluded place with a view of securing this money. If the motive existed, a predetermined purpose to perpetrate this crime must have existed, because the instant the motive fails, then the crime is dismissed with it. And the instant you determine by the proof in the case a motive is established, it ceases to be the motive unless coupled with the design. By taking the child's life and obtaining the money, the motive reflects upon the intention upon the motive. Both throw a perspective light forward and back to the period when the crime was committed, and tend to demonstrate its actual commission. Go with me to Dayton and trace the history of these people and see if there is a motive. These persons are poor. They are traveling from place to place. Cast hither and thither, why do they seek to adopt a child? We know that persons of affectionate disposition and in affluent circumstances, persons of kind hearts, often adopt children and incorporate them into their families. Here are persons whom counsel tells you are driven from pillar to post. Why should they adopt and add additional burden to their expense? It was not their purpose to incorporate anyone into their family permanently, and the idea that they intended to add anyone to their household is dismissed by the fact of their shifting so suddenly from the child they first intended to take. You recollect another child had been selected, and money sent by the Browns with which to furnish some article of apparel. The money was returned with the word that the girl was sick and could not accompany them. And in one instant, they shift to this little child of Mrs. Stewart. It was not affection. It was not love for the first child they intended to take. It was policy. It was for some purpose as yet perhaps undeveloped. In an instant, it is arranged that this child, Angie, is to go and take the place of the one they had intended to take. Let us view the arrangement under which the child is taken. The story of the man is that he is going on with his family, and that his wife is to remain at her mother's in Connecticut for 3 months. He is to be gone 2 or 3 weeks and then return. If the child is homesick, he is to bring it back with him. He says, "Mother, I will come back and keep house with you, and keep it well too." He laid out the precise arrangement under which he received the child from Mrs. Stewart. They took the child under the arrangement. They are to write back, and if the girl is homesick, she is to be returned in 3 weeks. And if not homesick, she is to remain with Mrs. Brown for 3 months. You will remember the awkward excuse as the reason. That a lady traveling upon the cars is liable to insult, and that if a child were along, people would see she was a married woman. After having compromised Mrs. Stewart sufficiently to gain her consent to the child's going along, they present themselves at Cleveland. And where is the first place you hear of them? At an insurance office. What are they there for? To insure the life of the child for $5,000. How do they insure her? As their daughter. The woman, Josephine, signs the application, and it was done in the husband's presence as he did not write. They represent to the insurance agent that Mr. Brown is to remain there, and the wife and daughter are to travel, that he wants insurance for 3 months. Why did he take the insurance upon the wife? It was to elude suspicion then and there. If he had come there to insure the life of his child and said that the child was to travel, an inquiry would have been instituted, and he would have had to acknowledge it was to travel with its mother, and the question would have arisen, why not insure the mother? She was to be exposed to the same dangers as the child, and to lull that agent into security, he was obliged to take an insurance upon the life of his wife. He obtains this insurance under a false statement of facts. From the hour he left Dayton, he commenced obliterating his tracks. He had agreed to write to Angie's mother, but in order to carry out this plot, he wished to cut off all communication between the child and mother, and if the plot was consummated, in the future no trace would be given by which she could find her child. While Mrs. Stewart knew them only as Mr. and Mrs. Barney, the insurance had been obtained in the name of Brown, and they thereby destroyed the probability of tracing them. They stop at Canaan. They there rent a house for a month. Perhaps that is well enough as an experiment, but it proves the transitory character of their purposes. It proves that they have but alighted in this village. They hold themselves in readiness for an early departure. They lived there until December, and now here is this couple, poor and penniless, birds of passage, resting for a short period in this place and that, brought up at length in this village. He has house, lodging, and abundance of work, and yet, in the dark days of December, as the winter is descending from the north, you find these people making all the preparations for another departure. They are about to leave this village, never to return. We will show by the circumstances which surround this case what the purpose was for which they entered upon this plot. A box is dispatched by express to Granby, Connecticut. It contains more or less of the clothing of the wife, some of the prisoners, and some other articles. What else do we see? We find that, on the morning of the day of the fire, this woman in full dress takes the cars and goes from Canaan to Chatham. Where is her husband? At work at Drowns. His job is finished at noon. He is seen to go into his house with his painter's clothes on, and to come out with his good clothes on. He goes around to one of the shops and talks about gold leaf, and about procuring some to paint slaves. Where is his job of work upon slaves? Mark this, for it tends to show a lie. We must proceed cautiously and exercise our circumspection, and weigh it well, and see if we can fathom his motive and design. In the evening his wife comes, and he meets her at the railway station. They go home and there eat supper. The little girl is at supper with them and in good health. Sometime during the evening this woman leaves the house, going away alone. And every person knows that when these people left that house, they had left it forever. They never intended to live there anymore. As a habitation for them, they had turned their back upon it for the last time. The woman was the first to go, and the prisoner was the last person to leave that house alive. Before proceeding with the history of this extraordinary case, there are circumstances to which I will call attention. I have said the motive was inseparably connected with the intention, and vice versa. Now, note the conversation in the presence of Edna Williams. Brown had been negotiating for the purchase of the Beau farm, for which the sum of $5,000 is asked. Brown says, "I will show the people of Canaan I will have $5,000 in money." And his wife then playfully cuffed his ears and said, "Yes, Joe, and maybe $10,000. Then the conversation about buying the hotel. He was not particular as to time. He would pay money down. These transactions are coupled inseparably with the obtaining of the child, and the whole history of this matter, down to the present time. This woman talks to Mrs. Provost, and dilates upon the subject of insurance, telling her that her own life is insured, that one could insure anybody's life, and get the money when death occurred. It shows what was the all-absorbing thought that was reveling in their minds. And did you notice how, with a woman's subtlety, she omitted to mention the fact that the life of the little girl was insured? After reviewing other points to show the connection between the motive and the purpose, the Attorney General continued thus. If you follow up the evidence, you will see from this instant these parties entered upon another course, which always indicates crime. We have traced them as to the motive and intention as gathered from their acts, and we will show you that they entered upon a concealment of the crime from the instant of its occurrence. Pretense is made that this child is his own, that it is flesh of his flesh, blood of his blood. Why does he say this? There is an awful significance in the pertinacity with which this man and woman clung together before the people of Canaan, and pretended that this man was the father of the child. When Brown took the remains of the little girl in that box, and delivered them to that old gray-haired sexton, that secret would have been buried with that child. But the rampart of innocence with which he had surrounded himself was broken down. So long as he could keep people impressed with the belief that this was his child, he was safe. He knew that nature, and nature's God, would abhor such a crime. That is why he told Mr. Batterson that she was his child, and that the mother was a drunken woman whom he had left in consequence of her pernicious habits, and that she had died in Canada long since. He was bound to impress people that he was the real father, and then suspicion would sleep. He felt that the tide of generous sympathy would flow, and they would believe his innocence. The Attorney General then commented with deserved severity upon the indecent haste with which the wretches applied for the insurance money, before the burial of the child, and their deliberate perjury in the affidavits taken before their attorney in Westfield, Massachusetts, when making up the preliminary proofs under the insurance policy. After a scathing comment upon their purpose to conceal the crime, as manifested by their conduct and conversation while in jail at Hartford, he proceeded. We brought him back to Canaan, and towards him, at every step of the pathway, is shed back from this fire a reflected glow of guilt. Let me call attention to a few of the surrounding circumstances, in the order in which they occur upon the night of the fire. This woman first goes to Williams's for a neighborly call. She states that her husband came with her, but had stopped at the door to talk with a man. That is shown to be false by his own confession to Packard. They had never visited at Williams's before. She had called simply on errands. Presently this man presents himself in a hurried manner, and remains in the room with the woman. Now an alarm is heard. Mr. Drown was at the fire at the first alarm, and, with the neighbors, tried the front door, and finally broke it in, and tore down the pantry partition. Where is Brown? After the dead body had been discovered and placed upon a blanket outside of the house, after the fire was extinguished and everything concluded, Brown is seen coming towards the house. View his actions when he reaches the place. He rushes into the house in the direction of the pantry where this body has been found. No needle ever pointed more unerringly to the pole than this man, thrown off his guard, pointed to the place where he knew these remains had been deposited. In the east end of this pantry, what do you find? We will not consider this case upon what was not seen, but upon what is proved. There was found a pile of charred coal, from 12 to 18 inches deep. The heap is measured, and found to contain 8 bushels, and under that pile is found the charred remains of the little girl. The outer door is locked, and the key is gone. The inner door is fastened. The door was tried 3 times, and an axe finally was brought into requisition. In that pile are unburned pieces of kindling wood. The prisoner, speaking through his counsel, says, "This is an accidental death. The lamp has exploded. It is easily explained." Miss Silvernail swears that a candle was in use that night. Which do you believe? The lamp is found with its top tightly screwed on. Now bring into the jury box your experience and knowledge of the analogy of things. Suppose she had undertaken to fill this lamp, that it had taken fire. What would she have done? The testimony is that her clothes were light, a thin calico dress. With a child's impulse, she would have shrieked for help. Apply your common sense and judgment. It is human nature to call for help. No cry is heard, although a house is within 27 feet of this place. To what extent was the child's body burned? In your mind's eye, bring it before you. 1/2 of the head burned off, face entirely disfigured, the jaw easily mashed between the thumb and finger, arms burned off, one lower limb gone, the liver baked. How was this body thus burned? The counsel and the accused come with the theory that it was the explosion of the lamp, the clothes taking fire, and then the child was buried and burned in this heap, and burned in the manner which had been described in the report of the autopsy. What an awful, concentrated heat must have been applied to that body, to bake it as it was. Where were the pantry shelves? But 1 or 2 shelves were left upon the west end, while 3 sides of the pantry had been shelved. Where were the missing ones? It shows human agency there. Whose hand removed those shelves? Where did this pile of charred coals and kindlings come from? These are questions you cannot shake off under the eloquence of the council today. The pantry door was fastened. I care not how. Beale swears that the door would catch at the bottom and was loose at the top. Who fastened it? Human agency again. Who was the architect of this ruin? Was it the child? Need she hold up those handless stumps to say it was not she? The murderer cut the shelves and piled up the faggots. Closing the pantry door, he fled from the house through the cellar door, and betaking himself away with all he possessed in the world, awaited the catastrophe. Counsel thinks it strange this fire was so long in kindling. Mrs. Gordimer passed close to this building. It was dark, and she saw an uneven, flickering light. The pantry window was of only 3 panes, and dirty at that. The rain had spattered the dirt up upon the window, and that obscured the light. The front part of the house was all shrouded in darkness. Why did not the fire burn? The pantry door was closed, walls upon 3 sides, plaster ceiling overhead. The fire was smothered and the room filled with smoke. The fire struggled, and he who holds the elements in his hand would not permit the flame to do the atrocious work it was intended to do. The very means the murderer took to conceal his crime was the instrument of his detection. The bottoms of the shelves were charred. The edges of the cloth were burned, showing fire had been built in the room. These are facts, not doubts. The last link is complete in the adamantine chain that will drag this man to the scaffold. Whether the remains of the dead are dug up, even if 40 or 50 years have transpired, if but a handful of ashes can be found, and there is a suspicion that the deceased died by poison, the learned men of their profession will take those ashes to the laboratory, and they will demonstrate to you the fact, if poison there exists. Let us look at this body. The autopsy describes its condition. In all the affairs of life, we are compelled to act upon the opinion of professional men. Society would not exist unless we could do so. Here are physicians who give it as their opinion that death ensued before the fire occurred. They have given you the reasons upon which this opinion is based. Every fact in this case, every attempt at concealment of the crime, every intention so far as declared, furnishes the most irrefragable proof that the testimony given by these physicians is true. End of section 46. Section 47 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies. An authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Homicide, Part 24, Angie Stewart, The Murdered Child, Part 3. In the calm and dispassionate charge of Judge Peckham to the jury, some of the points thus passed in review were presented with additional emphasis. From the closing portions of this charge, we extract a few paragraphs. On the night of this fire, the prisoner and his wife were found at the dwelling of Mr. Williams, about 50 rods from their house. She arrived a little prior to his coming. He follows a few moments afterwards and, as the girl says, came in on a run. They remained there, where they never had visited before, up to and after the time the cry of fire is raised. And then they start for the fire, and the prisoner arrives after it is all over with, after the fire was put out, after the body was discovered, taken outside, placed upon a blanket, and covered up. After he gets there, he inquires where his child is, as the witnesses say on one side, and I am not aware that there is any contradiction on that subject. And he leaned over backward, apparently fainting. From Brown's manner, a suspicion was excited that there was something wrong. Beale says he had suspicion of the genuineness of the fainting, and drew his supporting arm away, and the moment he did so, Brown clenched hold of him by the collar, to avoid falling. It is for you to say how much there was of fainting in that, and if he actually did faint, why did he do it? If he was an entirely innocent man and the child was not his own, why did he feign fainting? Did this man deem it proper to feign fainting for the death of another child than his own? And for what purpose? Then it is said the door was found locked. And why? Why is that outside door locked? This little girl, 12 years old, was at home engaged in ironing, the day of the fire. What necessity for the outside door being locked? There were neighbors living in the immediate vicinity. Only 20 feet off a neighbor lived, and all around were houses. Why was the door locked, and who locked it? The prisoner had just left the house, it is conceded. Why did he lock the door when he left it? It is assumed on the part of the prosecution that if anyone came to the door too early and sought admission, he would suppose the family had gone away and would go off. If the doors were left unlocked and the fire too soon discovered, why then, if the child were murdered, the crime would be discovered? Then again, not only was the outside door locked, but the next door, the pantry door, was fastened. Why was that? There is one circumstance to which I deem it important to call your attention, in reference to that inner door, although it has been alluded to by both counsel. Why was that pantry door fastened? Somebody fastened that door. That is to say, somebody put it in that shape so that it would stay fastened. Ordinarily, the door would not stay shut at all unless the foot was put against it and jammed it to. You could not do so on the inside. In order to make it stay shut, one had to be on the outside and put the foot against it. Did the little girl shut it? Could she so fasten it from the inside? If she did not do it, gentlemen, who did? No matter for what purpose, who did it? The prisoner was the last man who went out of that house. Did he put his foot against that pantry door and press it to before he left that house? Then another fact, gentlemen, and this fact you must answer by your verdict. The little girl, I apprehend, could hardly have put that door to under such circumstances. If she did not do it, who did? If the prisoner did, for what purpose did he fasten her in that place? And was she alive when she was fastened in there? Then, gentlemen, another fact. This child is found in the east end of that pantry, which is about 3 or 4 feet in width, and the same in length, under an amount of rubbish constituting, when put in a measure and measured, 8 bushels. There is no claim of anything having been put in there, except the rubbish consequent upon the fall of plastering, which accumulated from the knocking of a hole into the ceiling above. This plaster ceiling was but 1/4 of an inch in thickness, and as the witnesses say, this hole was made only for the express purpose of ascertaining whether fire existed in the wall. And considering this circumstance, you will judge how much debris would naturally fall down. How was it that this little girl was found under that rubbish, so that they dug with an axe for some 3 or 4 minutes before they discovered the body? How is that? Mr. Beale, who carefully examined the mass at the time, says he saw pieces of pine board partly charred, some ashes, small bits of lath. Where did all this come from? Why was it there? and who put it there. The window lights were up as high as a man could conveniently reach, and there under them, directly in front of the window, was this burning mass and the little girl beneath it. If she was covered up with these materials, it is quite clear, I may say, she did not cover herself up. In addition to this state of facts is the evidence of the physicians. 3 doctors have reasons, which they consider satisfactory, for stating that, in their judgment, the child was dead before burning. All 3 agree in that as a matter of science, giving as their opinion based upon science, examination, and experience that the child was dead, beyond doubt, before she was burned. The jury, after a lengthy consultation, found a verdict of guilty, and the court was convened to receive it. The usual forms being complied with, and the usual questions put to the prisoner, who gave his age as 42 years, the judge asked, "Have you anything to say why the sentence of the law should not be passed upon you?" Brown replied, "Yes, sir. I am not guilty of the crime I am accused of." "You have passed the verdict, and I suppose you have passed it according to your knowledge. You can kill my body, but you cannot kill my spirit. Have that in your mind in after days. That is all I have to say, Your Honor." Judge Peckham then proceeded to sentence Brown and spoke as follows. "Well, Brown, that statement will avail you nothing whatever. You have been fairly tried and deliberately. You have been ably and admirably defended. Your counsel was able and indomitable. He has been untiring in the defense of your case, exhibiting a skill and ability I have rarely seen equaled. But the evidence in your case is of the clearest and most conclusive character. It satisfied not only the jury, but it satisfied the court and every intelligent mind who has listened to it. There can be but one result in this case from the undisputed facts. You got this little girl on the 17th of September, 1867, from her mother, under the pretense of taking her with your wife, or sending her with your wife as a companion, as a sort of shield to the insults of men. Directly afterward, you go to Cleveland from Dayton, Ohio, and there get her life insured, with that of your wife, a proceeding quite unusual, to insure the life of a little girl for $5,000. Insurance is usually effected by men who have families to support and debts to pay, and they are taken that their families may not be left in want in case their life is lost. But here, what reason was there on earth to insure the life of a little girl, 12 years old, for $5,000? You did more. You got her insured in a false name, and a false name was taken for no other purpose than to carry out the design with which you got her in Dayton. That assumption of a false name was absolutely done with a view of cutting off all communication by the mother with this child. And then you came on east to Canaan, to this comparatively secluded place in this county, and there located, stayed there for a time with your wife, if she be your wife, at the hotel, and then took this house. Your policy had 3 months to run when taken out, and within 12 days of its expiration, this tragedy occurred. After your business was finished, after you had sent your little valuables away from that house, and, with your wife, put on your best clothes preparatory to the scene you knew was to occur that night. And then you had this little girl confined, the little child whom you were bound to treat well and kindly. Otherwise, she could complain to the neighbors that you were not in truth her father, and the moment that was known and death should occur, you would be troubled. Therefore you had to treat her well, as you did doubtless, in order to secure her confidence, in order it might not be known you were not the father of the child. As the night approached, all your things being ready, the first that is seen is your wife goes out to a neighbor's house, about 6:30, and in a short time after, from 15 to 20 minutes, you come in, running in, and it is obvious why you ran in, perfectly obvious. You had just come from the perpetration of the dark deed, from killing this child, and hence you came into the house upon a run, in order to escape as soon as possible, for fear the fire would occur before you got away. You ran into the house after you got there. There is no wonder you did not like to go back. And when you got there, after everything had been put out, you go back, and with the singular knowledge you directly start to where that dead child lay as you supposed. There you marched to that place, without anybody saying anything to you, and when told to go back, you then, without being charged with the commission of crime, except by your own conscience, which called upon you to do something to feign great grief, then you assumed to faint, and the man upon whose arm you lay, not suspecting you were not the father of the child, although he found you feigned fainting, it was not in the nature of the man, and he could not find it in his heart, to reproach the father of the child dead there with being a hypocrite. He could not do that, and hence your fainting went on, deceiving some, but not all. Then they examine this house and find the door locked. The reason why you locked it is obvious. You did not want that fire to interfere with you too quickly. They find the inner door fastened where this little child was burning inside, and it is a singular fact, and it seems to be in the order of providence that a crime of this heinous character could not be committed without its being disclosed. You were so foolish as to shut that door to on the outside. The evidence shows that it was strong evidence against you. The little girl could not fasten the door on the inside. Nothing but the application of pressure would have closed it to remain shut, and that you did on the outside. That shows, the child being on the inside, there was something wrong. Then you supposed when you set fire to the funeral pyre, everything would be consumed and nothing could be left to testify against you. Nothing would be left, you supposed, and yet the very course you took to conceal the crime was one of the surest means of your detection. You piled up the mass of faggots in that little pantry, which left in its results nearly 8 bushels, 6 or 7 besides what fell from the top. It was found on the top of this little girl, and of course the child did not cover herself, and no human being but you or your accomplices was engaged in it. That having been entirely accomplished, the child taken out, you then directly proceeded to a vigorous application to business, to get your money. There is no pretense that anybody else did this thing. No pretense whatever. If there was a killing of that child, you alone and your colleague in crime were the guilty parties. No such murder of the child was ever committed except for some great motive, and that motive you had. $5,000 was a large sum to you, that necessarily directed your action, and then by fraud and perjury you proceeded to obtain this money, and the sequel shows your detection. Under these facts, how idle to tell this jury that you are an innocent man. It is quite idle and useless, and I now say to you, Brown, for the purpose of having you understand that your career on earth is closed. To that you must make up your mind. The jury recommends you to mercy. Strange as it may be, under these appalling facts, they still have the tenderness to recommend you to mercy, though you showed none to that child. The court have but one thing to do. There is no power here to grant mercy, and I agree with the counsel that, being guilty of the offense, no executive will interfere between you and your doom. Therefore I say in all kindness, your career is substantially closed, and you must make up your mind to meet a hereafter. Perhaps I ought to say to you, in view of the facts here presented, you found these materials. You took off the shelves in that pantry, and I am told by the district attorney indirectly that since the trial, by some singular mistake, he omitted to bring into the court the evidences he had of these boards comprising the shelves and being in his possession, and did not produce them on this trial. He had them for some time, and having them so long in his possession, he forgot to produce them. But the case was clear before. No eye could look upon it and not know you cut up those shelves to burn up that child after you had killed her. And now, Brown, it is quite useless for you to deny and to turn to that jury and say they have done you injustice. You thought by this arrangement to escape. You thought, perchance, that fire would burn quickly, and the whole thing be consumed, that there would be not a trace. Possibly that might have been if there had been a strong fire. But the course you took to kill the child was one of the reasons that proclaim your guilt. The fire was slow, it was smothered, and the consequence was that it smoldered while you were waiting for the development. This, then, is your case, and now it is only left for the court to pass the final sentence of the law upon you. And a very solemn thing it is for any tribunal to pass upon the life of a human being. You have taken life deliberately and for money, the life of an innocent, confiding child, and you must pay your life in consequence. Your life must be forfeited. The sentence of the court is that you, Joseph Brown, alias Barney, be taken to the common jail in the city of Hudson in the county of Columbia, and that there, within the walls of the jail within the yard, on Saturday, the 30th day of May, between the hours of 9 o'clock in the morning and 1 o'clock in the afternoon, you be hanged by the neck until you shall be dead, and may God have mercy upon you. At the conclusion of his sentence, the prisoner remarked, "All right." Cool, stoical, and almost indifferent, he bore himself in a manner which some call brave, but which in reality was desperate, and showed that a previous career of crime had hardened his heart to such an extent that not even the knowledge that his course was nearly run could move it. The sentence was duly carried into execution at the time, place, and in the manner indicated. Josephine Brown was indicted as being accessory to the murder, but the case was never brought to trial. After lying in jail several months, a nolle pros was entered by the district attorney, and the greater criminal of the two was allowed to go free. End of section 47. Section 48 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies. An authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Homicide, Part 25, The Brantley-Eskridge Romance, Part 1. In the Circuit Court of St. Louis County, Missouri, February term 1871, suit was brought by Mrs. Minerva S. Brantley of Selma, Alabama, against the Travelers Insurance Company for recovering the sum of $10,000 under an accident policy written upon the life of John Harris Brantley for the benefit of plaintiff in the action. In her complaint, plaintiff states that she is now the widow and was the wife of John Harris Brantley, who, on the 4th day of December 1870, was, without fault, cause of provocation, shot and killed by a party or parties unknown to her. The insurance company, in its answer to the plaintiff's petition, admits issuing the policy referred to, and admits that Brantley was killed on the 4th day of December 1870 but denies that the shooting and killing was not the fault of the plaintiff. And for a further answer to plaintiff's petition, defendant alleges that prior to the execution of the policy of insurance upon which this suit is brought, the plaintiff and one Joseph N. Eskridge unlawfully and wickedly agreed, conspired, and confederated together to cheat, swindle, and defraud defendant out of the sum of money in said policy mentioned, and that, with that purpose in view and to that end, a secret agreement, understanding and conspiracy was entered into between plaintiff and the said Eskridge, whereby an insurance for a large amount was to be effected and procured upon the life of said Brantley, in defendant's company, and in other insurance companies for the benefit of the plaintiff, and that during the continuance and life of said policies of insurance, so obtained by them, the said Brantley should be assassinated and killed, or his life taken in some other violent manner, and after the recovery of the amounts for which the life of said Brantley was insured, plaintiff and the said Eskridge should share their ill-gotten gains with each other. That on or about the 2nd day of December, 1870, and pursuant to said agreement and conspiracy entered into, as aforesaid, between plaintiff and the said Eskridge, he, the said Eskridge, at the solicitation and request of plaintiff, left his home in Selma, in the state of Alabama, armed with a shotgun, and proceeded to Squawkalock, in the state of Mississippi, where the said Brantley then was. That said Eskridge reached said town of Squawkalock on the morning of December 4th, 1870, and after learning upon inquiry that said Brantley was at the railroad station of said town of Squawkalock, he, the said Eskridge, proceeded to said station, and then and there, pursuant to said agreement and conspiracy between plaintiff and Eskridge, brutally assassinated, shot, and killed the said Brantley. This answer of the defendant insurance company to the plaintiff's petition has no uncertain sound, no equivocal wording. If the allegations therein were true, the plaintiff richly deserved the extreme penalty of the law. If not true, the defendant could not be punished too severely for preferring such an accusation of crime. An early investigation of the facts and circumstances surrounding this case was entered upon, and a commission to take depositions in the cause quickly followed. It was learned that General Brantley, the father of John Harris Brantley, the insured, was a wealthy planter, formerly residing in the vicinity of Selma, Alabama. He possessed large landed and personal estates, and before the emancipation held an extensive property in slaves. His family, a few months before his death, consisted of 3 sons and 1 daughter, the latter a young widow. John was the oldest son, and had passed the age of 40 years. He was married, but had no children. He had been devoted to pleasure and vice while a young man, had spent large sums in dissipation, and had incurred heavy liabilities, which his father had to provide for. This state of affairs so exhausted the patience and forbearance of the old gentleman, who died in 1869, that he cut off the prodigal from further benefits. More than a year prior to his death, he conveyed, by deeds, all his property to his 2 younger sons and his daughter, leaving John wholly unprovided for. At the time the property was deeded away, John was living with his wife near Pensacola, Florida, and had neither business, property, nor credit. Soon after these conveyances had been recorded, he returned to the Brantley plantation, and had an ugly quarrel with his father and family. He sought legal advice, and employed General John T. Morgan as his counsel. At the earnest request of the father, a compromise was effected by settling about 500 acres of land upon Minerva, John's wife, the plaintiff in the action against the insurance company. Eventually, a young man named J.P. Howard, who had lost an arm in the Confederate service, came to live on a plantation adjoining the plantation of John H. Brantley and his wife Minerva. From causes incidentally growing out of the family feud referred to, Howard and John H. Brantley were on unfriendly terms. To such a point did Brantley's hostility finally increase that he threatened the life of Howard, and they both went armed for each other, expecting an encounter at any time. In the spring of 1869, Howard and Brantley became involved in one or two quarrels, and a few days afterwards, Howard was found dead in a swamp about a mile distant from Brantley's house. A jury of inquest was held upon the dead body, and the finding of the jury was that Howard came to his death from wounds inflicted by a shotgun in the hands of some person to the jury unknown. But, from the evidence, suspicion strongly attached to John H. Brantley. The coroner issued a warrant upon the finding, and Brantley was arrested and taken before a justice of the peace for a preliminary examination. General Morgan was Brantley's counsel at this time. Brantley was bound over in a bond of $10,000 to appear at the next term of the city court for Selma, Dallas County, Alabama, to answer an indictment to be found by the grand jury. When brought into court, however, the indictment was quashed on motion of General Morgan, the prisoner's attorney, on the ground that it was found by the grand jury upon evidence taken by the committing magistrate at the time of preliminary examination and without any other evidence. The laws of Alabama required the judge, in a case where an indictment was quashed, to hold the accused in custody or require him to give bail to answer a new indictment for the same offense. The judge, who was not a lawyer by profession, disregarded the law in this respect and made no order at that time to hold the defendant Brantley in custody or to require bail to answer to a new indictment. Nor did the solicitor make any motion for such an order. Immediately after the indictment was quashed, Brantley, upon hasty consultation apart with his attorney, walked out of the courthouse and made his escape. He went directly to the railway station, where he took the cars for Meridian, Mississippi. Changing cars at Meridian, he went north on the Mobile and Ohio Railroad to a small place known as Guacalock, where he quietly took up his abode. While there, he was in correspondence with his counsel, as will appear by the following letter, which was produced in evidence by the defendant in the course of the suit. Selma, November 5th, 1869. Mr. John H. Brantley. Dear Sir, I hear nothing said now about your case. I don't know that any bill has been found, but the stir that was made about the matter during the circuit court leaves no doubt in my mind that the bill was found. The studied secrecy of their movements is such that I think they mean mischief. You want to settle at some place where you will be content to live and will not be likely to be disturbed, so that you can go to work and build up. I cannot think it safe for you to return to Alabama, nor to live so close as in Mississippi. Yours truly, John T. Morgan. After Brantley's escape, the matter was again brought before the grand jury, and it was generally believed that an indictment was found. The following letter, which was proved to be in the handwriting of General Morgan, alludes to this subject and also to the Brantley family feud. Mrs. Brantley, Dear Madam, write to Mr. Brantley that I have information I believe to be reliable, that the grand jury have found a bill against him. I feel satisfied also that his place of abode is known. It may be, and I believe it probable, that persons interested will try to find him. I need not advise you what to do in the matter. I wish to see you soon in reference to a claim of your husband's against his father's estate. I am inclined to take steps to collect it if it can be done. Very respectfully, September 18th, 1869, John T. Morgan. Mrs. Brantley forwarded General Morgan's letter enclosed in the following letter, written to her husband. My darling husband, after writing you yesterday morning, I received the enclosed note from General Morgan in the evening, which I send to you immediately for you to act upon. It is just what I have been expecting. I cannot at present advise you what course to take. Only for mercy's sake keep on the lookout and out of the way. I believe, as General Morgan does, that it is known where you are. I will go in and see Morgan tomorrow and advise with him as to what is best for you to do. Your devoted wife, M.B. The result of Mrs. Brantley's interview with her legal advisor is made known in the following letter addressed to her husband. My dear husband, I saw Morgan today, and his advice to you is for you to change your abode until we can see or find out if a warrant will be issued immediately for your arrest. He says you must not let them arrest you, and do not let anyone know where you are for the present, and by all means keep away from the railroad. I will try and have it arranged with the sheriff where you are, not to arrest you, nor let you be arrested, if he receives any warrant. But you must be cautious how he is approached, for there is great danger of it getting out, as he might let it be known up here that you are down there. We will soon know what they intend doing, and then I will advise you as to what is best to be done. Your true and devoted wife. That Mrs. Brantley appears to have continued actively alert is evident by her letters to her husband during this period of his voluntary exile. She sends him little comfort in the following letter. My darling husband, I understand how its brother has written to someone here, inquiring about your case, and is going to revive the case again, and says he is determined to find out who killed his brother. I do not know how true it is, but I am going to find out more about the matter, and will let you know. There is no mistake about the fact that we have secret enemies here, who are working to do us all the harm they can. But I am on the lookout for them, and keep prepared for them. You need not give yourself any unnecessary alarm about this matter, but only be prepared and keep away from the cars. Someone here was making inquiries about my absence, wanted to know where I was and how long I was going to stay, and if I had gone to see you. But it is of no use for them to try to find out my movements, for I am too prudent and too cautious for them. I tell everybody you are in Texas. I am sometimes fearful that your whereabouts may be found out. If I were you, I would live as secluded as possible and not go to town often, but there is always someone on the cars from Soma. With much love, your devoted wife, M.S.B. The reader will remember that the insurance company, in its answer to the plaintiff's petition, alleges that Mrs. Brantley wickedly conspired and confederated with one Joseph N. Eskridge to cheat and defraud the company, and to that end they effected a large sum of insurance upon the life of Brantley, and then, pursuant to the secret agreement and conspiracy between them, they brutally assassinated him. This Mr. Eskridge, who was destined to play so conspicuous a part in the outgrowth of the tragic affair of which mention has been made, was a young man of pleasing address and of more than ordinarily fine appearance at the time of these occurrences. He had been a merchant's clerk in Soma and ultimately opened a store of his own. But having more beauty than brains, his mercantile career soon ended in bankruptcy. He was married to a young woman of good family, who owned and resided upon a plantation adjoining the Brantley place. After his failure in business, he returned to this plantation with his family, consisting of his wife and 2 children, and was residing there at the time of the Brantley feud. While Brantley was under indictment for the murder of Howard and was secretly hiding from justice, Eskridge appears to have been on terms of affectionate intimacy with Mrs. Brantley. This lady was of that rare type of personal beauty found only in those possessing a fair complexion, light golden hair, and lustrous black eyes. In features and form she was strikingly beautiful, and she is described as being brilliant in conversation, fascinating in her manners, and of a very affectionate disposition. By practical people, she was considered too sentimental. Eskridge was but 2 years older than Mrs. Brantley, and it appears in evidence that these pretty counterparts sympathetically gravitated toward each other. Mrs. Brantley's husband was not only under indictment for murder, but by reason of his riotous living, his long-continued excesses, his pecuniary and family troubles, he had become prematurely old. Although but little more than 40 years of age, he was very gray, and though formerly stout and robust, he was now sallow, lean, gaunt, and shrunken away. Broken down with protracted dissipation, he presented the appearance of at least 60 years. While Brantley was a fugitive from justice, and Mrs. Brantley was residing on her plantation, the 500 acres previously mentioned, Eskridge was at his wife's plantation, about 2 miles distance from Mrs. Brantley's house. Gradually, a suspicious intimacy grew up between them. We learn in the evidence of a brother-in-law of Eskridge that during the summer of 1870, Eskridge was neglecting his family and spending a great deal of his time at Mrs. Brantley's place and in her company. This witness and another brother-in-law of Eskridge, named Collins, talked the matter over, and witness advised Collins to remonstrate with Eskridge and persuade him to put a stop to his intimacy with Mrs. Brantley. That persistence in his misconduct would bring disgrace upon the whole family, as everybody in the neighborhood was talking about it. This gossip coming to the knowledge of the virtuous lady, she was prompted to write and send to the witness the following outburst of indignation. John H. McElwain, I understand you have been slandering me in the grossest manner. I warn you that my husband is much nearer than you are aware of, and when you least expect it, he will hold you personally responsible for the base, malicious lies that you are circulating about me. My husband is fully aware of all my actions and movements, and fully approves them. M.S. Brantley, October 28, 1870. The hollowness of this lady's pretense was fully exposed by witnesses of a criminal intimacy. An old and faithful family servant, Willis, in the course of his testimony, made very damaging revelations, but they are too voluminous to reproduce from the record. We have only room for brief reference to some of the material points. He testified that in driving Mrs. Brantley in her carriage to Selma, Eskridge constantly rejoined and accompanied her, meeting and parting with unrestrained and significant demonstrations in the presence of the witness. That sometimes Eskridge called with his buggy and took Mrs. Brantley riding, and that even in the streets of Selma, they were reckless as to any concealment of their guilty attachment. That upon certain occasion, when they were detected in the woods in flagrante delicto, Eskridge purchased the silence of witness with a bribe. Willis had lived in the Brantley family from his birth, and had been their slave for many years. He was devotedly faithful to his mistress, but he felt it his duty, as he says in his evidence, to remonstrate with her upon her growing shamelessness, whereupon Eskridge threatened his life with a pistol. Upon the restoration of amicable relations, Eskridge declared to Willis that he loved Mrs. Brantley and would die for her, and would not give her up for her husband or anyone else. Confidence between the couple and Willis having been reestablished, he was sent to Mississippi to bear to John H. Brantley some lying messages and to make the false plea of sickness in excuse of Mrs. Brantley's failure to rejoin her husband in his exile, in accordance with a promised arrangement. End of section 48. Section 49 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies. An authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Homicide, Part 26, The Brantley-Eskridge Romance, Part 2. Another witness, produced and examined on the part of the defendant in the suit, says he is related to John H. Brantley, deponent's father and Brantley's mother having been brother and sister. Deponent learned from another relative that John H. Brantley was in Mississippi, and that a letter addressed to Dr. Murdoch at Squawkaluk, Mississippi, would reach him. It was a common report in Selma that Eskridge and Mrs. Brantley were living in adulterous intimacy, and that they frequently occupied a room in the south end of what was once known as the Weaver Carriage House. Deponent saw Eskridge going into and coming out of that room, and noticed that he habitually locked the door when he came out. Witness wrote a note to Mrs. Brantley in the fall of 1870, and told her that he knew of her course of conduct, and that he intended to write her husband, informing him of what she was doing. He folded this note and pushed it through the keyhole of the door of the room in the carriage house at a time when Mrs. Brantley and Eskridge were in the room. Afterwards, he did write to Brantley and told him in the letter of the improper intercourse between his wife and Eskridge, as reported by common rumor, and directed the letter to Dr. Murdoch, Squawkaluk, Mississippi. Soon after this witness met Eskridge, who called to him and said, "I understand you have made some threats against me." Witness replied to him, "I have not, but as Brantley has killed one man in the dark, he can kill another in the same way." Upon receipt of the letter in question, Brantley determined to see his wife at all hazards. It appears from the evidence of Adeline, a house servant of Mrs. Brantley, that Brantley came home one Friday night after dusk. Mrs. Brantley was not at home. She had left her house that day in Eskridge's carriage, saying to witness she was going to town. Eskridge was not with her. His waiting boy drove the carriage. On Mr. Brantley's unexpected arrival, witness prepared supper for him. He immediately inquired for his wife, and witness told him that Miss Minerva had left home that day, saying she was going to Selma. He then asked when she was coming back. Witness told him she did not know. He said he very much wanted to see his wife, and that he had come a long way for that purpose. He remained at the house during Friday night and all day Saturday, and on his expressing anxiety to remain undiscovered, witness carefully kept the door shut and allowed no one to see him except Albert Sevier, the brother of his wife. In response to his wishes, Albert went after his wife, but he returned in due time with the intelligence that Mrs. Brantley would not come, that she was afraid to come. Mr. Brantley went away sometime during Saturday night. His wife returned home in the course of the following week, in company with Mr. Eskridge. These facts and various others, which were elicited during the trial, were corroborated by another colored house servant, named Hannah. Brantley was devotedly attached to his wife, and whatever suspicions may have been aroused in his mind towards the latter part of 1870, it is certain that he was wholly blinded to her misconduct during the earlier portion of that year. At that time, he appears to have placed unbounded confidence in his wife's friend Eskridge, who tendered his assistance in numerous little matters pertaining to the family feud, and he empowered Eskridge to execute, as attorney, some important trusts. His fond and loving wife continued to send him letters, overflowing with affection and sympathy for him in his exile. She also supplied him with money from her limited resources. From among the numerous letters produced in the course of the trial, the following may serve as a specimen, showing with what readiness Mrs. Brantley could use her pen. Usually her letters are exceedingly lengthy, and therefore only extracts therefrom are here given. My darling husband, I have been quite ill since I returned home, but am improving, yet suffering greatly from an overdose of quinine. You don't know how dreadfully quinine affects me. I am determined never to take another dose if I know it. I was like a crazy person. I long for the time to come when I will be able to sell out here and leave this hateful country forever. I am growing to hate this place and people more and more every day. They have no sympathy for anyone that has no money and is in trouble, but seem to do everything they can to put one down. We have not a real true friend here. I am resolved to sell out next winter and move to some other country, so you may be on the lookout for a home for me. What is life to you and me but a burden in the way we have to live? For no one cares for us. If we expect any happiness in the future, we must find it within ourselves, to try and make each other happy. It makes me miserable to think what a lonely life you have to live, and I am determined to share your future with you after this summer, come what may. For, after all, my darling, a man's truest and best friend is his wife, and I can say truly that I am the truest and best friend you have on earth. If the whole world forsakes you, I will cling ever the closer to you. All my acts and efforts are for you and your happiness, and you can ever rest assured, my dear husband, that in me you have one faithful and devoted friend who will ever be ready to make any sacrifice for you. My life is a sad one, with nothing but trouble and sorrow, and I have so much to discourage and dishearten me. Yet amidst it all, I feel it cannot last so always, that the time will come when I can have some rest from the sorrows and troubles of this life. And it is this cheerful hope that sustains and supports my drooping heart amidst all our afflictions. I am resolved never to give up in despair, but will fight it out like a brave soldier, if I die at my post. I will send you some clothes or the money, if I can get any, whenever you wish. With much love, your devoted wife, M.S.B. With all her alleged sentimentality and her complete surrender to a blind infatuation, Mrs. Brantley appears to have been of a shrewd business turn of mind. At that time, the agricultural interest of the neighborhood was productive of very little ready money, and her cash income was by no means adequate to her wants. Her friend Eskridge was always impecunious, and so they put their heads together to contrive a scheme for supplying themselves with money. Their attention was finally drawn to the practicalities of life insurance as a means through which they might further their purposes. An attorney at law residing in Selma, being examined on the part of the defendant insurance company, deposed that he had a lengthy conversation with Eskridge on the subject of life insurance early in the year 1870. Eskridge came into deponent's office and began a conversation on life insurance generally. After talking on this subject for a while, he asked if a life insurance company could be made to pay a policy upon the life of a fugitive from justice which is taken out while he was hiding from the law, and was afterwards caught and hung. Deponent told him that if the fact that he was a fugitive from justice was concealed from the company, they would not be bound to pay, but that if the company took the risk knowing all the facts, in Deponent's opinion, it would be bound. He then said he was trying to get a policy on the life of John H. Brantley for the benefit of Brantley's wife. He inquired how to obtain the application and how to comply with the requisite forms. He said at that time Brantley was in Mississippi, concealing himself from an indictment for murder. Having formed a definite plan of operation, Eskridge set about obtaining insurance on the life of Brantley for the benefit of Brantley's wife. In doing this, he seems to have disregarded the advice of his attorney touching the concealment of facts. An application for $10,000 insurance in the Life Association of America was made, dated April 25, 1870. This application was forwarded to the head office of that company May 26th. The policy in return reached Selma June 14th. But as Eskridge could not then obtain the money, the first premium was not paid and policy delivered until June 30th. It appears in evidence that Eskridge applied for a loan to a personal friend, a gentleman with whom he had been associated in business formerly, who, being examined on the part of the defendant, deposed and said, "Eskridge came to my office and stated to me that Mrs. Minerva S. Brantley had been over to Mississippi and had had her husband sign an application to have his life insured, that the application had been approved and the policy was now ready for delivery as soon as the premium was paid." He further stated that Mrs. Brantley was exceedingly anxious to obtain the policy on the life of her husband, because he was a man of such habits that his life was uncertain, and it was absolutely essential that the premium should be paid at once. That Mrs. Brantley had made application to her merchants for money to pay the premium, and they had refused to advance it to her. That he, Eskridge, had come to me to get me to advance a sufficient amount of money to pay the premium for Mrs. Brantley. I refused at first to advance the money. On a second application by him for the money, he having offered additional security and binding himself personally to see it paid, I advanced the money to him. Subsequently to the time of obtaining the life policy, Mrs. Brantley and Eskridge called at the Selma office of the Travelers Insurance Company for the purpose of obtaining an accident policy upon John H. Brantley. Upon making known their wish, they were furnished by the agent with a blank form of application and with the usual instructions. Some days afterward, they both called again at the agent's office and presented the application duly filled out and signed by Brantley. On the same day, August 25, 1870, an accident policy in the sum of $10,000 was written, but it was not delivered until 2 days afterwards, when Mrs. Brantley returned to the agent's office, paid the premium, and obtained the policy under which the suit was brought. Eskridge had now secured $20,000 insurance upon the life of Brantley, so that in the event of his death by violence, his disconsolate widow would be furnished with material aid and comfort. About this time, Mrs. Brantley addressed the following letter to her husband. At home, August 14th. My darling husband, I have received several letters from you and regret that you seem to attribute my not writing to indifference. But let me assure you that it is not true. I have been waiting for the last week to see General Morgan. A few days after you left, he went to see his family, and not being well when he left, I expect he is sick, as he has not returned as yet. I cannot get any money until he returns. I am exceedingly anxious to see you, and will certainly come if I can get the money. I am delighted to learn that you are so pleasantly situated, and that you are with kind friends. I felt so anxious about you for fear that you would give way to gloomy feelings and low spirits. I hope that you will be cheerful, although it is awful to be separated in this way. I hope that the worst is over, and that soon we will be united again. I feel so thankful that you escaped in the way you did, and that it was no worse. Everybody thinks you are cleared for good. A Negro man who belonged to Griffin was caught, and he confessed that he had killed 5 men in the swamp. He said he did not know their names. Everybody believes that he was the one who killed all those who were murdered in the swamp. We are well. My health is improving. No cotton worms yet, no news. I will write just as soon as I have seen Morgan. I will let you know if I can come. You know that I will come if I can, for you are the dearest object of life to me, and the only one I love and think most of, and would rather be with. Write me often, and believe me, your devoted wife, M.S.B. It will be observed that this devoted wife no longer alarms her husband with fears of his arrest, and no longer advises his flight to a place of greater seclusion and less danger. The occasion for this change in the tone of her letters may be accounted for in the evidence of the state's attorney, who was examined on the part of the defendant. In his evidence in the suit, he says, I began to act as solicitor in September 1869, and have been acting ever since. During that time, there was pending against John H. Brantley in the Circuit Court of Dallas County an indictment for the murder of one Howard. Joseph N. Eskridge called at my office to see me, the subject of his conversation being the laying of plans for the arrest of Brantley. He gave me the address of the brother and the brother-in-law of the man Howard, for the murder of whom Brantley was indicted, and asked me to write to them, to know if one or the other of them would meet a friend in Meridian, Mississippi. He cautioned me not to mention his name to them, but asked them to meet a friend there, and he told me that he would be that friend. He told me to tell them to name the day in the hotel at which this friend should meet them, and that this friend would give them the information and assist them in the means to arrest Brantley. And he told me that when they arrested him and brought him here, he, Eskridge, would give me the name of a witness that would hang him. I wrote the letters as requested and made the appointment, which Howard's brother and brother-in-law failed to keep on account of sickness, as they subsequently informed me. When Eskridge left me at the end of this interview, he went directly across the street from my office to Mrs. Minerva S. Brantley, who was standing in an alley on the opposite side of the street, walking about, apparently waiting for someone. When Eskridge came up to her, he commenced talking, without any salutation, and they walked off down the alley together, still talking to each other. They walked into a vacant lot on the side of this alley to Mrs. Brantley's carriage, and drove off in the direction of Mrs. Brantley's house. On another occasion after this, Eskridge came to see me at my office when I informed him of the failure of the appointment with Howard's brother and brother-in-law. This information was given in reply to Eskridge's question asking me why those fellows had not come to time. He asked me to arrange another appointment with the same men for the same purpose. When he left my office, I watched him, because of having observed his going to Mrs. Brantley at the end of the previous interview. On this occasion, he went directly to the street corner diagonally across from my office, where he met Mrs. Brantley. About 15 minutes afterwards, he rode out of town in a carriage with Mrs. Brantley, in the direction of Mrs. Brantley's home. On another occasion after this, he came to my office and conversed with me on the subject of arresting Brantley, and when he left the office he went straight down the street and met Mrs. Brantley on the street. They commenced talking without any salutation and walked off down the street together. Pending these arrangements for the arrest of Brantley, Eskridge came to my office frequently to inquire how I was getting along with the arrangements, and whenever he saw me on the streets, he would speak to me about it. He manifested great anxiety to have Brantley arrested by the relatives of Howard and appeared to be very restless and uneasy about it. He frequently cautioned me not to let it be known that he had anything to do with the arrest of Brantley, or that he was giving information about it. On one occasion, Eskridge told me that there was only one other person who knew that he had anything to do with getting up information and making arrangements for the arrest of Brantley. The second appointment at Meridian failed also. Eskridge came a short time afterwards and inquired why the brother and brother-in-law of Howard had not kept their appointment at Meridian. This was a short time before the death of Brantley. It is evident that Eskridge did not seek to have Brantley arrested merely and brought to justice, for that could have been effected quite as easily without as with the assistance of the brother or brother-in-law of the murdered Howard. On the contrary, it is apparent that his object was to have the arrest made by or in the presence of the Howard relatives, and under such circumstances as would render it probable that Brantley would offer resistance, which would afford a pretext for shooting him. Such an act would enable the Howards to revenge, with safety to themselves, the murder of their brother by Brantley, and by the same act, Mrs. Brantley would become a claimant for the $20,000 insurance money. The failure of the Howards to keep their appointment with Eskridge defeated the original purpose of the two conspirators and led them to adopt other schemes for the accomplishment of their purpose. They rearranged their plans and resolved to do the bloody deed themselves. By a preconcerted arrangement, Mrs. Brantley and Eskridge were to meet in Demopolis, a place about 27 miles distant from Selma, on the railroad running from that city to Meridian, Mississippi. Mrs. Brantley went by cars, while Eskridge rode through the country on his own horse, a handsome iron-gray thoroughbred, which he took for the purpose. The day before he left his home, he sent Mrs. Brantley a note written in the following words: "My dearest one, I enclose you $25, which, I presume, is as much as you wish till I see you in Demopolis. Be prompt, my dearest one. God bless and protect you, my darling, till you join your devoted boy." End of section 49. Section 50 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies. An Authentic Record of Remarkable Cases by John B. Lewis and Charles C. Bombaugh. Homicide, Part 27, The Brantley-Eskridge Romance, Part 3. The guilty pair arrived at a hotel in Demopolis, where they fully matured their plans. Eskridge, who was to personally attend to the killing of Brantley, in prearranging to prove an alibi, and also to account for his absence from home, wrote a letter to O.F. Harrell in Selma, which letter is postmarked Demopolis and reads as follows: "Dear Sir, I am compelled to be gone for a few weeks on business and to recruit my health, which is very bad at present. There are some little balances still due by the tenants on the Swift place, of which I will send you a memorandum. I will be back between this and Christmas. Yours truly, J.N. Eskridge." In furtherance of their plans, Mrs. Brantley wrote a letter to her husband dating it, "At Home," although it was mailed and postmarked Demopolis, requesting him to meet her on the morning of the 4th of December at the Squawkaluk railway station on the arrival of the early up train. This letter was afterwards found on the dead body of Brantley. In Demopolis, they both were strangers and attracted no particular attention at the time. They occupied a room at the hotel as husband and wife, announcing themselves as such. When they were ready to leave, they hired a conveyance to drive to Livingston, Sumter County, Alabama. Eskridge and Mrs. Brantley occupied the conveyance together, while a boy accompanied them, riding Eskridge's horse. Reaching Livingston, they stopped at a public house there kept by Mrs. Lockard, who, being produced on the part of the defendant in the insurance suit, testified as follows. About the 1st or 2nd of December 1870, a gentleman came to my hotel in company with a lady. They drove up in a carriage together. A boy was attending to them, riding a very fine iron-gray horse belonging to the gentleman. The horse was retained here, and the carriage sent back, with the boy, to Demopolis. The gentleman registered their names as Joseph N. Eskridge and lady, and said they had come up from Demopolis and wanted to go to the nearest station. From this place, on the Mobile and Ohio Railroad, above Meridian. I directed them to Gainesville Junction as the nearest point by private conveyance, through the country, about 25 miles distant from my hotel. I advised them to go by rail from Meridian, but they objected, saying they desired to avoid that place. They remained as guests at my hotel during 2 nights and 1 day. They represented themselves as man and wife, and occupied the same apartment. His attentions were remarkably affectionate and tender towards her, and the waiters called them the loving couple. This gentleman and lady remained in their room nearly all the time during the day, except at meal hours. They walked out on the streets both evenings, and remained out about an hour the last night of their stay. That night, when they returned from their walk, they brought back with them a new double-barreled shotgun. Important testimony was also furnished by William Kirkland, keeper of a livery stable in Livingston. He stated that on the 2nd day of December 1870, Joseph N. Eskridge, whom he had formerly known for many years, came to Livingston in a wagon belonging to Mr. Breitling in Demopolis. A very handsome lady, unknown to witness, accompanied him. He brought with him a fine iron-gray horse, which witness stabled and fed. Being acquainted with Eskridge, witness asked him who the lady was, but he would not tell, and evaded every question about her. A merchant doing business in Livingston brought out a material fact in the course of his evidence. Said he, "To the best of my recollection, between the 1st and 3rd of December, 1870, a strange gentleman came into my store and selected a double-barreled shotgun, the price of which was $25, and at his request it was laid aside for him, he stating that he would call for it. He came the next night in company with a lady whom he called dearest, and asked for the gun, and the lady paid for it. She, upon examining the gun, remarked that it was a very nice one and would do, as they wanted to use it about 2 months, and then could sell it to the freedmen for the amount they gave for it. They took the gun and left the store, it being then about 9 o'clock at night. This lady was tall and slender, had black eyes, fair complexion, light hair, and wore a diamond ring. The gentleman was about 5'7" or 8 inches high, good-looking, hair short, and inclined to be gray. Eskridge procured a carriage at Kirkland Stable on the morning of the 3rd of December, for the use of which he paid Kirkland $10 to go to Gainesville Junction, a station on the Mobile and Ohio Railroad. A son of Kirkland went with them, riding Eskridge's horse, and brought the carriage back from the junction. The party arrived at Gainesville Junction before noon of that day and stopped at a small hotel kept by Reuben S. Parks. At the time of their arrival, Mrs. Brantley was in the carriage, and Eskridge was riding his horse. Eskridge dismounted and assisted Mrs. Brantley to alight from the carriage, while a son of Mr. Parks, the landlord, took Eskridge's horse. They went into the hotel and upstairs to a room, where they remained together some 2 or 3 hours. In the course of the afternoon, Eskridge's horse was saddled for departure. He mounted and rode over to the depot, where he dismounted and asked Alan Parks, the boy who had received his horse on arrival, to hold his horse in a bundle while he went into the depot office. Alan testifies that while he was in charge of the bundle, during Eskridge's absence in the depot office, he examined it and found it to be a double-barreled shotgun, unstocked and wrapped in a blanket. Eskridge inquired of the depot agent the nearest way to Shackalack. He was directed in reply to ride upon the railroad track to a station 5 miles north, where he would strike the dirt road leading to Shackalack and could there get further direction. He at once rode off up the railroad as directed, with the bundle containing the shotgun across his lap. Shackalack, the place where Brantley had remained so long in concealment, is about 25 miles north from Gainesville Junction, and Eskridge arrived there sometime during the evening of the day he left the junction. It appears that Brantley, that evening about 10 o'clock, took his supper with one Felix B. Greer in the back room of Norman Anderson's store in Shackalack. Mr. Greer had some mules in a lot back of the store, and hearing a disturbance among them, he went out to learn the cause. There he saw a man with a blanket over his shoulders, carrying a gun. The stranger remarked to Greer, "Your mules are only frightened by me," and at once walked down the street, whereupon Greer returned to the store. Greer again that night saw the stranger on the platform of the railway passenger station, and also saw him in front of Nurm and Anderson's store, where his horse was hitched. Greer remarked to him that he had a fine horse, and he replied that it was a thoroughbred. The moon was shining very brightly, and Greer noticed that the horse was a dark iron gray with a white face and 15 or 16 hands high. Greer further said in evidence that in conversation with Mr. Brantley that evening, December 3rd, Brantley said he was expecting his wife by the early morning train, and in order that he might not fail to be present on arrival of the train, he was to sleep at the passenger station house with Mr. Irwin, the station agent. Eskridge, it would seem, was prowling about the vicinity of the railway depot several hours that night, watching for his victim. During all this time he had his blanket wrapped about his shoulders and had his gun, which was then properly adjusted with the lock under his arm, carrying it in the usual manner, muzzle down. Sometime during the early morning hours, and probably somewhat under the influence of liquor, Brantley went into the depot unobserved by Eskridge, and there fell asleep in a chair before the stove, in which a fire was burning. While Brantley was thus sleeping and awaiting the arrival of the train, on which his wife was expected, Eskridge took deliberate aim, and shooting from where he stood on the platform outside, sent the charge through the closed window into Brantley's head, causing his instant death. The only other person in the room when Brantley was shot was the mail carrier. He was lying upon a bench under the window through which Eskridge fired, and was asleep at the time. This carrier had seen Eskridge that night on arriving with the mail at the depot, and had observed his iron-gray horse particularly. Eskridge was dismounted at the time and standing with the bridle in his hand. He was wrapped in a blanket and had a gun under his arm. When the shot was fired, the frightened carrier jumped up, ran out and hid under a car, where he remained until daylight. Immediately after the shooting of Brantley, Eskridge sprang into the saddle and rode rapidly away. To return to Mrs. Brantley, whom we left at Parks's Hotel, Gainesville Junction, she remained there that night, gave her name to the landlord as Mrs. Brantley, and left on the early train going north. On the same train was a passenger who, on the part of the defendant in the suit, testified as follows. The train left Gainesville Junction about 3 or 4 o'clock in the morning on the 4th day of December. It arrived at Chackalack, 25 miles above, on scheduled time. When we reached Chackalack, a lady got up from the seat immediately behind me, in the ladies' car, and rushed to the door exclaiming in an excited tone, "Where is my husband? Is my husband here?" She received no reply, and returning to her seat, appeared satisfied. The cars then proceeded to Macon, the next station, which is about 10 miles above. There was a freight train on the main track at Macon when we arrived, and the passenger train was obliged to halt until the freight train could back out. After our train stopped, the same lady took her satchel and was in the act of getting off the train when I informed her that the train had not reached the depot. It was a cold morning, and I then occupied the seat directly in front of the stove. After I spoke to her, the lady came in and stood by the stove. When I observed that her dress was wet and I asked her to take my seat, she seemed cold and her shoes were muddy. She sat down and asked me to share the seat with her. I did so. As soon as I took my seat, she commenced talking of what caused her feet to be wet. She said that morning her husband put her on the train at Gainesville Junction, and as she was getting to the train, she stepped into the mud. She then said that her husband from Selma had telegraphed her to meet him at Chackalack, and if he was not at Chackalack, for her to go on to Macon. After telling me this, she said that her husband would have come up with her on the train that morning, but that he had a very fine racehorse which was afraid of the cars, and so he had ridden his horse through the country to meet her at Chackalack. She requested me to attend to her baggage in going from the depot to the town of Macon. We stepped into the omnibus, and I then discovered that the woman was apparently drunk. When we reached the hotel, she was in such a condition that she could scarcely alight from the omnibus. When the driver opened the door, I took her satchel and mine. She got hold of my arm and walked with me into the hotel. I remarked to the clerk that here was a lady who wanted a room. She paid her omnibus fare, and while she was doing so, I left the hotel office. When I returned, about 20 minutes later, the clerk assigned me a room. While I was in my room, my attention was attracted by the sound of someone pounding on the wall in the adjoining room and calling, "Come in." I went to the door of that room, opened it, and discovered the same woman who had come to the hotel with me from the cars. I asked her what she wanted. She answered, "Come in." I walked to the foot of the bed upon which she was lying with all her clothes and bonnet on. I supposed that she was still intoxicated, and I left her room and at once informed the clerk that she needed assistance. It is probable that the intoxication was due to morphine and chloral, which Mrs. Brantley took occasionally, and which is known to have produced similar effects upon her previously. End of section 50. Section 51 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies. An authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Homicide, Part 28, The Brantley-Eskridge Romance, Part 4. In continuation of the tragic story, we quote from the testimony of the Marshal of Macon, who was also a deputy sheriff. He said, "I was acquainted with John Harris Brantley and have known his wife Minerva since 1860. I have known Joseph and Eskridge about 12 years. On the morning of the 4th day of December, 1870, I was ordered by the sheriff to go to Chackalack and summon a jury for the purpose of holding an inquest upon the body of Brantley. I was also informed by the sheriff that Mrs. Brantley was in town at the hotel. I called upon her and told her that her husband was at Chackalack and that she must go with me to that place. She asked me if her husband had been arrested. I told her it made no difference. She would find out when she arrived there. Mrs. Brantley at the time was under the influence of morphine. She said she was suffering from neuralgia and could not go with me. I insisted that she should get up and go at once. She then asked me why I wished her to go with me and inquired again if Mr. Brantley had been arrested. I told her it made no difference, that she would learn about that after we started, that she must get up and go with me, which she did. On the road to Chackalack, we came up with the sheriff, who informed Mrs. Brantley that her husband had been killed at Chackalack that morning. She made an effort to cry, but did not shed many tears. We then went on to Chackalack. While we were on the road, I handed her a letter. She then spoke of Mr. Brantley and said she had always told him that if he was ever killed or captured, it would be at a time when she was going to him. On the way, she talked of her affairs at home, saying that she was left in a bad condition, that Mr. Brantley was always writing to her for money, and she did not have any to send him, that he had written her to come on and see him, and she was afraid to stay away. Apparently, her husband's death was the least of her troubles. I asked her if she had any idea who did the deed. She answered that she had not, that she could not think of anyone who had animosity against him sufficient to do such a deed. When we arrived at Chackalack, we passed within 30 or 40 steps of the place where Brantley was killed. I asked her if she wanted to see her husband's body, and she said she did not. I inquired if she wished to go to the hotel, and she asked me if I did not have a friend at whose house I could take her, so that she would be secluded. I told her that I did have, and I carried her to Captain Roll's house. During the drive from Macon, she seemed quite indifferent about her husband and the manner of his death, and much of the time she talked and acted in an ordinary and unconcerned manner. She did not go to see her husband's body at any time. I remained at Chackalack from about 10 o'clock in the morning until about an hour by the sun in the evening. I visited Mrs. Brantley several times during the day. She made no allusion to her husband, except to ask me what the notions of the people were about his death. I told her that they were saying that she was as deep in the crime as the man who committed the murder. She replied to this that she could not see what grounds they could have for such a feeling against her. I told her it was because of a letter written by her, which was found on Mr. Brantley's person after he was murdered, stating that she would be at Chackalack on the morning train of December 4th. I then asked her why she did not get off the train at Chackalack instead of going up to Macon. She replied that she sent a gentleman who was sitting on the seat next to her to inquire if Mr. Brantley was there, and he told her Mr. Brantley was not there, and so she then went on to Macon because Macon was the next station. I asked her why she did not get off at Chackalack, even though Mr. Brantley was not there. She did not reply to this question. She made no inquiry concerning the dead body of her husband as to what attention was being paid to it, or whether it was receiving any attention at all. I told her I was going away, when she eagerly asked me where I was going. I answered her by saying that the sheriff had ordered me to capture the man who had done this deed. When I said that, she looked frightened and pleadingly implored me not to go and leave her all alone in such a condition, but to let someone else go, as I was all the friend she had. I told her I would have to go, or I would lose my office. She asked if I had any idea who the person was. I answered I had not. I further said to her that if she had, and if it was a friend of hers, she must tell me, confidentially, as her friend, and I then would know how to proceed. She replied, "Mr. Simmons, I cannot say." I then left her. During the day, I had made inquiries in Chakalak about what had occurred there at the time of and immediately preceding the killing of Brantley, for the purpose of getting a clue to the murderer. I learned that a stranger came there the night before on a gray horse and was first observed at about 9 or 10 o'clock when he hitched his horse in a backyard behind a store. And at about 11 o'clock, he brought the horse in front of the store and tied it to a wagon. I was shown both places where the horse had been tied. I also learned that this strange man had been prowling about the place during the night until Brantley was killed, and then he left on his gray horse. While lurking about the depot, the stranger had a blanket thrown over his shoulders and a double-barreled shotgun partially concealed under it. I got a minute description of this gray horse and made a careful examination of his tracks where he had been hitched, and noticed that the horse was barefoot except the left forefoot, which had a worn shoe upon it. After obtaining all the information I could, I followed the track of the horse from the corner of the depot where it had been hitched last. From the tracks, the horse appeared to have taken an easterly course towards Wahalak, going in a lope. As long as daylight lasted, we were enabled to follow the horse by its tracks. At the forks of the road, the tracks indicated which road he took, and also showed that he went in a lope for 7 miles until he arrived at the house of Mr. Etheridge. At the house, I learned that the horse and the rider had stopped there, and from a description of them, I knew I was on the right course. I pursued an easterly direction through Wahalak in Mississippi to Gainesville in Alabama. We made inquiries along the road for the horse and rider, and thus were enabled to follow them. We also could see the tracks of the horse in the soft places in the road, as the moon was shining brightly. When we arrived at Gainesville, we learned upon inquiry at the ferry that the man and horse had crossed the ferry in the direction of Eutaw, Alabama. After having our horses fed, we continued our pursuit, crossing the Bigbee River at Gainesville, and rode eastwardly until we came to the house of Dr. Jolly, which is about 6 miles from Gainesville near Mount Hebron. All the way on the road from Chakalak to the house of Dr. Jolly, wherever we could see the track, it showed that the horse was barefoot except the left forefoot. I became familiar with the appearance of the track, so that I could recognize it at a glance. On the road, we obtained frequent descriptions of the horse and rider, of the dress of the rider and the outfit of the horse. After crossing the ferry, we met a Negro, and from information received from him, and by taking him along with us, we went to the house of Dr. Jolly, which is about 300 yards from the public road. This house is not the residence of Dr. Jolly, but that of his plantation overseer. 2 gentlemen went with us from Gainesville. Arriving at the place, we went first to the overseer's barn, and there found in a stable a deep iron-gray horse, with head and neck whiter than any other part of him. He was a remarkably fine, stylish-looking animal. I found 3 of his feet bare, but the left forefoot had a shoe on it which was badly worn, particularly in front. After examining the horse and posting guards at the 2 doors of the house, the deputy who accompanied me sent the Negro to wake up the overseer. The latter came out to the fence. We gave him a description of the man we were in search of, told him our business, and inquired if the man was in his house. We were informed that he was. By arrangement, we all went to the door of the room where the man was. When the overseer called to the man and said that he wanted some medicine, which was in the room, and asked him to get up and light a candle. The man got up, lighted a candle, unfastened and opened his door, and we then seized him. When we arrested the man, he asked, "What right have you to come here and arrest me?" I replied, "You are the man who killed Brantley at Chocolate yesterday morning, and we are going to take you back there." The man then asked me what authority I had to take him from one state to another. I answered that my authority was main strength, and that the sheriff of Noxubee County had sent me after him, and I was going to take him back dead or alive. When we arrested the man, I recognized his features, but could not recollect his name, as I had not seen him since the war. I said to him, "You know me. What is your name?" He replied, "I will not tell you till I see counsel in Gainesville." I told him that he would never see counsel in Gainesville, that the only counsel he could see would be in Chocolate. In the room where we discovered him, we found his saddle and saddlebags, his double-barrel shotgun, and 2 pistols, 6-shooters. His gun was unbreeched and wrapped in a piece of blanket and tied behind the saddle. I took the gun and examined it minutely. One barrel was loaded with 18 buckshot, such as are commonly called blue whistlers. The right-hand barrel was empty and appeared to have been shot off. The gun was a new one, and the left-hand barrel appeared never to have been used. We took the man and put him on a horse and took him back to Gainesville. On the ferry flat at Gainesville, he called me aside and said to me, "Simmons, I know you. I knew you at first, but I did not want to let you know my name until we got here to Gainesville, where I can have counsel." I told him he might just as well tell me his name at once, as he could have no counsel in that place. He then told me his name, and I recognized him as Joseph N. Eskridge, a man whom I had known before. He again asked me to let him see counsel in Gainesville. I refused to do this, but I untied him and advised him to go back with us voluntarily, as it would be better for him to do so. The place where we arrested Eskridge is in Greene County, Alabama, 34 miles east from Chocolate. It was about daylight on the morning of the 5th of December when we reached Gainesville. There we purchased a bottle of whiskey, and at Eskridge's request, we bought a small vial of morphine for him. We remained only long enough to effect these purchases, and then rode on toward Chocolate. When about a mile from Gainesville, we stopped, and Eskridge took some morphine, while we took a drink of whiskey, and I invited Eskridge to take some with us. He did so, and then commenced crying. He said he would not mind being taken back if it were not for his wife and 2 little children, that he had as good a wife and 2 as lovely children as were in the state of Alabama. I said to him, "Joe, what did you kill Brantley for?" He replied, "If I killed him, I had a cause, but I did not do it." He spoke the latter part of the sentence in a low tone of voice. He then said, "Woman, woman, woman, this kind heart of mine has brought me to where I am." I then stopped him and told him not to talk any more on that subject. We proceeded on our way, and when we came near to the church in Chocolat, where the graveyard is, we saw a burial procession at the graveyard, and the deputy accompanying us said they were burying Brantley there. Eskridge then said to me, "Simmons, for God's sake, don't carry me past there. I do not want to be disgraced that far." As he spoke, he became very pale. We then turned around to avoid going past the burying ground, and Eskridge asked us to stop a moment until he could take another dose of morphine. While taking the drug, he remarked that it was the only thing that would ease his troubles. He then requested me not to take him through the town where the people could see him, that he did not want to be seen going to prison. I complied with his request and conducted him by a back way to Esquire Haynes' house and placed him under guard in a private room upstairs. I there left him. As I was about leaving him, he asked me if Mrs. Brantley was in town. I answered that I did not know. He desired me to ascertain and let him know, as he wished to see her. I told him if she was there, I would return and inform him, but if she was not there, I would not come back. He requested me to get him another vial of morphine and send it to him, as he had taken all that I obtained for him in Gainesville. After leaving Eskridge, I went to the house where I had left Mrs. Brantley the evening before, and upon inquiry was told she had gone from there to Kemper County, about 18 or 20 miles distant. On the morning of the 6th of December, Eskridge was taken before a court composed of 3 magistrates of Noxubee County for a preliminary examination. He was fully identified by 3 or 4 persons as the man who rode up to the railway station on the night of 3rd of December on a gray horse, and who had been observed prowling about the station as already described. He was promptly committed, without bail, to answer the charge of murder of John H. Brantley. He was first taken by cars to Macon and kept there, under guard, overnight. The next morning, which was the 7th of December, he was lodged in jail. On the morning of the 8th of December, a warrant was issued for the arrest of Mrs. Minerva S. Brantley on the charge of being accessory to the murder of her husband. A deputy sheriff made the arrest at the residence of Mr. Maury in Kemper County, whither Mrs. Brantley had gone from Chocolat. The officer who made the arrest testifies as follows. I told her I had a very unpleasant duty to perform as an officer, that she was my prisoner. She was sick in bed and unable to be removed. I summoned her attending physician, and he decided she was not able to be moved. When I first went into her room, she was in bed, lying with her face from me, with her head on the far end of the pillow. The end of the pillow towards me was tilted up, and I noticed the handle of a small Wesson pistol, which I took and removed from under the pillow. When I told her she was my prisoner, she turned in bed and put her right hand under the pillow from which I had just taken the pistol. I said to her, "It is not there." She then lay down in the bed and had a sort of fainting spell. I examined the pistol soon afterwards and found 3 cartridges in it. I remained at the house in charge of Mrs. Brantley 3 or 4 days, at the expiration of which time the sheriff and Deputy Sheriff Simmons came and took her to my own house in Macon, where I guarded her until between the 10th and 20th of December. Deputy Sheriff Simmons testifies relative to his official visit to Mrs. Brantley during this period of her arrest as follows. When we arrived where she was, Mrs. Brantley drew me aside and said, "Mr. Simmons, I will never forgive you for this." "For what? For bringing Joe Eskridge back?" She answered, "Yes." I told her she need not blame me for that in my opinion, She knew as much about who had committed this crime before he was captured as she did now. When we left the house, Mrs. Brantley rode in a buggy with me and continued to ride with me for 3 miles or more of the way. She talked about Eskridge and asked me if he had said she had anything to do with the murder. I told her he had not. When we reached Noxubee County, the sheriff drove up and stepped into the buggy with Mrs. Brantley, and I got into his buggy. End of section 51. Section 52 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies. An authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Homicide, Part 29, The Brantley-Eskridge Romance, Part 5. Mrs. Brantley soon afterwards was brought before a magistrate's court on preliminary trial. She waived examination and consented to give bail for her appearance at the next term of the Circuit Court of Noxubee County in the sum of $7,500. The court, without solicitation from the defendant, fixed her bail at $1,000. After furnishing the required bail, Mrs. Brantley went to Chattanooga and visited other places, returning to Macon and to the house of Deputy Sheriff Reed during sitting of the Circuit Court at the spring term of 1871. While at the house of Mr. Reed, she wrote a very lengthy letter to Eskridge, who was then in jail in Macon. Concerning this letter, there are interesting particulars in the testimony of Mrs. Reed. That lady said, Mrs. Brantley was brought to our house in the month of December, 1870. She boarded with us, a prisoner, until her bond was made. I had frequent conversations with her during her stay, which was about 3 or 4 weeks. She frequently referred to Eskridge and spoke of him as a good and kind man. She expressed great sympathy and sorrow for him, and said that she could not believe he was the man who had killed her husband. She sent a newspaper by her brother, whom she called Bud, and told him to take it to him. She called no name. Her brother refused and said, "Oh, no, sis, I don't want to." She then entreated him and said, "Oh, take it, do. He is so lonesome and wants something to read." Bud put the paper in his pocket and went away. I saw a lady called Mrs. Eskridge while she was in Macon. She had a child with her named Morton. Mrs. Brantley was at my house at that time, and Eskridge was then in jail. The day before she left my house, she wrote a lengthy letter, was writing almost all day and nearly all night, and she was crying nearly all the time she was writing. In the afternoon of that day, she asked me to walk out with her, and I did so. While walking, we passed by the jail, and she asked me to point out the room which he occupied in the jail, and which window he could look out of. Soon after our return, she recommenced her writing, and took her writing materials out on the porch. She continued crying, and told me she was writing to a cousin of hers, who had not heard of her trouble. She wrote until dark. After supper, a neighbor came in, and in the course of conversation he spoke of a man by the name of Moore, who had been arrested and put in jail here. Mrs. Brantley joined in the conversation and seemed to be much interested. She inquired how it happened that Moore was so easily caught, and was told that he was detected by a peculiar watch key and chain that he wore. She continued her writing in my room until after midnight, having inquired first if it would disturb us, stating that she had a great deal of writing to do. She left my house the next morning, saying she was going to Chattanooga. Before leaving, she came into my room and laid the letter which she had written on the mantel, and asked me to deliver it to Mr. Reed, my husband, with the request that he would hand it to Colonel Dismux, her attorney. I took the letter from the mantel. It was unsealed and addressed upon the outside to Colonel E. Dismux. I opened and read it all. I am acquainted with the handwriting of Mrs. Brantley. It was her handwriting. I copied the letter and copied it carefully, word for word and letter for letter. Where a word was erased in the letter, I erased it in the copy I made, and it was, in all respects, a perfect copy. When I had copied it, I gave the letter to Mr. Reed. The copy which I made is now on file in the office of the clerk of the Circuit Court of Noxubee County. The letter to which the foregoing testimony alludes was enclosed in a sheet of paper upon which were written the following words: Colonel Dismux, will you be so kind as to hand this letter to, and oblige, yours truly, M.S. The whole manuscript was placed in a large envelope addressed to Colonel E. Dismux, and was delivered to him upon his calling and inquiring of Mr. Reed for it, saying that he received a telegram from Mrs. Brantley, requesting him to call for it. The full text of the letter is as follows. My own precious one, we did not come this morning as we expected. We were left. Oh, my darling! Oh, how painful, how cruel and agonizing it is to my poor, sad heart to be so I can almost hear you speak, but dare not go to you. Bud, footnote, Bud is the pet name of Mrs. Brantley's brother. Wants to see you, but I think it best he should not. He is perfectly willing for me to do everything in the world for you, and will assist in getting money for you. I am going to raise money for you, my own darling one, if I have to sell my land. You shall be released, cost what it may. I cannot live, my sweet one, if you have to suffer in this way, for you are suffering surely. But is willing for us, just as soon as we can raise the money, to go far away to some new state. And now, my precious one, promise me that when you are free, you will not stop until you are far, far away from this country. Do not, for God's sake, and your own loving D's. Footnote. D is Mrs. Brantley's signature, as used in her recent correspondence with Eskridge. Sake, try to see me. It will not do for us to see each other in this country, for you will be hunted down, and of course I will be wretched, for they will think that you will be somewhere near me. Oh, my heart's idol, is it not better for you not to see me for years? But it will not be that long. Oh, sweet one, I know you are crazy to see me, and it will almost kill you to have to live without seeing me. But it must not be. Promise, swear to me that you will not, that you will go far, far away from me. You know, my own darling, that I will join you as soon as it is prudent and safe for me to do so. I swear, so help me God, I will not rest one moment until I get my business in a condition so that I can meet you. You are my life, my all on earth. I love you, my own sweet one, more than life. I live for you, and I would die for you. Bless your precious soul. My darling, it would be a pleasure to die, if necessary, for one so sweet, so noble, so faithful and good as your own precious, loved self is. Oh, my darling, what is life to me without you? Nothing but a lonely, wretched, and miserable existence. You almost fill my every thought, every desire, and there cannot be any peace for my weary, anxious soul until you are free and I am with you. My dearest one, you must go far away into some new state and firmly bear our separation like a true man, with patience and cheerfulness, until I can join you. For I swear to you, my own loved one, that my soul, heart, and mind shall know no fear nor rest until I join you, and that I am coming to my own darling the moment I get the money. For we must have money. We cannot live without it, and I am going to have it at any sacrifice. I will sell the last thing I have on earth to raise it. I am fearful I will have to sue for my insurance policies before I can get that money, but is willing for us to leave this country. Indeed, he is very anxious to have us do so. He expresses a great deal of sympathy for you, my own sweet boy. We can find places where we can live unknown and in safety. The only trouble will be in your getting away. When you first leave here, my darling, you must be so cautious and prudent in traveling. I would not go where there are telegraphs. You will have to disguise yourself completely. Have nothing about you that could be recognized, not even your name. Oh, my precious one, I am so fearful that if you do get out, you will not be prudent or cautious enough. If you stay here and stand a trial, I am so fearful that they will do the worst they can against you. Oh, my precious one, will you promise your devoted Dee that you will trust to her undying love, her true sincerity and everlasting faithfulness and devotedness to you? That you will not give yourself any uneasiness about her, but rest assured that she loves you with a deathless love which the whole world cannot change, and that your D's every thought and hope is of you, and that she will employ every moment and bend every energy for you. Precious darling one, believe me, so help me God. Your D will join you even though you are in Europe or any other part of the world. Yes, my sweet, worshipped boy, I am coming to you or will die in the attempt. Oh, sweet one, will you take the advice of her whose very being and existence is centered in you? Sweetest, dearest, best of God's creation. Yes, darling, I am proud of your love, and thank God in the fullness of my heart for blessing me with such pure and faithful love as yours. You alone, darling one, can make me happy, and I will die 1,000 deaths before I will give you up. Yes, I first will sacrifice every earthly joy and pleasure, indeed all that is near and dear to me. My darling, I will remain in Chattanooga until I hear from you. You must destroy every letter I write you, for it would ruin us forever if they should be found. When you read my letters, do not let anyone see you. Oh, how my heart longs to be pressed to your faithful breast once more. It is cruel, almost wretchedly painful, to have to wait for that sweet, blessed hour when we will meet to part no more on earth. My darling, let us pray to God to reunite us, and for a Christian resignation to suffer patiently our separation until we can join each other in safety. God is merciful and good, and he will not deprive us of the greatest consolation we have on earth, although the dark clouds of hopeless despair hang threateningly over our gloomy pathway, and the sunshine of hope seems forever fled. In his own good time, he will bless us with peace and happiness. Many have suffered the same bitter trials and sorrows, such as we now endure, yet in the end have come out triumphant. So let us, my own darling, strengthen our hearts with new hopes, energies, and fortitude to bear all, and prepare ourselves with renewed vigor to conquer or die, to overcome all obstacles which would keep our hearts apart. Oh, my own sweet boy, if I could only feel that you will cast off all unhappy feelings, and cheer up, and endure your troubles like a brave and true man, I would be so much happier. So do be cheerful, my darling, and determined to be free. I almost die with all sorts of fears and misgivings concerning you. Will you do as I beg and entreat of you? And oh, believe and trust in your own devoted Dee's faithfulness and undying love for her own worshipped and idolized boy. There goes your dinner. Footnote: Eskridge's meals were sent to him from the house wherein Mrs. Brantley was writing. Oh, my darling, it recalls happy scenes of days gone, when we used to have our meals brought to us. It is almost more than my sad, aching heart can stand. And to think, darling, that the one I so intensely, so fondly, so madly love should be so cruelly and awfully treated. I would to God I had the power. Then my darling should be free, should not remain one moment more in that old hateful place. Oh, God, have mercy, and deliver my precious one from his enemies, and restore him, most gracious God, to her who will never, never know peace, nor happiness, nor rest until he is free. Precious, I have wept thousands of bitter tears over this letter. I write a while and cry a while. My darling, I am truly glad and delighted that footnote, M, Eskridge's wife, is to remain with you. It is just what she ought to do. It will be so consoling and cheering to you in your loneliness to have her who loves you and is so near to you, to your heart. Oh, my precious one, I sometimes feel that I am doing wrong in loving you, when your sweet and lovely wife, who should occupy your whole heart. I am sometimes fearful that God will not bless our love. Oh, if you could only forget me, and bestow all your heart's best and warmest affections upon her who, before God, is fully entitled to them. I sometimes think that it would be better for all if I were to go into a nunnery, and there is but one thing that keeps me from it, and that is my promise to you. My darling, try and keep M with you all the time, for it will be a great consolation to me to know that you have a loved one with you. Oh, would there was more for me! Yet all can see you but poor me. It is too bad, too cruel. Precious, I have heard so many lies since I returned to this place that it makes me hate and despise mankind. How can men tell such base, malicious lies? I do believe the old devil has been turned loose and has possession of most men. How I long to leave this country and go to some far distant one, where I will never hear of any person whom I ever knew. My darling, I am heartsick this evening. Your Dee looks 10 times older than when you saw her last. Grief and sorrow are leaving deep and lasting traces upon her brow and heart. Yes, all within is dark and lonely, desolate and wretched. Oh, what is life to me now? I would pray for death, darling, if it were not for you. I must live to save you, to help you to be free once more. I must live. I must suffer all, bear all, for your sweet sake. I will never give up the ship, but will struggle on with undying faith, hope, and energy until she is brought safely into port. Oh, my darling, you cannot feel more miserable than I, for although my poor feeble body is not imprisoned, yet my heart, soul, and thoughts are, for they are with you day and night, and your sufferings, griefs, and sorrows are all mine. Believe me, dearest, my spirit watches over you day and night. I am with you, always with you. Oh, darling, pray with your own Dee, that our Almighty Father to sustain you in your undertakings, and to restore you soon to the loving arms that are tremblingly awaiting to forever clasp around you. My darling, I could never pray with any faith or power before. My every breath is a prayer for my absent darling boy. Just as soon as I return to Chattanooga, I will send you my picture, which I will have taken. But you must be so careful with it. Keep it close to that heart, whereon I so often have lain my weary head. My darling, it seems impossible for me to stop writing to you. I will send you some papers for you to read in your lonely hours. Oh, how can I say farewell? How can I part with you? How can I leave my sweet one? I have almost cried my eyes out. Indeed, they are so weak from crying, I am uneasy about them. Write to your own D. 5 o'clock. My loved one, since I returned this evening from a walk in which I had to pass the dark and gloomy walls wherein the idol of my heart is confined, I feel that death would be to me a blessing. O merciful God, to think the idol of my soul should be cruelly and wrongfully shut up in that gloomy. Oh, it will kill me. The very thought is maddening. I must leave this place, or I certainly will go mad. Yes, mad, if I remain a week longer. It is more than my poor grief-stricken heart can bear. I am weeping the most painful, the most bitter tears I ever shed in my life. Now, while I am writing, did you ever see your D as she passed by? Oh, I can never tell you the agony I felt. I have had sorrow, but never in all my life have I suffered such painful, excruciating grief as I now am suffering for you. My darling, all say to me that I am free from all my troubles, that I should be very happy. Dearest one, they know not what they say. They know not the utter desolation and wretchedness, the imperishable grief that fills my soul. They know not that all my earthly happiness, nay, my very life and existence, are confined in that gloomy prison. I cannot live if you are not released. I shall go crazy or will die. I truly believe I have been almost insane all day. Oh, my darling, why did you not write your D one sweet line today, to cheer and console her poor heart? I know you have with you those who love you fondly, and I will not be selfish. God bless dear little Morton. Footnote. Morton is Eskridge's little son. How truly I love him, for he is my darling's child, and his children are dearer to me than all others. How much I would love to have him with me, and darling, as long as I have a cent, I will share it freely with your loved ones, for they are mine also. It would kill me to learn that they ever suffered while I have a cent left. Precious, I am going to try to sell my land, so that we will have money enough to buy us all a home in some distant new state. Should you get out, let me beg of you to wear nothing whatever that you have worn before, not even your sleeve buttons. Do not have any baggage that you have with you now, for if you do, you will be described, and it may be the means of your recapture, as were the things of Moore. He was discovered by a key upon his watch chain. See what little things will do. Oh, how can I stop writing? For it is my only pleasure and comfort. When you write me, direct your letters like the others, except do not put on them strictly private, as it may cause suspicion. Try and disguise the backing of your letters, as they may have found out your handwriting in the office here. Give all your letters to Dismux to put in the office. My loved one, write to your D soon. God bless you and our dear loved ones. Ever yours until death, D. It is now a well-known fact that at the date of these occurrences, the prison discipline in some of the southern states was of an exceedingly loose and uncertain character. The officers of justice were those least competent to serve as such, and in some instances, even the bench was in the custody of persons without honesty or reputation. It is not to be wondered at, then, that this beautiful woman, who was so madly in earnest, should have found an official ear willing to listen to her entreaties. Little surprise was manifested when the fact was made public that the cell of Eskridge was mysteriously vacant, that the prisoner had gone, no one knew whither. The extent of Mrs. Brantley's complicity with the murder was not then known, nor was it generally credited, and those who did suspect such a thing possible were willing to excuse or justify it. Not only was Mrs. Brantley the charming woman we have described, but her husband was known in the locality as a miserable vagabond and a fugitive from justice. It was no wonder that she could not mourn a loss which was merely nominal, not real. The criminal proceedings against her were quietly abandoned, and she then only needed to return to Selma for the furtherance of her plans and to notify the insurance companies of her claims against them. This she did through her counselor, General Morgan. Without delay, legal steps were taken by her attorney for the recovery of the sum insured, which action resulted in the disclosure of the plot, culminating in the tragic manner we have related. So overwhelming was the evidence produced by the Travelers Insurance Company in defending the suit. The plaintiff saw that her cause was not only hopelessly lost, but that her liberty and perhaps her life was endangered. A discontinuance of the suit stopped the introduction of further evidence, and the plaintiff disappeared from public gaze. For a long time, her whereabouts was a profound mystery, known only to her legal advisers, if at all times it was known even to them. The developments resulting from the insurance suit occasioned further steps to be taken for the recapture of Eskridge, and finally he was discovered and arrested in Texas, whence he was brought back to Mississippi, where he was tried for the murder of Brantley, and upon being found guilty was sentenced to be executed. That the extreme penalty of the law would have been carried into effect, there is no reasonable doubt. But during the governor's temporary absence from the state, a pardon was obtained from the Negro lieutenant governor. It is generally believed that a bribe of $500 was the price paid for Eskridge's pardon. We have no positive evidence that such or any sum was paid. Our only reason for discrediting such a rumor is that so large a sum as $500 was regarded necessary to purchase a pardon from the official who granted it. End of section 52. Section 53 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies. An authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Homicide, Part 30, The Hunter-Armstrong Tragedy. Benjamin Hunter was a man who stood well in business circles in Philadelphia, and who had accumulated money in the kitchen range and boiler manufacture. He was respected in the church of which he was a member, and was said to be a kind and affectionate husband and father. An old personal friend, John M. Armstrong, a slender, good-looking man, rather deaf, about 40 years of age, who was engaged in the music publishing business, induced Hunter to invest money in his business as a special partner. When this association was dissolved by limitation, Armstrong was in Hunter's debt to an amount exceeding $7,000. The undertaking turned out unsuccessfully, and Hunter complained bitterly that Armstrong had lived in a style beyond his means, that he avoided and slighted his creditor, and evinced no disposition to meet his indebtedness. Hunter, who was noted for his avaricious spirit, brooded over the loss till he conceived what he termed a deep-laid plot to insure Armstrong's life in his own behalf for a large sum, much larger, as afterward appeared, than the amount of the obligation, and eventually compass his premature death. He proceeded to carry this villainous design into execution by taking out the following policies on the life of Armstrong: one for $10,000 in the Manhattan Life, one for $10,000 in the Mutual Life of New York, and one for $6,000 in the Provident Life and Trust of Philadelphia. Armstrong was too deaf to catch the mention of these sums at the offices, and Hunter told him that the total insurance was only $7,500, just enough to cover the amount of his indebtedness, and thus disarm suspicion. Hunter's next step was to procure an assassin for his victim, and he found one in Thomas Graham, a dissolute fellow, formerly his apprentice, who consented to do the deed for $500. Hunter took a journey to Virginia, with the understanding that the murder was to be accomplished while he was away. But nothing was effected during his absence, Graham becoming chicken-hearted and infirm of purpose, and he found that he himself would have to take a direct and active hand in the work of assassination. He forged on a postal card a message from Ford W. Davis of Camden, the New Jersey city on the opposite shore of the Delaware River, to Armstrong, inviting the latter to visit him, Davis, in that town to receive money in payment of a debt due to him. Armstrong caught at the bait, and Hunter and Graham accompanied him. Before leaving, Armstrong sent a note to his wife informing her that he would not be at home to take tea that evening, as he was going to Camden with Hunter and Graham to receive some money. This was January 23rd, 1878, 7 weeks after Hunter had taken out the policies on Armstrong's life. Hunter had bought a new felt hat and a hatchet, and muffled himself up so as to be unrecognizable. Graham was provided with a hammer, on the handle of which, as well as that of the hatchet, were cut the initials FWD, implying a design to throw suspicion on Ford W. Davis, against whom he owed a grudge, and whom he was willing to see convicted and punished for his own crime, for which every preparation had now been thoughtfully and carefully made. When the victim reached the corner of Fifth and Vine Streets, Camden, near Ford's residence, Hunter gave the signal by uttering the word "yes," which the deaf Armstrong did not hear, but which brought Graham, who had slunk behind, up to the work, and he felled Armstrong to the earth with his hammer. As he sank beneath the force of the blow, he turned on Graham such a look of pitiful appealing and distress that the assassin, pierced to the heart with remorse, threw away his murderous instrument, turned and fled in horror. But Hunter, a bolder and more hardened wretch, completed the butchery by smashing the victim's skull with his hatchet. The assassins met again at the ferry, where, in answer to Graham's anxious inquiry, Hunter replied, "I finished him." Graham received $10 on account from Hunter as payment for the part he had taken in the murder. When Armstrong was found on the sidewalk, he was insensible. He was taken to his home in Philadelphia. The hammer on which the initials were cut was picked up, and Ford W. Davis was arrested. James P. Demaris, another resident of Camden, likewise involved in business complications with Armstrong, was also imprisoned on the same charge, as an express driver testified that he saw two men running away on the fatal night from the scene of the murder. The appearances against them were dark and menacing. At daybreak, after the night in which Armstrong was struck down, his son Frank, prompted by the note his father had sent the evening previous, called on Hunter for an explanation. But Hunter declared that he had not been at Camden on the night before, and that if Armstrong had written that he was going there with him, he was covered with lies from head to foot. Hunter went soon after to the shop of one Peter Epp to request him to go with him to repair a boiler, and as they were on their way, begged him as a favor because a man had been hurt at Camden, where he had been the night previous, to state that he, Hunter, had been at his place at that time, lest his wife should be angry with him and he should be brought into discredit in his church. Epp, who is said to have been a decent mechanic, was foolish enough to comply with the request. Then came a climax which revealed the fiendish and revolting cruelty of Hunter. After calling at Armstrong's with Epp to force his alibi on the family, he returned later in the day and quietly entered the room in which the dying man lay. The wounds had been staunched and carefully bandaged, and the sufferer was lying unconscious on the bed. Mrs. Smith, an old friend of the family, acting as nurse, was the only other person in the room, the doctor having just gone. Hunter, seizing the opportunity, said blandly to Mrs. Smith that he would see to Armstrong and relieve her for a little while, urging her to go down and comfort Mrs. Armstrong. Mrs. Smith left the room. In a few minutes she returned. She saw, to her horror, that there was a complete and terrible change in the dying man. His body was in a violent tremor. He was moaning and his wounds were bleeding afresh. In the excitement, Hunter said he would go for a doctor and left the house. It was then discovered that the bandages had been torn from the murdered man's head, and that a clean napkin, which had just been placed over it, had been taken away. Fearful lest Armstrong might be so far restored to consciousness as to reveal the name of the murderers, the miscreant had torn open the wounds he had made, and thus rendered his victim's death certain and speedy. A few days after Armstrong's death, Hunter accepted an invitation to go to New Jersey to give important testimony in the case, but was not permitted to return home. The suspicions against him, however, being mainly based on the fact of his holding the large insurance on Armstrong's life and his excessive eagerness to divert attention from himself. As the chain of evidence grew stronger, Davis and Damaris were released, and Hunter was bound over on the charge of murder. Thomas Graham was next suspected as an accomplice and was shadowed by the police for many weeks, a detective obtaining rooms in the house where Graham boarded. Enough was learned to warrant Graham's arrest, and on the 19th of March, 2 months after the murder, he was taken over to Camden, where he made a full confession of the deed. He recited Hunter's proposition to him to murder Armstrong, for which he, Graham, was to receive $500. How the conspiracy failed on one occasion, how on the fatal night Hunter, wearing a new felt hat and with his face muffled, went in company with Armstrong to Camden, Graham following them with the hammer, which Hunter provided him with, and how at the corner of 5th and Vine Streets, Hunter gave him the signal for the attack. Graham then claimed that after he struck the first blow, his heart failed him on seeing the distressed and reproachful look of astonishment on the face of their helpless victim, and he then threw down the weapon and ran away, leaving Hunter and the victim in the darkness. Soon afterward, Hunter joined him at the ferry and informed him that he, Hunter, had finished him. Both then crossed the river and separated in Philadelphia. After this confession, a true bill was found against Hunter, and on the 10th of June, he was brought to trial. Testimony which was clear and conclusive showed that Hunter not only murderously assaulted his victim in the streets of Camden, and by cutting the initials on the weapon sought to involve an innocent man, but that he also went to Armstrong's house in the character of a friend on the day after the assault and tampered with the wounds on the head of the dying man, who was still insensible, causing them to open afresh. His counsel made great efforts to prove an alibi, but they broke down, and on the 3rd of July, Hunter was convicted of murder in the first degree. Although the jury remained out nearly 3 hours, it was subsequently reported by some of them that they would have convicted the accused without leaving the box, had they not dreaded the ensuing excitement. The insurance motive, the purpose to profit by insurance contingent upon the life of Armstrong, was clearly pointed out in the course of the summary of the public prosecutor, Mr. Jenkins, who said, Benjamin Hunter, the defendant, had obtained an insurance of $26,000 on the life of John M. Armstrong, and this fact we contend furnishes the motive which led to the murder. The defendant was not a rich man at that time by any means, as it has been shown to you in this case. His property was only valued at $32,000, while his income merely amounted to about $2,200. His taxes, the interest on his mortgages and his water rents, amounted to $750, and the premiums on these policies amounted to something like $1,000 or $1,100, which, after being deducted from the amount of his income, would only leave him about $500 a year upon which to support his family. He had a large family, and this sum was apparently insufficient to support them in the style in which they had been living. He had his carriage and his horse. He had his servants, and he had his house to maintain. And $500 was too small with which to meet the expenses of his expensive household. It would have taken $3,000 a year at least. He had retired from business and had been living in style. It is a hard matter for those who have been accustomed to the luxuries of this world to retrench those expenses which are necessary for the purpose of affording them. It is an easy matter for a poor man to become still poorer, but it is hard for a rich man to give up his accustomed way of living. And this is the experience of all of us in this age in which we live. Benjamin Hunter told you that Mr. Armstrong understood thoroughly that the policies of insurance to the amount of $26,000 were to be taken out upon his life by him. He stated that they had a conversation together about this matter, and that Mr. Armstrong understood it thoroughly. But from the testimony of Mr. Van Oxen, it is apparent to you that Mr. Armstrong did not thoroughly understand the negotiation of this insurance. John M. Armstrong had no idea that the defendant was intending to procure $26,000 insurance. But when he went to the New York Mutual Life Insurance Company in Philadelphia to be examined and told by Mr. Van Oxen that the policy to be taken out was only for the sum of $2,500, Mr. Van Oxen asked him, "No more?" And he replied, "No, $2,500. Armstrong was not so big a fool as this defendant would have you believe. He understood his business, and he knew that he did not want $26,000 of insurance upon his life when he only owed the defendant $6,000 or $7,000. What, then, was the object the defendant had in taking out that amount of insurance upon his life? If Mr. Armstrong had lived the length of time for which these policies were taken out, the aggregate of premiums would have amounted to more than the several policies combined. These policies of insurance were a heavy load for the defendant to carry, but he tells you that his sole object in taking out these policies of insurance was for the purpose of benefiting the creditors of Mr. Armstrong. Was ever such an idea conceived, that he intended to pay $1,000 a year for the space of 20 years in order to satisfy the creditors of John M. Armstrong? He was confident, and he thought he knew that he could claim every cent of this money at the death of Mr. Armstrong. In fact, he even went so far as to ask Mr. Ashbrook, the agent of one of these insurance companies, to have the policy made out in such a way that he could collect it immediately after the death of Mr. Armstrong. And then, after his death, what do we see the defendant doing? 3 days after John M. Armstrong died, we find this defendant placing that policy in the hands of a lawyer for the purpose of having it collected. I say, therefore, that the state in this case has shown a very strong motive to lead the defendant to commit this murder. Remember also that Mr. Hunter was one of the best friends in the family of Mr. Armstrong. He was continually loaning Mr. Armstrong money, but he was always well secured. After his conviction, strenuous efforts were made to save the wretch's life. Judge Woodhull overruled a motion for a new trial. Hunter was ably pleaded for before the Court of Errors and Appeals. The great influence brought to bear on Governor McClellan proved unavailing, and Hunter was doomed to pay the penalty of his crime. When Hunter found that his sentence would certainly be executed, he showed, in an attempt to commit suicide, the same resolute cunning and unflinching determination he had displayed in murdering Armstrong. While chatting, joking and laughing in his cage in Camden jail, with his keeper Nissen, and smoking his cigar with an air of sang-froid, he managed, under the pretense of rubbing his feet and ankles under a piece of carpet to keep them warm, to cut the arteries of his instep with a sharp, ragged piece of tin, filling the spittoon under him with blood, and had he not been handcuffed and a doctor called in to stop the hemorrhage, he would have bled to death. He became very weak from loss of blood and refused to eat, and was kept alive by stimulants. His pulse at various times was as high as 180. As the time approached for execution, efforts were made to overcome extreme nervous prostration by pouring down copious draughts of brandy. But being utterly helpless and unable to walk, he was carried to the enclosure, oblivious to all surroundings. At 11:25 a.m., the sheriff cut the auxiliary rope, and here occurred a sickening spectacle. The rope either had too much slack or gave way so much that it lifted the culprit barely from the floor, when he fell back and was caught by the assistants. Sheriff Calhoun seized the rope leading to the basement and hoisted Hunter into the air, and he was hung only by a number of persons holding to the rope during the whole time of suspension. The physician said that his neck was not broken, and he died by strangulation. Thus ignominiously perished the victim of his own insatiable avarice. His greed tempted him to commit murder, and his meanness toward his accomplice led to his betrayal. His excessive confidence in his own cunning helped to complete his ruin. He persisted in trying to deceive his own counsel till it was too late for them to save him. Had he confided the facts to them at first, they would doubtless have sent Graham out of the way of arrest. Hunter's attempt to rectify the blunder by bribing monks with $200 to poison Graham in prison was a piece of folly from which his counsel found it hard to dissuade him. Monks would have kept the money and betrayed him sooner than Graham did. Hunter, it is said, expressed no contrition for the murder he had committed, but quite broke down when its effects on his family. his wife and children, was presented to his mind. The love of one's own is a feeling cherished even by the most brutal natures, and its exhibition on the part of this wretch was the one bright spot in the picture on a background of revolting depravity. Looking back upon this burlesque on judicial forms of execution, and upon the mental anguish and physical suffering which attended the last days of Hunter, the majesty of offended justice, it would seem, could have demanded nothing more in the way of satisfaction. If the vindication of law meant that the hangman's rope must be preceded by the helpless torture of suspense, the hopeless agony of disappointment, the desire without the capacity of self-destruction, the inexpressible woe of a wrecked and crushed spirit, and the maddening remorse and horror of the closing hours, violated law had nothing more to ask. In the course of his fragmentary confessions, Hunter said, "Armstrong thought I had but $2,500 in each of the 3 insurance companies, and this would have covered his indebtedness to me. I had him insured for $26,000 without his knowing it. I had queer thoughts concerning him then, but I had no idea of killing him. It was that cursed insurance did it all. That put the thought in my head and kept it there, and that impelled me, I know not how, to do what I did. It was not that insurance is a curse, except in its falsification or illegitimate misuse. The bread which sustains the body, and the bread of eternal life which sustains the soul, may be perverted to base uses. The curse was in a nature which, when unmasked, exhibits a degree of inherent debasement that seems to have been unsuspected by his neighbors. To outward appearance he was a respectable, well-behaved, law-abiding, church-going citizen. He was revealed as a demon of avarice, a monster of iniquity, a felon at heart waiting only for the opportunity to strike his victim. One would think that in deliberately scheming to kill his friend in order to make money by his death, he had reached the depths of fiendishness. But he went further. There was a lower deep. He plotted the ruin and probably the conviction on circumstantial evidence of an innocent man, Ford W. Davis. He forged a chain of evidence which so seriously implicated Davis as almost to afford presumptive proof against him. He employed Graham as a bribed assassin, and had it not been for the hireling's confession, Hunter could have seen either of them hung without wincing and without remorse. Society could not at first comprehend how a man with so fair an exterior could reveal such immeasurable outlawry and ruffianism. But society now knows that the most abandoned criminal could not have shown more coolness and cunning in the execution of his plans. As to the accomplice, Thomas Graham, public sentiment was against conviction of murder in the first degree, because as Hunter was convicted mainly on Graham's testimony, it was felt that no one would be likely thereafter to turn state's evidence in New Jersey, and thereby fatally incriminate himself. The question was not whether Graham deserved hanging, but whether in view of the use the state made of him, and of universal custom, it would be wise or just to hang him. Under advice, Graham pleaded guilty of murder in the second degree, and was sentenced November 24, 1879, by the Supreme Court at Trenton to 20 years at hard labor in the state prison. Chief Justice Beasley, in pronouncing sentence, said it was only from motives of public policy, in view of the valuable evidence furnished by Graham, that the plea was accepted. He served his time, which was shortened by good conduct, and was released from prison August 15, 1893. In May 1882, Armstrong's heirs brought suit to recover the amount of insurance placed on his life at the instigation of Hunter. A test was made in the United States Circuit Court, Eastern District of New York, against the Mutual Life Insurance Company. Before the policies were issued, Armstrong had executed an assignment to Hunter of all policies that might be issued. The former, therefore, according to well-settled legal principles, had no interest in an insurance which was the sole property of his murderer. When Hunter was convicted of his crime and paid the penalty on the gallows, it was generally supposed that the anticipated profits of his fraud perished with him, and that any attempt to collect the money in behalf of his estate would meet with summary failure. But this attempt to recover the money in behalf of the murdered man's family raised strange questions in ethics as well as in law. Public policy demands that fraud should defeat a contract, whether it be the destruction of insured property or insured life. Is that policy changed in respect to the sufferer from the fraud? Public policy is certainly against recognition of a contract consummated for purposes of fraud. Any other position would allow the heirs to connive with swindlers and defeat the whole object of the law. If the insurers are liable, it must be on the assumed grounds of a criminal negligence, which furnishes the temptation for the murder. But such an action should be of the nature of damages and not under a policy. There is a rude sense of justice that would decree to the innocent sufferers the proceeds of the policies which tempted the crime, but broader principles of law and ethics would seem to forbid that money like this should be collected at all in the interest of either party. The company resisted payment on the ground of attempted fraud by Hunter. The counsel for the plaintiff contended that the promise of the policy was twofold: to pay a sum of money to Armstrong in 20 years, or to his legal representative if he should die within that time. The assignment to Hunter carried only the right to the money if Armstrong lived 20 years. It did not convey the death claim. The counsel also claimed that the evil designs of Hunter could not affect the validity of the policy. The court adopted this view and held that any evidence of Hunter's fraud must be excluded. There was no evidence in the case of an attempt to defraud on the part of Armstrong, nor was any offered to be shown by the defendant. In the opinion given by Judge Wheeler, it was held, among other things, that peril evidence was not admissible to vary the language of the contract by showing that the real contract was with Hunter, that the administrator of Armstrong was his legal representative and was entitled to recover the amount in the absence of sufficient ground to defeat a recovery, that the right to receive the money in case of previous death, the policy was an endowment, did not pass by the assignment, but was left in Armstrong and accrued to his representative who, as Armstrong was an innocent party, was entitled to recover, notwithstanding the fraud of Hunter. The judgment was reversed on appeal to the Supreme Court of the United States. The Mutual Life Insurance Company of New York, plaintiff in error, versus John M. Armstrong, deceased April 5, 1886. Justice Field closed a lengthy review of the points in the case in the following language. Wherever the intent or guilty knowledge of a party is a material ingredient in the issue of a cause, collateral facts tending to establish such intent or knowledge are proper evidence. In many cases of fraud, it would be otherwise impossible satisfactorily to establish the true nature and character of the act. The evidence offered that Hunter obtained insurances in other companies on the life of Armstrong at or near the same time was, under these authorities, clearly admissible. It tended to establish the theory of the defendant that the insurance in this case was obtained by Hunter upon the premeditated purpose to cheat and defraud the company. Especially would it have had that effect if followed by proof of the manner of the death of Armstrong. But independently of any proof of the motives of Hunter in obtaining the policy, and even assuming that they were just and proper, he forfeited all rights under it when, to secure its immediate payment, he murdered the assured. It would be a reproach to the jurisprudence of the country if one could recover insurance money payable on the death of a party whose life he had feloniously taken. As well might he recover insurance money upon a building that he had willfully fired. This view renders it unnecessary to consider the effect upon the policy of the statements made in the application of the assured as to the amount of other insurance on his life. In thus determining the invalidity of the claim of the widow, Mrs. Julia Armstrong, the highest court in the land says in substance that a life insurance effected at the instance and for the benefit of a man with murder in his heart, the premium being paid by that man, the policy delivered to that man, and the murder a short time afterwards committed by that man, shall not be made available for the benefit of a person who was a nominal but not an actual party to the transaction, available for anybody in fact. End of section 53. Section 54 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies. An authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Homicide, Part 31, Meyer, with Many Aliases, Part 1. The case of the people of the state of New York against Henry C.W. Meyer, with numerous aliases, was tried in the court of Oyer and Terminer, before Judge George C. Barrett and a jury, in December 1893. The charge was the murder by poisoning of Ludwig Brandt, who had been insured under the name of Gustav Heinrich Maria Joseph Baum in the following companies: Washington Life, $3,000, Mutual Life of New York, $3,500, New York Life, $1,000, Aetna Life, $1,000. The beneficiary was Meyer's wife, who, in pursuance of fraudulent intent, went through the form of a marriage ceremony with Baum, according to the testimony of Reverend F.E. Werner of Chicago in February 1891, passing herself off as Emily Rather, the name of a niece of Meyer in Ovenstadt, Germany. Near the close of the trial, while the counsel were summing up the testimony, one of the jurors became insane. This unfortunate incident abruptly stopped the proceedings. A second trial took place in April and May 1894 in the Court of General Sessions before Recorder Frederick Smith, and Meyer was convicted of murder in the second degree. The jury stood a long time, 11-1, but the one juror obstinately held out against conviction in the first degree, and the rest finally yielded to his dominating influence. Yet Recorder Smith's charge to the jury was strongly to the effect that it could not bring in any other verdict than murder in the first degree. The man who was thus placed behind prison bars, instead of being led to judicial execution and ignominiously yielding up a life which had several times in succession been forfeited, had occupied an unusual degree of attention on the part of the sensational newspaper reporter. Whole columns of leading papers had been filled with recitals of Meyer's plots and counterplots, his forgeries and marriages, his murderous plans and methods, his aliases and disguises and false personations, his skill in poisoning with antimony, his cold-blooded and brutal disregard of the lives of his victims, his dexterity in the management of accomplices, and the ingenious reinforcement of the principal confederate, the she-devil who passed as his wife. In the extended and comprehensive investigations, patiently and intelligently conducted on the part of the Mutual Life Insurance Company by the former manager of the Department of Medical Revision, Mr. D.G. Gillette, and his associate, the present manager, Mr. H.G. Julian, it was learned that Meyer, in the course of his criminal career, had killed at least 7 persons: Mary Kirchhoff, Henry Gelderman, Master Meyer, Baby Gelderman, G.H.M.J. Baum, the real Baum, Indiana Maggie, and Ludwig Brand, and that at least 3 escaped after he had commenced his poisoning operations: Mrs. Gelderman, Klaus Dressen, and Mary Nice. It was also learned that Meyer's schemes included robbery of others, as well as of the life companies. He was after a large estate in the Rhine region of Germany, of which the real Baum was the only heir. This fugitive and shiftless wanderer was the sole representative of a very wealthy family in Cologne, and Meyer's game was to impose upon the family his own wife, or reputed wife, Mary Dressen, and her child, as the widow and child of Baum, and thereby entitled to the inheritance. If he could prove collection of insurance money on Baum's life, it would go far toward establishing the question of identity and supporting the alleged widow's claim to the Cologne estate. One of the remarkable features of this case is the ingenuity with which for years Meyer eluded and baffled the detectives. At times he was audacious enough to return to the scene of his criminal operations and deceive the police, who were trying to run him down by his very boldness and unconcerned demeanor. His favorite toxic weapons were antimony and croton oil, which he gave in small doses, repeated after brief intervals, continuously for weeks, so as to stimulate natural morbific conditions, and thereby throw dust into the eyes of physicians who were summoned in attendance. Meyer's biographers tell us that in 1893 he was 35 years of age, that he came from Minden, Prussia, that he graduated from the Homeopathic Medical College in Chicago in 1878, and that he practiced medicine for a period of 10 years on the north side of that city. His first wife died soon after he began the practice of medicine, under circumstances which many believe indicate that she was poisoned. Soon after this he was tried for the murder by poison of a wealthy north side grocer named Gelderman. He was acquitted, and soon after married Gelderman's widow, who was worth $30,000. Shortly after the marriage, he was charged with the murder of his wife's son. On this trial, he was also acquitted. Not long afterwards, his wife was found to be suffering from a wrecked constitution. Suspecting mischief, she left Meyer and procured a divorce, and she claims to this day that he attempted her life by poison. A little later, about the year 1888, he met and married his present wife, whose maiden name was Dressen. She was the daughter of a thrifty, elderly German of the north side, Klaus Dressen, who had accumulated considerable property. One day it was discovered that the old gentleman's name had been forged to an application for a heavy life insurance in the Germania Company. It was easy enough to point to the forger. Meyer at once disappeared, but was traced to Denver, whence he was brought back, committed to jail, in due time tried for forgery, and, with the peculiar luck which invariably attended him, was acquitted. His brief incarceration in prison, and certain parties he met there, largely influenced and governed his subsequent career. From the opening address of Assistant District Attorney McIntyre when the trial was resumed, April 26, 1894, and from the memoranda of Mr. Julian, we obtain the following details of his checkered course of life. In March 1890, a man was confined in the jails of Cook County, the county which embraces the city of Chicago, who was known as Karl Kerfel, afterwards as Karl Muller, and at another time as August Wummers. This man Muller, known also as Wummers and Kerfel, was charged by the United States authorities with violating the postal laws of the government. He personated a young woman, representing herself as desirous of obtaining a husband, and for that little pleasantry, in the way of correspondence, the post office authorities charged him with improperly using the mails. He was apprehended and thrown into the Cook County Jail. When the time came to hear the indictment, the records show that he pleaded guilty. Thereupon, the presiding judge of the federal court imposed upon him a sentence of 1 year in the Joliet prison. While Muller was confined in the Cook County Jail, awaiting sentence, certain other persons were thrown into that jail. Among them, a man known as Gustav Joseph Heinrich Marie Baum, to whom reference has already been made. Also, a professional thief known as Jack W. Gardner, or Chicago Jack. Also a man charged with an attempt to defraud some editors of Scandinavian journals, whose name was Ludwig Brand. Also Brand's relentless fate in the shape of Dr. Meyer. Here these kindred spirits met, and acquaintance soon ripened into intimacy. It is said by the Chicago police that Meyer and Gardner concocted a scheme by which they were to have Baum's life insured, then take him out in an open boat on Lake Michigan, ply him with whiskey doctored with nitroglycerin in quantity sufficient to produce symptoms similar to those of sunstroke, and they would then return to shore and get a physician to certify to death by sunstroke. One day Meyer asked his newly found friend Muller, "What are you here for?" Muller said in reply that he had violated the postal laws of the federal government, that he had advertised in Western newspapers that he was a beautiful young woman desirous of meeting a man who wished to engage in matrimony, and as a result of the advertisement, farmers in the far west communicated with him, that on receipt of their communications he would write that he would go to them, provided they would send means by which he could pay his railroad fare. And for that, the post office officials got after him and caused his arrest. He added that when brought to the bar to answer the indictment against him, he would plead guilty and ask for leniency at the hands of the court. Meyer then retorted, "There is no money in such small business, no money in impersonating a young woman and defrauding farmers out of paltry sums. But I can give you a scheme out of which you will make fabulous sums, and if you will join me in a scheme that I can suggest, the day will not be far distant when you will become possessed of a large amount of worldly goods." "What is your scheme?" asked Muller. "Why," said Meyer, "I want you to enter into a plan by which we can swindle the life insurance companies doing business in this city. They can easily be swindled if you follow my suggestions and take my advice." "Well," Muller said, "I can't do that just now. I am about to plead guilty, and I will be sentenced." "Yes," replied Meyer, "but your sentence will not be one of long duration, because, in consideration of the plea that you are going to enter, the court will be lenient with you. At all events, after you serve the sentence which the court may see fit to impose upon you, I will be in the city of Chicago again, practicing my profession. Look me up in the directory of that city. Come to see me, and we will talk the scheme over." Muller's sentence dated from the 1st of August, 1890. Simultaneously, Gustav Baum was sentenced for a period of 1 year in the Joliet prison, while Ludwig Brand was sentenced to a shorter term of imprisonment and discharged before the expiration of the terms which had been imposed upon Muller and Baum. Meanwhile, Meyer was released and left the prison in the month of May or June 1890. He returned to Chicago and there resumed the practice of his profession. But before reaching Chicago, he stopped for a brief period at a place called Ravenswood, a suburban annex of Chicago. Then he took a residence and an office at 331 Center Street, Chicago. From the time that he left prison to the 29th of May, 1891, Meyer did not see Karl Muller. He and his wife frequently visited the Joliet prison to see and talk with Gustav Baum, but they avoided seeing Muller. On the 29th of May, 1891, the latter's term was completed, and he immediately returned to Chicago and went to 190 12th Street. On the 5th of June, Muller looked up Meyer's address in the directory, found that he was living at 331 Center Street, called upon him there, told him that he had just been liberated from Joliet prison and that he was in dire distress and needed money, being practically penniless. Meyer handed him some money for his immediate needs. Afterward, Muller called again at Meyer's office and returned the borrowed money. While there, Meyer said, "Muller, what are you doing now?" "Nothing," said he. "I am not doing anything." Meyer asked, "Are you still willing to go into a scheme with me to defraud life insurance companies?" Muller replied that he had just got out of a difficulty and was not desirous of again putting his neck in the halter. That if Meyer had a swindling scheme on hand, he would rather not take part in it. One day in the following month, Meyer called on Muller at his room in 12th Street and asked him what he was doing to make a living. Muller replied, "I am working about houses of ill repute. I am a musician. I am playing the piano in houses of that character." "But there is no money in that," said Meyer. "Why don't you join me and enter into a scheme by which we can defraud life insurance companies? And I will promise and guarantee that you will make money that will take you far from the poverty line." "What is your scheme?" said Muller. "Simple enough," was the answer. "As I said to you in the Cook County Jail, life insurance companies can easily be deceived and easily defrauded. I will get someone to go and have his life insured. I will have the policies written on his life. I will ultimately get control of these policies. I will make it appear that the subject described in the policies has died. And then we will go and collect the money due on the policies, and you and I will divide it." Muller said, "No, that won't do, Dr. Meyer. The insurance companies will discover that scheme. They will want some identification of the person who died. They will require the certificate of some physician. No, that scheme will never go." "Well, I have other ways," said Meyer. "I have methods by which I can deceive any life insurance company." And he added that he would unravel his plans at some future interview. Muller removed to 4th Avenue, and one night while walking in Lincoln Park, he met a woman named Lena Kaufman. They walked together to the house of Meyer, and Muller introduced Lena Kaufman to Meyer. A conversation ensued about conspiracies to defraud life insurance companies, during which Ludwig Brand appeared. "Do you remember that man?" asked Meyer. "Why, that is Brandt. He was in jail with us." Muller looked at him steadily and said, "Yes, I remember him." "Well," said Meyer, "that man will do anything I tell him to do. Off and on, he resides with me. I maintain him, I care for him, I support him. He is devil-may-care in his habits. He is no good to me." He did not acknowledge then that he was about to insure Ludwig Brand. Brandt, by the way, was a Norwegian of good family who had come to this country 7 or 8 years before. He was a man of considerable ability and had been a reporter on a Norwegian paper in the city of New York. He was recklessly indiscreet and addicted to faults and follies which eventually cost him his place. He drifted westward and in the course of time took up with Meyer. He was remarkable for physical vigor, but his mind was completely under the magnetic or hypnotic control of the master. Dr. and Mrs. Meyer knew that Brant was infatuated with Mrs. Meyer, and that he would do anything at her command or to please her. After the meeting at which Lena Kaufman was present, and Brant not far away, Meyer and Muller had frequent consultations at 157 Randolph Street. One day the former inquired whether Muller had seen Baum while in the Cook County Jail. Muller said no. He was kept in one part of the prison and I was confined in another. We never had an opportunity to communicate together, but just before I was about to go, I did see Baum for an instant. How did he look to you? How was his apparent health? Did he seem physically strong or did he look weak? Oh, said Muller, he looked sickly and weak. True, said Meyer, because when I and my wife visited him in Joliet, we noticed that he was in a weakly condition. Do you think he is going to live long? I can't tell, said Muller, and they parted. In the month of August, the couple met again, and Meyer said, Muller, Gustav Baum is in trouble again. He went to Cincinnati and there committed a forgery, and he is held under that charge. Well, what of that? Said Muller. Why, I must go and get him out of the scrape if I can, said Meyer. I will go and see Gustav Baum in the Cincinnati jail and try to liberate him. I will have Ludwig Brandt insured in New York companies under the name of Gustav Heinrich Joseph Marie Baum. I will go and talk with Baum and find out from him all about his birth and antecedents and the genealogy of his family. Having his family record, no insurance company can get on to my scheme. Meyer, accordingly, in company with his wife, went to Cincinnati and had an interview in the jail with Baum. He interrogated Baum concerning his family history, ascertained when and where he was born, where he had lived, etc. On his return to Chicago, he interviewed Muller and said, Now the time is ripe. I am going to Europe. I am going to possess myself of certain evidences, so that when the time comes to defraud the insurance companies, I will be so fortified that there will be no room for doubt. After serving his term in the jail at Cincinnati, Baum, according to one report, went to the city of Mexico, and, as a usual outcome of his moral obliquity, was apprehended for the commission of some crime. According to another statement, he was taken by Meyer to Detroit, where he died of consumption. Be these statements as they may, it is certain that from that time, the latter part of August 1891, to the present, Gustav Heinrich Joseph Marie Baum has never been seen or heard from. All trace of his whereabouts was lost, and the detectives long ago gave up further search. When Meyer announced Baum's arrest in the city of Mexico to Muller, he said, Now that he is out of the way, I am going to Germany to see his parents, and I am going to tell them that he committed murder in one of the western states. I have learned that someday he will be possessed of 1,000,000 marks. His family, I know from what Baum told me, are very wealthy, and I am going to work on their feelings and get some of their money. I will tell them I have influence to get him out of jail if they will pay 10,000 marks. On the 5th of the following month, September, Meyer and his wife sailed from New York to Rotterdam, and thence took train to Cologne. He found the family of Baum, told them that the son had been convicted of murder and attempted by various tricks and devices to get money from them. This part of the story was told on the witness stand by a man who sailed on the same vessel with Meyer, a man with whom he became intimate, whom he took into his confidence, and whom he asked to aid him in the criminal course that he was about to pursue, even to the corroboration of his statement to the Baum family that the son was in prison on the charge of murder. His conduct must have been insufferably offensive, according to letters from the agent of the Mutual Life of Cologne and Mr. Gustav Baum of that city. He was driven out of Cologne and was obliged to leave hastily and by stealth. He took the first steamer back to America, and when he reached New York, he was so impecunious that he pawned his watch in order to pay his car fare to Chicago. End of section 54. Section 55 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies. An authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Homicide, Part 32, Meyer, with Many Aliases, Part 2. About the end of December 1891, or the beginning of January 1892, the restless Meyer sought an interview with Muller and renewed his importunities to become a confederate in his scheme. He explained that before he went to Cologne, he had insured the life of his docile and subservient tool, Brandt, under the name of Baum, in 4 companies, for a total of $8,500. He admitted incidentally that in order to complete the first payments, he was obliged to borrow $70. The lender was his friend Gardner, with whom he afterward quarreled. He stated that his plan was to obtain a substitute from a hospital, someone who was nearing his end, palm him off as Baum, and after his death, Mrs. Meyer, personating the wife of Baum, and as such, the beneficiary, would claim the insurance. More than that, she would eventually claim a share in the Cologne estate. Subsequent interviews and discussions of the project took place at a beer saloon in Randolph Street, as testified by a witness named Egidio. Several stratagems, in turn, were suggested, but Muller was not convinced of their feasibility and declined to join in undertaking them. Finally, he was persuaded to agree to the plan of substituting a moribund hospital patient in another city, and New York was suggested as a favorable field of operation. During the preparation for the execution of this artifice, the conspirators, as the evidence showed, had rehearsals of the parts they were to play. Brandt was taught to feign excessive nausea, the poor fool being under the impression that that was his part of the play, and that when the time came for a corpse, it would be provided. Mrs. Meyer is said to have exhibited considerable ability in her portrayal of typical widowhood, and in exemplifying her acting when, as the widow of Baum, she would appear before the insurance companies in the somber habiliments of mourning. In concurrence with the general plan, Meyer escorted his wife and Ludwig Brandt to the house of a minister in Chicago, and they were then and there married, as already noted, Mrs. Meyer assuming the name of Emily Rather. Meyer signed the certificate as a witness of the bigamous marriage under a fictitious name. Immediately after this comedy, arrangements were made to assign the policies on Brandt's life to the pretended wife. Brandt and Muller were to precede Meyer and the woman on the way to New York, and to pave the way in that city for the denouement. By this time, Meyer seems to have felt sufficiently sure of his control of Muller to unburden his purpose plainly. In handing him the railway tickets and money for preliminary expenses in New York, and in giving instructions, he said, in reference to Brandt, "On the train, I want you to give him a certain preparation which I will hand you. I believe we might just as well do away with Brandt." There was no uncertain sound about this. The inveigler had done his work so well that Muller by this time was virtually a particeps criminis. Meyer wrote to a drugstore in Chicago and bought a package of tartarized antimony, tartar emetic, which he handed to Muller with instructions for its use. The latter asked what it was, and Meyer, in reply, gave the German name, Breckweinstein, and said that if given in small doses, repeated according to his directions, it would produce a condition so closely resembling that of diarrhea or dysentery as to deceive the physician who would be called in attendance. He also gave Muller a bottle containing sulfate of morphia. Brandt and Muller left for New York February 25th. They hired unfurnished rooms at 320 East 13th Street and bought some scanty furniture. Brandt, under the name of Baum, addressed letters to the insurance companies announcing his change of residence, in accordance with instructions before leaving Chicago. On the arrival of Meyer and his wife, March 4th, the woman saw at a glance that such forlorn lodgings did not comport with the presumable style of a gentleman who was paying for $8,500 of insurance. More furniture was therefore purchased. A piano was rented from Gordon Brothers, and something in the way of home comfort and ornamentation added. About the 7th or 8th of March, they were ready to begin the dosing process. The co-conspirators went to an apothecary's in the neighborhood of 7th Avenue and 42nd Street, and on a prescription from Meyer, signed Otto C. Stern, M.D., obtained some croton oil. Then followed the dismal story of torture, day by day, of the poor victim, and his sufferings from chronic antimonial poisoning. A young medical practitioner, Dr. Minden, of St. Mark's Place, was called in to prescribe for what was alleged by the messenger to be dysentery. The symptoms apparently corroborated the statement, and Minden prescribed opium and bismuth and appropriate diet, regarding it as a case of dysentery and not suspecting poisoning. The medicine was procured but was not given, while his food was impregnated with antimony. The fiend who administered it, being undisturbed by the terrible distress he was witnessing hour by hour. Brandt always believed that he would be brought back to good health by Dr. Meyer after the deception of Dr. Minden had been carried to sufficient degree. Toward the 25th of March, Meyer became impatient of delay and concluded to finish his murderous work. On that day, he went to Jersey City and procured some arsenic, informing Muller on his return of what he had done, and his purpose to substitute the arsenic and hurry up the job. On the night of the 30th, the wretched sufferer died. Dr. Minden was called in, and after examining the emaciated body, he gave the required certificate of death, in which the cause assigned was chronic dysentery. Curiously enough, Dr. Minden was somewhat of an expert in antimonial poisoning, as he had practiced among the lead workers of Colorado, but Dr. Meyer was skillful enough to deceive him. 2 days after Brandt's death, he was buried in Evergreen Cemetery. The pretended widow donned the sable garments of mourning, and after the funeral, notice was sent to the insurance companies. A representative of the Washington Life, Mr. Tierney, who was also a notary public, called to take the acknowledgments that were necessary, and while completing the papers, his sympathies were so strongly aroused by manifestations of grief, desolation, and despair on the part of the afflicted widow, that he soothed her with a promise to facilitate the collection of the money that was due to her. On the day appointed, the woman, heavily draped in solemn black, called at the office of the Washington Life in company with Muller, and after presenting evidence to justify the payment of the claim, a check for $3,000 was handed to her. Meyer was waiting outside, and in a few minutes the check was in his grasp. His wife endorsed it. They were identified at the bank by the complacent landlord of 320 East 13th Street, and the money was paid. On the next day, the same game was played at the office of the New York Life, with the same result. A check for $1,000 being paid to the claimant. On the following day, the conspirators called at the agency of the Aetna Life. But there, instead of realizing the result of 8 or 9 months' preparation, they struck a snag. The check had not been forwarded by the company from its Hartford office, as the company at first suspected all was not regular, owing to the occurrence of death so soon after insurance. But the check was forwarded soon afterward. They never called for that check. The next day they presented themselves at the office of the Mutual Life Insurance Company and were introduced to the hospitable attentions of Mr. D.G. Gillette, a born detective and unsurpassed cross-questioner. What followed is thus told in Mr. McIntyre's address. The defendant introduced the co-defendant, Mrs. Meyer, as the wife of Gustav Baum. He said he had come there to help her. Mr. Gillette looked at him and said, "Who are you? What relation do you bear to this woman?" Defendant said, "I am only a friend." "What is your name?" asked Gillette. He replied, "My name is William Richter." "Where do you live?" said Gillette. "I live in Cincinnati." "What street?" 458 Main Street, in that city." "Write it down," said Gillette, "upon a piece of paper." A piece of paper was handed to him, and he signed the name William Richter and the address as that of 458 Main Street, Cincinnati. Mr. Gillette then said to the woman, "Sign your name." She signed the name of Amelia Baum. "Where did you come from?" said Mr. Gillette, in the presence and hearing of this defendant. She said, "I came from Denver, Colorado. I only married my husband on the 11th day of February, and here I am a widow in that short time." "Well, tell me something about the people that you know in Denver, Colorado. Tell me the name of a single soul that you know there," said Gillette. She stammered and hesitated, and said that she couldn't remember. Gillette said, "Tell me the name of a single street in the city of Denver, Colorado." She couldn't tell the name of a single street. Gillette, looking at her and the defendant standing in close proximity to her, said, "Madam, you say you were married on February 11th, and this is the 6th or 7th of April. Why, madam, you are about to become a mother. You are in an advanced state of pregnancy. How do you account for that? Married but 2 or 3 months." The defendant said something to her in German, and she threw her 2 hands up and said, "My God, I don't want anything more here. Take me out of this place." Mr. Gillette stopped her and said, "Madam, we suspect that this whole thing is a fraud. We know it is a fraud." And turning to this defendant said to him, "This is a fraud and we know it. There has been a pretended death here, or there has been a murder committed. We sent to Chicago and we found Brandt's coat. In Brandt's coat were found bills belonging to the notorious Dr. Meyer of Chicago." Looking sharply at this man, he said, "Do you know Dr. Meyer of Chicago, who has been engaged in innumerable swindles against insurance companies, who has twice been tried for murder in that city?" At this, the defendant and his wife went out. They promised to call the next day. There was a check waiting for them in the agency of the Aetna Life Insurance Company. They never went to the Aetna Life Insurance Company to get that check for $1,000. Straightway, they made a contract with a small furniture dealer uptown to sell their furniture for $12, of which $4 was paid on that furniture and $8 was due on it. They never went to get the $8 that was due. There was a piano in that house, as I described to you, but they never went to Gordon Brothers to tell them to take the piano away. The piano was left there. They never went back to 320 East 13th Street in the city of New York. Meyer wrote to Mueller that the fraud was discovered, that the mutual life insurance company had got onto their scheme, and that he must skip out of the city of New York. Just before Mueller left the city, or rather just as soon as the policy was paid by the Washington Life, the defendant gave to Mueller the sum of $750 as his part of the bargain and told him to go to Chicago, and that he would see him later, that he would communicate with him. Mueller did go to Chicago. He went right out of town as soon as he got the $750. Meyer and his wife, instead of going back to the mutual life insurance company to collect the $3,500, or to the Aetna Life to collect the $1,000 due, took the first train to Chicago. While living in New York, it was his habit to wear a beard and to wear his hair long. Sometimes he wore a beaver hat, and sometimes a slouch hat, usually a long-tailed coat. When he reached Chicago, he immediately disguised himself, changing his appearance in every way. He altered his manner of dressing and shaved off his beard. He saw Mueller and explained to him once more that the insurance people had got wind of his scheme. He kept himself secreted. He never went to his home at 331 Center Street, but instructed Mueller to go there and sell his furniture. Mueller went there under the name of Klein to get the furniture, sold it, and took the money thus realized and gave it to the defendant. Apprehensive that if he stayed in Chicago he would be caught, he went to Detroit, Michigan. There he remained in concealment for a long period of time. Then he went to South Bend, Indiana, from there to Indianapolis, thence to Cincinnati, and subsequently went to Toledo, Ohio. In each of these places he was known by a different name. In Toledo he lived at 957 Dawes Street, and was known there as Hugo Whaler. All these migrations, these flights from one city to another, were because he apprehended danger and felt that the sleuth hounds were after him. 70 or 80 days after the burial of Brandt in Evergreen Cemetery, the coroner, at the instance of the Mutual Life Insurance Company of New York, directed the disinterment of the body. After the exhumation, the people who knew Brandt in life identified his remains. The physician who attended him, the undertaker that buried him, and others who knew Brandt in his lifetime, stood beside the emaciated corpse and recognized the features as those of Brandt. The body was taken from the coffin and laid upon a table. There were present the most scientific men that we have, the most thorough physiological chemists, the most accomplished physicians and pathologists. They were there on that occasion, and from that body they took the viscera, the lungs, the heart, the stomach, and the liver. They placed them in jars. They were taken to the laboratory and there analyzed. The evidence corroborates Mueller when he testified that antimony and arsenic were administered. The evidence shows conclusively that the body of Ludwig Brandt was saturated and impregnated with arsenic and antimony from head to foot. The chemical analysis shows that there was antimony and arsenic in the muscles, in the brain, in the intestines, and in the heart. Arsenic and antimony were found in separate, distinct, and weighable quantities. Mr. H.G. Julian, Special Representative of the Mutual Life Insurance Company, is the man to whom the credit of finding Meyer belongs. He tells the story in the following interesting manner. After the company discovered that Brandt had been murdered, I was ordered to locate Meyer, and was given carte blanche and instructions not to return to the Home Office in New York until I could bring Meyer back with me. It took a year for the expert chemist to determine the poisons that were given, because antimony is so rarely used as a poison with murderous intent that all other tests were experimented with before antimony was finally thought of. It was, therefore, 1 year after his disappearance that I started after Meyer and found him in the unexpectedly short time of 6 weeks. My first move was to go to Chicago to obtain full history of Meyer and his fellow conspirators and their victim, and to watch all the relatives of Meyer and Mrs. Meyer and all their former associates and haunts to discover some clue to their hiding place. A picture of Meyer was found in the rogues gallery of the Pinkerton Detective Agency and identified as the man who came into the New York office of Mutual Life. The mails were watched, and every dodge known to detectives was tried to entrap Meyer, but his long experience in crime made him familiar with the ways of detectives, and he did not communicate with any of his old cronies and did not allow his wife to communicate with her relatives. I was about to follow false clues to Germany when I heard of poisoning operations in Toledo, Ohio, similar to those in the New York case, and when I showed Meyer's photograph there, it was fully identified. He had insured his wife's nurse girl, Mary Nice, in the equitable life of $5,000, representing her as his wife, and then commenced to poison her slowly. Carl Kerfel, alias Muller, Meyer's accomplice in the New York crime, visited Meyer, fell in love with the girl, noticed she was sickly, learned she was insured, told her Meyer was probably poisoning her, and eloped with her. Meyer got another girl, Indiana Maggie, from Indianapolis in the place of the first and killed her. The Equitable Life discovered that the dead woman was not the one insured and declined to pay, whereupon Meyer skipped out again. To the police who were hunting Meyer for this last crime, it did not occur that the unknown man who eloped with Mary Nice might be an old crony of Meyer. I found that his description fitted the Carl Muller of New York, and I then located him by tracing Mary Nice through her relatives. I then had him watched and surrounded by Pinkerton detectives, and I set up a law office in Chicago, and as a lawyer, I was introduced to Muller, and he finally told me of the Toledo crime, but not a word of the New York crime, in which he was particeps criminis. Muller undoubtedly did not know Meyer's whereabouts at this time, but one day he received a letter from him at one of their old resorts, while in the company of a disguised Pinkerton detective. The latter reported Muller's agitation and the significant word or two that slipped from him. I then revealed myself partly and put the screws hard on Muller, and forced him to tell me all he knew, and to assist me by keeping up the correspondence with Meyer under my direction. Muller could not tell from Meyer's letters where Meyer was, because the letter was careful to have them come indirectly, and through other hands, and not even written or signed by him. Muller helped me, under threat of punishment for other crimes, believing I only wanted Meyer for the Toledo crime, and also because Meyer tried to poison his mistress, and did not divide the New York spoils fairly. Had Muller suspected that I was from New York, he would have told me nothing, being an accomplice of Meyer there, but would have avoided me. After long maneuvering, I finally traced Meyer to Detroit, the last place in the world that a man in his situation would think of resorting to, because Mary Nice, in whose stead he killed the Indianapolis girl in Toledo, was insured through his instrumentality in the Equitable Life office in Detroit. While his house was being watched by my Pinkerton assistants, I entered to look at rooms that were to rent, as advertised on a card in the window, and as soon as I saw him, I knew he was my man. I found there evidence that he and his wife were preparing another murder. As soon as Muller learned that Meyer was arrested for the New York crime, he realized that he had been fooled, and he skipped. But I had Pinkerton shadows on him, and when ready, I took him from his hiding place to New York and made him and his wife witnesses against Meyer. Meyer was arrested July 12th. A requisition upon the governor of Michigan was promptly honored, and the manifold criminal was taken to New York by detective officers. The compromise verdict, which followed the second trial, as noted in this narrative, attracted comment which was anything but complimentary to the jury. It could only be regarded as 1 degree better than a disagreement. Recorder Smith, before whom the case was tried, declared that the crime was one of the most atrocious that ever came to his knowledge, and that the verdict was clearly illogical, as the evidence warranted a verdict of murder in the first degree. End of section 55. Section 56 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies. An authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Homicide, Part 33, The Hendricks Case. In June 1877, one Henry C. Hendricks was convicted at Angelica, New York, of murder in the second degree, and by the court sentenced to imprisonment for the term of his natural life. The prisoner was indicted in the fall of 1876 for the murder of his wife, and at a previous trial escaped conviction through a disagreement of the jury. Conflicting medical testimony, aided perhaps by a friendly personal feeling, led to this result, and also induced the absurd verdict rendered by the jury on the second trial. Hendricks was a young man of fine personal presence, about 32 years of age, a farmer, and was living at the time of the tragedy on the farm of ex-Attorney General Champlain in Cuba, New York. His family relations, so far as known, seemed to have been pleasant, and his previous character without reproach. He had served in the Army during the late Civil War, and upon his discharge from service in 1865, had married and engaged in farming, working the estates of others upon what is commonly known as the share plan. He claims to have been awakened early in the morning of the 7th of July, 1876, by a noise in his sleeping chamber, and as he was in the act of springing from the bed across the body of his wife, a shot was fired which lodged in her abdomen. Going towards the door for the purpose of intercepting a supposed burglar, a second shot wounded him in the fingers and thigh. His wife had been able to rise from the bed and follow him without being aware of her own wound, until his exclamation, "I am shot," elicited from her. "So am I," assisting her into another chamber, and laying her upon the bed, he, for the first time, inquired where she was wounded, and upon being told, "in the bowels," examined her person, and found such to be the fact. It would seem that this discovery should have convinced him of the serious character of her injury, and moved him to immediate action for medical assistance and relief. But no, he claims to have been withheld by her entreaties and fears for his own safety. It states that, in their conversation, she expressed doubts of surviving the wound, and talked of plans for his future and for their only child, a boy of 9 years. That she made some requests as to the disposition of personal remembrances to members of her own family, and at the last that she advised him, after a reasonable length of time, to marry his cousin Mattie. Nearly 2 hours thus passed, and it was daybreak before an attempt was made to raise an alarm or procure the sorely needed assistance. Then, from the steps of the house, he fired his revolver in the air and shouted for help in the intervals of firing. Soon afterwards he sent his little boy, not to his nearest neighbor, but to the house where Mattie was temporarily lodged. She quickly responded to the summons and remained thereafter at Hendricks's house. Mrs. Hendricks lingered for 6 days, dying on the 13th of July. The day after her death, a post-mortem examination developed the course of the ball, from its entrance near the umbilicus, passing inward, upward, and obliquely to the right, and effecting a lodgment in the right kidney, where it was found. The intestines were not injured, but the peritoneum was cut just the size of the bullet. The weight of the medical testimony conclusively established the fact that the wound must have been received while Mrs. Hendricks lay upon her back, and it does not appear in evidence that any of the bedclothes or nightdress of the wife were perforated by the bullet. It will be remembered that Hendricks states that in rising he sprang across the body of his wife, having during the night changed his position from the front to the back side of the bed. An inspection of Hendricks's wounds disclosed a slight scratch upon the left thumb near the inner corner of the nail, and a corresponding wound upon the left index finger. The wound upon his left thigh was upon the outer side, about 12 inches above the knee, and had the appearance of having been made by a small bullet which had passed through and just beneath the skin at a point about 1 inch from the place of entry. All bore the appearance of having been made by point-blank shots, the distance of the weapon not exceeding, apparently, 3 inches. It was the theory of the prosecution that these wounds were self-inflicted, based upon the fact that the wound upon the thigh was in an oblique direction, presenting the appearance of having passed from the inside outward, that the subsequent discharge of matter, therefore, contained dirty, darkish brown particles, which were without doubt grains of gunpowder, and that the flesh near the wound, upon the inner side of the thigh, also appeared as if burned. An offer was made to fix the relative position of a hole in his shirt, made, as he claimed, by the shot which wounded him, with the marks upon the thigh. But in all positions, it was apparent that his claim was untrue. Little doubt existed in the minds of the surgeons and attendants of the guilt of Hendricks, or that his wounds were inflicted by any other than himself, for the purpose of diverting suspicion from himself and avoiding legal inquiry. His efforts to this end were for a time successful. 3 months elapsed before his arrest and subsequent indictment, and it cannot be questioned that such action was at last taken as a result of the inquiry and investigation instituted, and in a measure conducted in the interest of an insurance corporation. In May preceding the shooting, Hendricks had obtained from the agent of the Travelers Insurance Company an accident policy upon himself. The insurance company was informed, soon after his arrest, that he proposed, if acquitted, to present a claim of indemnity for 4 weeks' disability. The life of his wife was insured by the Mutual Life Insurance Company of New York for the benefit of her legal representatives in the sum of $2,000. Subsequently, he endeavored repeatedly to secure its assignment to himself, but without avail. His efforts to this end continued even after the shooting, and may have been one of the subjects of conversation during the hours of suffering which Mrs. Hendricks endured before he sought assistance. Her father testifies, "I had conversation with the prisoner about his wife's insurance. I told him the policies were not equal, that hers was worth $2,000 to him, while his was only worth anything to her in case of contingencies, that I did not care for the money, and would speak to one of the ladies and have them speak to Cynthia, Mrs. Hendricks, about it. I did so. This was in the forepart of the day. In the afternoon, the matter was again spoken of." Another witness testifies, "Hendricks talked with me about 11 o'clock the morning of the shooting about the insurance. Mrs. Hendricks's father wanted me to speak to her about it, Then he went out and Hendricks said, "We have talked it all over and it is understood." And he wanted me to speak to her. I went to her and said, "We would like to know how you want the insurance, whether to you or to Henry." She said, "To Henry, for his is drawn to me, and it is no more than right that mine should go to him." This evident anxiety to realize to himself the pecuniary benefit which would result from the death of his wife does not seem to have roused at the time any suspicion in the minds of those present, all of whom were relatives of friends of his wife. Without specific designation, her son was the legal representative, and the father, in the ordinary course, would have been the legal as he was the natural guardian of their child, and as such would have controlled the proceeds of the policy. He was not content to administer the trust for another, although in the situation it would seem that parental affection would dictate such course. But he sought to acquire the absolute ownership of the benefits to be derived from the policy. The realization of the insurance fund was not, however, the only apparent motive actuating the commission of the crime. Some 2 years previous, a young lady cousin of Hendricks had become a frequent visitor. She is described as a person of rather more than average height, of a slight, delicate build, with brown hair, large and expressive black eyes, a very intelligent look, and an attractive person. Frequent rides in each other's company, visits to mutual relatives, with occasional trips to neighboring villages, and on one occasion, her installation into the charge of his house during a short absence of his wife, characterized their earlier intimacy. It is apparent that such relations soon developed into others of a more intimate and questionable nature than was warranted by the kinship which existed between them. In May preceding she had, at his request, taken up her residence with him, but, objection being made by his wife, the arrangement was terminated 2 days previous to the shooting. While no act of open criminal intimacy could be directly and positively charged as having been committed, yet so strongly did appearances indicate such relations that even before the death of Mrs. Hendricks, her sisters did not hesitate in asserting their existence, and the conduct of the two during the week Mrs. Hendricks lingered after being wounded was such as to favor such belief. None other dressed his wounds, the location of which necessarily involved an exposure of his person, and although she had a way of making the dressing stay on better than he could, yet the operation was required to be repeated several times during the day. Little attention or service was rendered by either of them to his dying wife, but, withdrawing from her and the friends surrounding her, they passed their time in each other's society, until, upon the day of her death, indignant remonstrances by relatives forced an outward observance of propriety. Cousin Mattie continued with Hendricks after the burial of his wife, and their relations, according to the testimony at the trial, were even more intimate than before. In his desire to possess for himself marital rights over her, the days passed too slowly, for we find that in October, but 3 months after the burial of his wife, he sought an interview with his father-in-law, and stated to him the request of his late wife that he should marry his cousin Mattie, and desired advice. No objection was made, the reply of the father being, "If that was her request, I have nothing to say." Hendricks evidently was of the opinion that the reasonable time had elapsed, or that his wound still required the attention which, it appears, she alone could give. His hopes were not, however, to be realized. Arrest, presentment, indictment, and trial succeeded, with the final result as stated in our opening. That the verdict rendered was wholly at variance with the testimony and evidence cannot be denied. The array of evidence, circumstantial as it may have been, fully proved the crime intentional and its perpetration premeditated, if it proved anything. None other than the prisoner could have any motive for its commission or profit by its perpetration. His circumstances were not such as to expose him to a visitation from burglars seeking to obtain either money or valuables, and a tenant farmer does not generally possess such property as invites the attention of those gentry. To us it seems that the case, as presented, did not admit of other findings than guilty or not guilty, as charged in the indictment. The time and manner in which the crime was committed, apart from any other circumstances or consideration, were conclusive as to its premeditation. No sudden fit of temper or angry quarrel led to its commission. It was deliberately planned and as deliberately executed. His neglect to raise the alarm or seek required assistance, his inattention to his wife and subsequent conduct all served to stamp his act as intentional, premeditated murder. The verdict as rendered was a mockery in the administration of justice and a scandal and reproach upon the jury who, by their solemn oaths, were sworn to well and truly try and true deliverance make, without respect of person or favor of any man, according to the law and the evidence before them. End of section 56. Section 57 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies. An authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Homicide, Part 34, The Professor West Infamy. In Dover, the capital of Delaware, a certain Professor, Isaac C. West, Jr., was pretending to experiment with the mysterious gas, one peculiar property of which was that it would cause the removal of the color from the skin. He took care to spread abroad a report that the gas was highly inflammable and explosive, and that in conducting his experiments he was obliged to exercise great care to prevent dangerous results. One day in December 1872, there was a loud explosion in the professor's laboratory, followed by an alarm of fire. Successful efforts were made for extinguishing the fire, after which some of the citizens who entered the building encountered a ghastly sight. In a charred dry goods box lay the mutilated remains of a man's body without head, hands, or feet. By the charitably inclined, it was at first supposed that the professor had been killed and blown to fragments by an explosion of a retort of the destructive gas. Closer examination revealed evidences that the missing head, hands, and feet had been cut and not blown from the body. Underneath the floor, where the body lay, was discovered a quantity of gunpowder sufficient to have blown the body to atoms if the flames had reached it. These facts, conjoined with other circumstances, and noticeably the disappearance of a well-known colored man named Henry Turner, who had frequently assisted West in his work, eventually aroused grave suspicions of foul play. These suspicions were strengthened when it was discovered that West's life had been insured to the amount of $25,000, his neighbors immediately concluding that he had killed Turner and mutilated the body beyond recognition, as he thought, in the hope that the insurance companies would pay his supposed widow the amounts for which he was insured. It was then determined to watch his communications with his wife and to note carefully her movements, their object evidently being to effect a settlement with the companies, and then to retire to some distant locality to enjoy their ill-gotten wealth. After a singularly fruitless attempt at flight, West surprised everybody by unexpectedly returning to Dover and voluntarily delivering himself to the sheriff. He confessed that he had killed Turner, but urged that it was in self-defense. And he also revealed the whereabouts of the head, hands, and feet, which he had secretly buried. After a brief search, the various portions of the dead body, including the integument of which it had been denuded, were found. A coroner's jury was impaneled at once, before which the prisoner appeared. The Attorney General said to West that it was useless to state the nature of the charge that had been brought against him, and if he had any statement to make of his own free will, the jury would be glad to hear it. West thereupon, after a great deal of effort to control his almost overpowering emotion, proceeded to make a detailed confession of his bloody work as follows. My name is Isaac C. West, Jr. My age is 30 years. I was born in Sussex County, but had lived in Dover and vicinity for 3 years. I don't claim to be a physician. My business is to administer gas for the treatment of disease. The killing took place on Monday night, December 2nd. On Monday morning, I was taking a bucket of water to my office, but don't remember the exact time. Turner came along about this time and said, "Boss, I'll carry that up for you." I told him I would carry it myself, but had some work for him, if he would do it. He said he would, and wanted to know what it was. I told him I had a large box at Captain Battle's. He said he couldn't carry it then, that he was cutting up meat for Mrs. Mullen, but that he would attend to it some time in the afternoon. I went to Mrs. Mullen's about 1 o'clock on the same day. Some colored men there said that Turner was not there, and had not been there, and they didn't know where he was. About 3 o'clock in the afternoon, I met him on the street, and he said he was ready then to carry the box for me. He got a wheelbarrow of Mr. Collinson and took the box up to my room for me. I took out my pocketbook in my office in Kerbin's building and paid him 25 cents. He then said, "Boss, you seem to be pretty flush." Then he wanted to know if I wouldn't give him money to get a drink. I told him I would if he would go down to the bar next door. He then said that after supper he would come back to bring water to fill my gasometer, and would not charge me anything for that, as I was so good to him. We went down together and into the barroom below, and I paid for Turner's drink at Levy's bar. This was when the sun was about half an hour high. We came out together and separated as we came out of the door. Turner said, "Boss, I'll be on hand in half an hour." I met him again between that time and sunset, near the post office. He said he was ready to take the water up, but I told him I was not ready then to go up to my room. A short time after that I met Turner near Hoffaker and Stewart's store on the corner, talking to a colored man. I passed him and went on up to my office. I had just got there and unlocked the door when he came up. I went on upstairs ahead of him and unlocked the room door upstairs and went in ahead. I had taken my gasometer to pieces that day, intending to fasten a small sledgehammer to the weights. The sledgehammer was lying just inside of the door. The other weights were over in the corner, about 8 feet farther on. One of the weights was a bolt or a piece of an iron axle. It was about 2 feet long and 1.25 inches in diameter. I had just gone over to where this bolt was lying when I turned and saw Turner with the sledgehammer in his hand in a threatening attitude. When he found that I saw he was coming, he said, "Give me your pocketbook or I'll kill you." I then snatched up a bolt or a piece of axle, and just as I did so, he struck at me with the sledgehammer, the blow falling on my hat and denting the crown. But it did not touch my head, as I was stooping over. I then struck at him with the bolt or axle, intending to strike him on the head. But I missed his head and struck him on the neck below the ear. He fell, and I don't think he ever kicked afterwards. This was just after sunset. He fell over on his side. I then felt him and examined his pulse and found he was dead. I did not intend to kill him, but only intended to knock him down, so that he could not kill me. After a long pause, the prisoner continued. I then left the body lying there and came up to Fountain's Hotel and got my supper, and didn't go back any more that evening. But I went back Tuesday morning, about 10 or 11 o'clock. I then thought I would cut Turner in pieces and bury him. So I cut off his head, hands, and feet with my penknife. Knife here shown had 4 blades, and was identified by the prisoner as the one with which he did the cutting. I cut off his head and feet with the penknife, and skinned the body. That is the knife, pointing to it, which lies on the table. I broke one of the blades cutting the bones. I broke several of the bones with a piece of axle. This was not all done before dinner. I don't know how much I did do before dinner. I went to dinner that day, but do not know the exact time. Do not remember positively whether I was back at my office after dinner or not. In the afternoon I got a horse and carriage of Mr. Fountain and went out to Hazlettville, my home, and came back in the evening thinking to take the remains away and bury them. I got back about 6 o'clock that evening and brought down the skin of Turner from my office in a water bucket, which was about half covered with a piece of paper. The horse smelled it and would not let me take it, so I set it down just inside of the outer door and locked the door. I then brought the horse and carriage to the stable and went up to the hotel and warmed myself. I then thought I would carry the remains in a bucket and bury them. I went back to my office about 8 o'clock and took the bucket which had the skin in it and started out on the street with it. I found the ground was frozen and that I had nothing to dig a hole with, so I turned and brought it back to my room again. I remained in my room planning what to do, and then concluded I would tear a large box I had to pieces and make a box that would hold the remains, for the purpose of shipping them on the Delaware Railroad to some point, and then follow and bury them. I found it was getting late, and I could not stay any later that night. About 11 o'clock I returned to the hotel and went to bed. This was Tuesday. My foot was hurting me on Wednesday, and I didn't go back to my room till about 9 o'clock in the morning. I found the remains smelling so much that I could not ship them on the railroad. I got my dinner at the hotel that day and was about at different places that afternoon. I returned to my office in the afternoon, when I took my knife and cut off the nose and lips from the head, intending to skin it, and also cut some pieces from the abdomen. I then struck the head with the bolt or iron axle for the purpose of smashing it up so it could not be recognized, but found I could make no impression on it. I was afraid if I skinned the head it would still retain its shape and would be recognized. Afterwards I put the head in a bucket and took it down to a lime heap near the railroad and rolled it in the lime, and then raked it back in the bucket and carried it to a place where I buried it, using a spade belonging to Mrs. Jones for this purpose. I buried the head under a heap of cut briars in the street near the corner of Water Street and the railroad. I then went back to my room about 10 o'clock. I had a candle and 2 lamps at my office, one for burning alcohol and the other for burning kerosene. I took the bucket and put the skin in it to carry it away. Went out on the street with it and saw some person coming, when I took it back to my room again. I melted the end of a candle that I might stick the candle on the floor. I took one of the feet and poured some alcohol over it, thinking that by setting it on fire it would change the color of the foot. I set it on fire and spilt some over on the floor, which also ignited. I had previously placed the box over the body and put the small pieces on top of the box. I intended, if the alcohol did change the color of the skin on the feet, to spread the skin out on the floor and change the color of it by burning alcohol on it. But I found that the alcohol would not change the color of the skin. I intended, if the color was changed, to replace the skin on the body and fit it as well as I could. When the alcohol on the floor caught fire, I gathered up the feet, hands, and skin in my hands and got out of the room as soon as I could, fearing the powder I had there would explode. I made an effort to extinguish the flames, but failed. After getting outside, I walked to the Methodist graveyard with the feet, hands, and skin. After I had gone some distance from the office, I saw that the fire had gone out, and I started to go back, but I was afraid to go, remembering that the candle was on the floor. When near Mrs. Jones's new house, I noticed the fire flash up again, and I turned and went back towards the graveyard, where I had left the feet, hands, and skin. I then took them up and carried them over into the Methodist graveyard, and there waited until the fire was put out. I buried the skin alongside of the railroad, and then went to get the hands and feet to bury them, when I heard the whistle of the 4 o'clock down train. I raked some lime over them and ran up to the depot and waited until the train arrived, when I went on board with a bundle of my clothes and went to Delmar, from which place I walked to Salisbury, Maryland, on the railroad track. I went to Tracy's hotel in that place and remained there until this Friday morning, December 6th, when I got on the northbound train and came up to Farmington, where I got off and walked to Harrington. I got on the evening train and came to Dover and gave myself up to the sheriff. I had previously called on a constable at Harrington to deliver myself up. My life is insured for $25,000. $10,000 in the New England Mutual, $5,000 in the John Hancock, $5,000 in the Delaware Mutual, and $5,000 in the Aetna. About half in favor of my wife, and half in favor of myself. They were all life policies. I took out the Aetna policy 5 or 6 years ago, and the others last spring. I never had any previous difficulty with Turner. Knew him only by the name of Joe Turner. Never exchanged half a dozen words with him before that time. I bored the hole found in the office floor about a month ago with a brace and bit. It was intended to set a post in for my retort. The powder, about 1/4 pound, was put into the hole on the 30th of November. I used it as a medicinal preparation. The bundle of clothes I took on the cars with me consisted of circular coat, pair of boots, and 3 shirts. I bundled them in my room on Wednesday night and put them back of Holland's store and left them in the graveyard until I heard the whistle of the train, when I returned and got them and took them to the depot platform. The same bundle of clothes, with the addition of a pair of pants, is at the Dover depot in a bag I bought at Salisbury. I tore Turner's clothes into strips that they might not be recognized. They consisted of coat, pants, and shirt. I cut the tops of Turner's shoes off and threw the soles into the street, and left the uppers with the torn-off clothes, intending to carry all off and bury them. The front shutters of my office were closed when I left the last time. To this confession, which is verbatim, West appended his name and was then remanded to jail. How anyone with a grain of common sense could expect the public to accept the ridiculous statements and explanations in his so-called confession is incomprehensible. Its only effect among intelligent people was to arouse their bitter scorn and their inexpressible disgust. The principal points developed by the testimony for the state were briefly that the annual premium of $25,000 of insurance at the age of 29 years was not less than $600. That West was always impecunious, so much so at the time of the murder that he owed for 2 weeks' board at his hotel and was unable to pay it. That he had repeatedly visited one Frederick Windolph, a friend and member of a society lodge to which he belonged, before the commission of the crime, selecting him from among his acquaintances because Windolph's height, weight, and chest measurement corresponded nearly with his own. That he was continually maneuvering to establish himself in Windolph's confidence, and that, upon one pretense or another, he made several attempts to inveigle him into his laboratory. His diabolical design upon Windolph being clearly revealed by the murder of Turner, the testimony of Windolf was abundantly corroborated by other witnesses, who recalled incidents which at the time seemed strange, but which awoke no suspicion of ulterior purpose. It was also in evidence that West said he wanted to make money enough in the next 2 weeks to make or break him. Another witness said that he saw Turner in company with West in the afternoon of the day of the fire. Turner was under the influence of liquor when West treated him to brandy and asked him how much he could drink. Turner took a glass full. They left the barroom together, and witness was surprised that West should treat a Negro in that liberal way. Witness saw very little money in West's pocketbook. On behalf of the defense, testimony was introduced showing that the prisoner was insane, that his father was subject to fits of melancholy 2 or 3 years before the birth of his son, Isaac C. West, Jr. But it became evident that the defense chiefly relied upon popular prejudice against color and popular feeling against hanging a white man for the pardonable offense of killing a Negro. Entrusting to this sentiment a relic or legacy of the old slavery regime, the defense was not mistaken. The state introduced several medical witnesses to rebut the insane Dodge, and the case was given to the jury, who returned a verdict of not guilty on the ground of self-defense. The leading daily journal of the state of Delaware, commenting upon this preposterous verdict, says, "All that has ever been said about the stupidity of jurors and the uncertainty of jury trials is illustrated and enforced by the verdict in the West case. We would not have been surprised at an acquittal on the ground of insanity, since we have read the strong array of evidence in support of that theory. But for a jury to disregard this, practically declare its disbelief in it, and then to acquit this man on the ground of self-defense is a performance which we can find no words to characterize, excuses to palliate, or reasons to explain. The prisoner in his own laboratory killed Turner, then skinned him and cut him up, and finally set fire to the building with a view to destroying the disgusting evidences of his crime, and then ran away in disguise, and being caught, confessed his crime, but said he killed the man in self-defense. And upon his simple say-so, a jury, sworn to deliver a true verdict in the case, acquits him on the ground of self-defense. Such a verdict is not only simply preposterous, it is monstrous. It is some satisfaction to know that this inhuman villain did not escape scot-free. Upon being tried for the crime of arson, he pleaded guilty and was sentenced to 2 years' imprisonment in the penitentiary. His second confession is a virtual admission of his murder of the poor Negro. Unfortunately, a criminal cannot twice be put in jeopardy for the same offense. End of section 57.